Hey guys, good evening. Hello, everybody. So, yes, I did not get a chance to watch all this crap before it happened. I got partway through Thursday, things kind of happened. I wasn't able to watch all of it. And then today, well, I was busy, had things going on, and I know it just wrapped up. And I know today things like fucking bombshells dropped. So, let's buckle up, guys. We are going to start from the beginning, though. And yeah, today was insane from what I've heard. You can't wait to see this reaction. Well, yeah, here we go. Well, but I haven't seen all of it, so we're gonna get her done. So here we go. Gonna eat some fucking lunch today is what we're doing, and we're not. Well, we'll get through it all at once, but we're gonna try. Sure as hell, we're gonna try. All right, I'm gonna try the at 11 Alive Atlanta. I know they have commercials on, but I don't know who else to watch the trial from. Did Law and Crime cover? Do you guys just want to use them instead? Would that be better? If you guys have an idea, I'm gonna have a great time. Good, I hope so. But yeah, I guess I'll use a props on Maddie today. Oh, well, I need to reach out to Null because I want to talk to him, see if he wants to come on and talk about what's going on. So, did I rape a woman? Define rape. And then you have to define woman. And we got a super chat already. Fair Frozen 55 for $2 saying bought a Glock 19X and a 22 Charger today. Hi, Sean. Good selections. Good selections. Good selections. Nothing wrong with those choices. Is she gonna be funnier as a rerun? Well, we'll see. We'll see. Did I rape 3 women? I assert privilege. I mean, you could assert a privilege to rape 3 women? I want that privilege. So, all right, guys. You know what? We're just gonna get started. It's gonna take forever and a day. I don't know if you guys heard me. I know you guys probably watched multiple streams. Was Long Crime? What was the best stream feed to watch off of? Do you guys know? And then also tomorrow we will catch back up Michelle Traconis. Apparently that was getting very good. Finally, things were starting to come up together. Catnam Day said Doliger Jobless starting on Monday. Congratulations. Good stuff. Okay, so you guys aren't answering my question. I'll just have to figure it out. I'll just figure it out. What is the best one here? Break it on. All right, we'll do 11 Alive Atlanta because I don't know what else to do. Hot Atlanta and Hotlanta, the hottest of the Atlantas. All right, here we go. You were watching the Zoom. I don't know which the Zoom link is though. Joe had the NBC stream. That was perfect. Okay. Just finished watching the morning of the trial with a tunnel digger. Use Joe's stream. I have a little self-respect. I'm just kidding. I love Joe. But I wouldn't do that to him. He worked hard to run that stream. I wouldn't just piggyback off of him. And we have standards here. X saying Rob Gavea's mods are. You know what though? Rob Gavea. I got nothing but love for Rob. Rob's a great guy. He's a super smart fucking dude. I totally respect his style, how he puts it on. You know, I've done my looking into him. He's a good fucking attorney. So, however he runs his shop, man, that's how he runs his shop. That's all I can say. He runs a shop the way he runs a shop, and he does damn good at it. So, Joe had 92,000 views. Woo! Woo! Damn, Joe, Joe. You know, hope you are partying in the tunnels tonight, man. Damn, that's good. All right, guys. So here we go. Joe had 4K at one. He had 92. He didn't have 92,000 views. Oh, okay. He had 4,000 views at once. Okay, well. Zoom, you chased the day away. Oh. So I don't know if I want to. Like, I saw some of the Zoom stuff. It kind of looked kind of crappy. So, Hashu, say happy Friday. Yeah, happy Friday to you too. All right, here we go. Let's do this.
DA Willis and
okay, well, I don't need. Look at that guy. He's like me, but older and with more black hair. Judge McAfee. Oh. Does he have like an Uncle John? That'd be my concern. He gets up on the stand, gets up on the bench. He's like, I want to send this one out here and dedicate this next hearing to my Uncle John. My best uncle ever.
Georgia with my dog.
Okay. All right, here we go. All right, here we go.
I don't think that necessarily opens the.
Okay.
knowledge about Fulton.
Leah's still.
Okay. So, guys, if you didn't know, the attorney leading the Trump team and all this is Ashley Merchant. She represents Roman. She is a fucking assassin. As much as I think Law Twitter's cringe, when those douchebags out there say, oh my God, she is dangerous, that tells you a lot. This woman is a force to be reckoned with. So here we go.
Leah's still not with us in person. However, there's a proposal to potentially move on to other witnesses. Why don't we start with the state? Ms. Cross.
Thank you, Your Honor. Yes, in order to be efficient with the court's time, we have a witness here and prepared to take out of order, and it sounds as though there's no objection from the defense, so we can do that at the court's convenience.
We don't have any problem taking him out of order, but it's our understanding Discovery Farms at least here to establish that he was the first choice of Ms. Willis, and she testified to that, so I don't.
Yeah, going out of order if you don't have to, if it's not critical people, not a big deal. It's how things go sometimes. President-elect Phil Swift, first to come. I apologize for not seeing that earlier, but yes, first to come. Fair Frozen 55 says the Glock 19's in Flat Dark Earth is the Earth, and the Charger is in cheetah print. Ooh. Hopefully matches your thong. I know you guys rolled down in Puerto Rico. President-elect Phil Swift says for $2, I'm finally first and you don't read it. I'm suing. And better hire Schneider while you're at it. See if he'll give you a discount rate for Monty. And then let's go Brandon for $4.99 says you're going to lose your mind over this. Fair warning. I know a little bit, but yeah. Here we go. Here we go, chat. No more games for real.
Why we can't call him to establish that. We're not refuting that fact. Keep her on that fact.
Ms. Cross, I think did she say it was her first choice? Did she not say who was her first choice?
I think
Oh, these guys
that,
talk
I
way
don't
too
believe that,
fast.
The governor's name was mentioned. I think there are some facts and circumstances surrounding the search for someone to take over the lead of this investigation at that time. Now prosecution is something that, given the allegations in the case, is certainly relevant.
All right, and it doesn't sound like it would be all that long a witness.
I don't.
Anyhow, all right, so in that case, we can transition over, and Ms. Cross, would you like to call your witness?
Thank you. The state would call Governor Roy Barnes.
And Judge, just so I'm clear, so you had told us not to ask questions about qualifications. We did not ask any of our witnesses about qualifications. So the state's now going to bring in evidence of that. We would just ask. I'll be able to go into that.
Sounds to me, well, Ms. Cross.
If you want to ask Governor Barnes about his qualifications, that's something you have knowledge of. I don't know what his basis of knowledge for anyone else's qualifications might be, but I also don't think that opens the door to anything other than what my understanding of what the testimony is.
As I hear it, the issue of qualifications versus who was her first choice is going to be relevant to her intent, maybe, and perhaps that issue of the case in whole. I don't think that necessarily opens the door. We'll see how it goes.
I believe he's being brought up, Your Honor.
All right.
Okay, so this is the first choice she initially had for her independent counsel type thing.
Ms. Cross, assuming this may be a 10 to 15-minute witness, does the state have other witnesses on deck that they'd like to go forward with as well?
Yes, we called to gather everyone we could, so we can go forward with another witness, I believe, after this one.
All right, appreciate it.
He's wearing a fucking. He brought his fedora hat. Wow. I used to be governor. We could hang your cons.
I do.
I was the governor when
Roy
Sherman came
Eugene
through.
Barnes. ROYEUGENE. Barnes, BARNES.
Say, good morning, Mr.
Morning.
Barnes. Can you tell the court a little bit about your background as it relates to your service in public service?
I was first elected to the state senate in 1974 from Cobb County, and I served 16 years there. And then in 1990, I ran for governor and was defeated. And 2 years later, I went back to the House of Representatives. I was elected to the House of Representatives, served 6 years until I was elected governor in 1998, and I served in that position until January of 2003.
And after serving in the position of governor, can you tell the court a little bit about what you transitioned into after your public service?
I did exactly what I was doing before I was elected. I went back to practicing law in Marietta, Georgia, with my daughter, who's now judge of the state court, and my son-in-law. And now we have, I think, 6 or 7 lawyers. Charlie Bailey back there was one of them at one time.
Okay. And Governor Barnes, would you consider yourself to be a trial lawyer?
Yes. That's
Okay.
We don't write contracts or we don't write wills. All we do is try cases.
And I want to direct your attention.
I like that.
back
We don't.
to,
We just try cases at my firm.
2021,
That's
where
badass.
you were approached by the district attorney of Fulton County, Fani Willis, about being a special prosecutor.
I was. I don't recall the exact date, but I know it was sometime in 2021. And she asked me to come down, and I met with her and Nathan Wade, and there were several other in the meeting. She asked me, said they were beginning this investigation, and she asked me if I'd be interested in being special prosecutor, to which I replied that I had mouths to feed at a law office, and that I would not do that. And also, I just had a bad, well, I won't say bad because it happens from time to time, but I just had the FBI to report a fella, a militia trainer, to me that said they were concerned that he was making threats against me.
Oh,
And
pussy.
because I thought it was because of the flag, but I asked him and he said, no, it was because I was too close to the Jews, quote unquote. And
Well, are you?
I told DA Willis I'd lived with bodyguards for 4 years, and I didn't like it. And I wasn't going to live with bodyguards for the rest of my life.
Ultimately, you turned down.
Yes. Yeah, I told her. I said, I'm not interested.
Nothing further from the state.
First,
So I couldn't find
morning,
the
Governor
guys.
Barnes. How are
I
you?
just had to
just
hire
fine. How are
a
you?
Good
scumbag
to
like
see
my
you.
boyfriend. That's the answer.
You said it was sometime
the
in
argument?
2021. Do you remember
I think
if it
it
was early?
was. I don't remember the dates. They all go. I could look it up on my calendar at the office, but I don't have that.
Well, I want to ask you about some statements that Ms. Willis made March 28th, 2021. She was talking about assembling a team for this case. Are you familiar with her work assembling a team for this case?
Well, I assume that's what she was talking to me about. But besides that, I don't know.
And I know you had said you had a meeting with some folks and Mr. Wade was at that meeting.
Correct.
Okay. So he was with the district attorney interviewing you about taking this case.
Well, of course, I know Nathan very well, as you do.
Yes.
And I exchanged pleasantries with him, but the conversation was with Ms. Willis.
Okay, with Ms. Willis. Were you aware at the time that her team consisted of Brian Watkins, Megan Vargas, Sonia Allen, Shannon Trotty, Bao Chan, and John Floyd? She had reported that was her team on this case.
I know John Floyd was involved, and she probably told me the others, but listen, I barely remember what case I tried last year, much less every word.
What's wrong with my microphone, Charlie? Check your microphone. What happened? Oh, okay. Sorry. I'll make sure. I didn't realize the mic was still on. My bad. Sorry.
That was said in the conversation.
I understand, fair enough. But she said she was looking to hire more lawyers and investigators to work on this case.
She told me, it was to me, she said, would you be interested in being special prosecutor in this case? And I gave the reply that I've already known. I mean, about hiring other lawyers or whatever, I don't know. All I can testify to is what she told me.
Did she tell you at all why she wanted to hire special counsel and not use someone who was an ADA, not have an actual employee?
No, she did not. I mean, we did not discuss that. And, but I would assume it was because in a case as big as this, that you'd have to have physician help. I know John Floyd has been in some cases over the years out in Cobb County, for example, and others.
Would you agree that an employee of her office, someone who was paid a state salary or a county salary as an ADA, could handle a case like this?
I couldn't tell you that unless I knew the person, knew their experience, and really had been with them in a courtroom.
All right.
Has an opinion on that.
Thank you.
Yes, ma'am.
Say no.
Hello, Mr. Sathow.
It's been a while.
It has been a while.
I hope you're well.
I'm doing fine, just getting older, but that beats all.
That's true, but that applies to all of us, I believe.
Yes.
I think you indicated that if you had your calendar, you'd be able to pinpoint a date for
I
us.
would.
Is there a way for you, for example, at a break before you actually leave, to contact your folks to see if you can get a date?
I guess I could. I don't know how far back we archived those, but I assume I could.
Would you be willing to give that a shot for us?
I mean, I'll do whatever the court instructs.
So if I ask the court and the court says, go ahead and you could do it, that's all right?
Yeah, it's a family reunion, but to be fair, this is the attorneys that were hired. So, like, Trump's attorney is a really good fucking attorney in Georgia. So, like, these attorneys, like, you're getting the best attorneys in the state in this courtroom. They're gonna know each other. They know who they are. They know each other on first name basis. They've gone up against each other multiple times. They've been co-counseled before. So, I mean, that's not uncommon at all. Like, they all know of each other. So that's, you know, it's a bit incestuous, but you go to anywhere, really, the attorneys are going to know each other. You know, hey, Bob, what's up? Or, hey, Phil, how you doing? How are the kids? Or, you know, this, that, or the other, blah, 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 blah. You know, shit happens. Also, this guy's the former governor. If that's somebody you're going to hobnob with, that's the guy you hobnob with. So
I'll do whatever the court instructs.
I hear you.
And you should too.
I try to live by those words. I'm not always successful, but I try. If I pinpoint a date, for example, I think the record is clear that Mr. Wade was hired for the position on November 1 of 2021. Does that help you at all?
No, it does not.
Then let's go to the meeting. It sounds like it was just one meeting.
Yes.
And could you tell us where that meeting took place, if you
It was in
remember?
the conference room adjacent to the district attorney's office.
So was it in this, or the adjoining building?
It was in the Lewis Slate building.
And District Attorney Willis was there, obviously, right?
Yes. Yes.
And Mr. Wade was there?
The best I recall, now I could be mistaken about that, it's like anything that far away, but that's my recollection.
Do you have a recollection of anyone else being present?
Yeah, there were some other folks, but I don't remember.
Do you remember, were you introduced to Mr. Wade by anything other than you already knew him? Was he given a title
I
or
would've
anything?
known.
So at least as you're there, if I heard you correctly, Miss Willis did all the talking, Mr. Wade did not.
I mean, we exchanged pleasantries, but as far as the basis of the conversation, the reason I was there, Ms. Willis did the talk.
And would you be able to give us an estimate how long this meeting lasted? Just rough.
Probably an hour.
And during the meeting, you made it clear, but it was the thanks for the offer, but no thank you.
Oh, yes, I did. As I said, I started off as a prosecutor, and for about 10 or 15 years, I did nothing but criminal. But I've tried to move away from it and do primarily civil now. Mr. Gillen and I have done some white collar cases over in federal court. I've got one over there right now, but it's generally business related, you know, where I have a client that's got a kid or him getting indicted. And the case I have over there now is an alleged fraud case.
Fair to say that based on your career and the work that you've done, you've handled high-profile cases, correct?
I have. I've handled some pretty good cases. I sued Syria one time for beheading a client of mine, recovered $82 million. I guess that's the best high profile, but that was in D.C. I tried that up in D.C.
And what would be considered complex cases, you've handled those as well, correct?
Yes, I mean we regularly
You won $80 million, but how much did you recover?
do mass torts, class actions, business torts, breach of contract, and most of those are complex, requiring many experts. We also do malpractice. I did malpractice defense for about 25 years, but since I've returned from the governor's office, I try not to represent an insurance company anymore. And I just tried a malpractice case before Judge Edlin in November. And those are complex cases because of the type of, medical knowledge and that you have to have, and also because of the many experts that you have.
Thank you. Did Miss Willis, and this is the last question, did Miss Willis tell you why she had sought you, why you had been her choice?
No, I hadn't, but I get consulted fairly often on major cases.
Would you believe, based on circumstances in which you were given the offer, that it had to do with the fact that you had handled complex and high-profile cases in the past?
It could have been. I know her very well. I tried a case against her. She worked for the JQC, and I represented Judge Robert Crawford, Matt Crawford, and she prosecuted him, and I defended him. She beat me at the trial. I turned it around at the Supreme Court.
So you had some experience with it.
Oh, I had plenty of experience with it. She's a very qualified young. Well, everybody's young to me, but she's a very qualified young woman.
After that one occasion,
Mm-hmm.
did you have any other contact with her in reference to the position itself or who she might be considering?
I had some conversations with her or Jeff DeSantis or some of those, but not really an in-depth, about who she should hire or anything like that.
Did the name Nathan Wade come up in those conversations
No.
with her? No, right?
No.
Nathan
Nathan was there, I thought. Now, I could be mistaken, but I thought Nathan was there when I.
For the
I think
conference.
Nathan was. I'm not positive. Nathan was there when I met with him.
Right. And my question was probably poorly worded, but what I was asking is after the conference and whatever consulting you might have done.
Yes.
What's a JQC? I don't know. Hold on. I don't know. Also, that's interesting. So there was no issue of talking about was Nathan. Notice he's trying to be nice about it, saying that he knows what the hell he was there for. What's JQC mean? I don't know what JQC means, guys. Sorry. I just tried Googling it. Oh, Judicial Qualifications Commission. Okay. So she prosecuted a judge on behalf of the Judicial Qualifications Commission. So that's when he defended the judge. Okay, there we go. So that's in charge of a Judicial Qualification Commission would be who governs judges when they break their rules. So they're in charge of disciplining judges. So he's a fan. Well, that's how old guys dress, dude. He's an old guy who hunches over all the time. So Anyway, so we're going to keep going.
Ms. Willis or Mr. DeSantis bring up the name Nathan Wade as a special prosecutor?
I don't think so. I don't recall one. I mean, Nathan is a good organizer. You know, Nathan can organize stuff. I've watched him over the years. So I wasn't surprised that he was acting as a special prosecutor.
And Mr. DeSantis, for the record, who was that? Jeff DeSantis?
Jeff DeSantis.
Do you know who he is?
Oh, yes.
Could you tell us who he is for the record?
Jeff works in the DA's office. I knew him when he worked for Thurber Baker.
Do you know what his role in the DA's office is?
I have no earthly idea.
Is he in media? Does that sound familiar?
He has done media in the past. Jeff has generally been, I like Jeff, and I'm very close to him, but he's generally been on the other side of my campaign.
All right, so we're talking the best of your recollection, conference, we don't have the date, I'm asking if you could possibly get it, but the conference you have, Mr. Wade could have been there,
Yes, I'm almost sure he was.
and Ms. Willis, obviously, and Mr. DeSantis was there.
I think Mr. DeSantis was too.
And as far as whether there was anyone else there, you don't
I
have a
don't
present recollection?
No.
Okay, thank you, sir.
Next time I'll take a picture, so I'll have an exact.
Next time, hopefully, you won't have to be here.
Well, hopefully not.
Thank you, sir.
All
All
right.
right, Mr. Stockton,
No questions, Judge.
Thank you.
Mr. Durham,
No questions, Your Honor.
Mr. McDougall,
No questions for the governor,
Mr. Rice,
No questions, Judge.
Mr. Gillen.
I've been waiting for this.
I couldn't give up the chance getting up here, Governor. Good to see you again.
Good to see you,
We've
Craig.
done some work in the past together, haven't we?
I consider you to be one of my best friends and a crackerjack lawyer.
Well, I will say to you on the record that I can understand why they came to see you because you're the finest lawyer that I've ever worked with.
Thank you. I need to put you in the next day.
Yeah, there we go. We'll get that. But I got one or two more questions.
Okay.
You and I working together when
Suck each other's wieners.
when it's appropriate. We've had no qualms about filing motions to disqualify the DA, have we?
No.
Matter of fact, you and I successfully disqualified the DA out in Cobb County in the Brown case, didn't we?
We did.
So whatever needs to be done should
You
be done.
represent your client.
You got that. Thank you so much.
Mr. Coturo, are you still with us by Zoom?
I am, Your Honor.
All right, any questions?
No, sir.
All right, and Mr. Cromwell for Ms. Latham?
No questions, Your Honor.
All right, any redirect, Mr. Abadi? Can this witness be
Good
excused?
question, guys.
Your Honor, is there a way that we could potentially ask for you for that date?
Very good
The
question,
issue, the
John.
question is, you want the exact date that the meeting occurred?
Yes, if we can get that.
And I'm wondering if we can, if it's really material, the exact date rather than just its proximity to the November 1st hiring. Is that fair? If he knows whether it was far earlier in the year.
Island saying, I'm so lost. This was the guy Fani Willis was going to hire before Nathan Wade. This was supposed to be her number one. This is the guy, this is the former governor of Georgia. He's apparently a well-established trial attorney, really good at his stuff. I mean, all these other attorneys know him as a force to be reckoned with. That tells you a lot. This guy's good. Fani wanted him to lead the charge, and the guy's like, I don't want to do that. I think part of this is to point out that Fani tried to get the best attorney possible, and then she settled on the guy that's, licking her pussy, is pretty much what it came down to. So that's where we're at with this. That's what the discussion is. That's who this guy is. And they're giving him a lot of deference because he's an old man. He's the governor. This guy's time is very precious. But yes, so Fani was fucking around. And then Nathan Wade was there, but he wasn't picked yet. So if he was there, and this is the question that John brought up. So Wade was hired on by Willis. Yeah, but at this point, he wasn't hired on yet. So what was Nathan Wade doing there? Which implies they have a relationship. And I think so I hope that catches you up, Island. That's where we're at with this. That's why this makes sense, why they're bringing this guy in. He was the first pick, and he turned it down. So then Fanny's like, oh, well, shit, I guess you could be it, Nate. And I hope that makes sense to you guys. Let's not talk about with my name on the screen. Okay. So, okay, fine. The guy who's getting very intimate with her. So here we go. Yeah. All right.
Here versus maybe closer, would that obviate the need for the exact date?
If you can't get the exact date, of course, we'll take the best we can get.
Okay, let's start there.
All right, let me
I think, well,
look
you
around.
may take care of it for us, just if we hold in place here.
I'm not sure of this.
Well, let me try this first, Governor Barnes, before you do a deep dive in the email there. Do you recall what time of year it was when this meeting occurred?
I'm afraid not.
Okay.
I mean, you know how this is. The cases and the days moved together. I had a fellow a few years ago that said I represented him in 1978, and I told him I'd take his word for it.
Now, you wouldn't, I gotta ask though, you wouldn't do that if it was a question of him saying he just paid you.
No, I would not. I will tell you, I believe lawyers should be well paid, Mr. Saban.
All right, so sir, is that something?
I'll have to look. It didn't come up.
Lawyers
Okay.
should be well paid.
All right, we'll ask this witness to step down, subject to recall.
Even though you're Democrat bro-fist,
And-
lawyers
and
should
now
be
after
well
something-
paid.
The state can present with stipulation as well. All right, thank you, sir. Do we have an update on Mr. Bradley?
Good lawyers are known for, if you can be a good lawyer and not be a big asshole, that gets you really far. Really, really far.
Lawyer should be here. He's probably outside. I'm saying.
The last estimation I heard was about 11:30.
Okay. If that's still the case, then Ms. Cross, did you have another witness available?
But having brought over, it's Mr. John Floyd, not the special prosecutor, John Floyd. John Floyd, is District Attorney Willis's father.
Okay. And is he heading this way?
Yes.
All right.
Oh shit, guys, this is day 2, not day 1. Fuck. We started off on the wrong day. My bad. I thought this was day 1. This is no good. This is no bueno. No bueno. I am so sorry. We need to do day 1. Because I didn't get day 1 done. So, my bad.
No, she would never.
My bad, guys. So here we go. I apologize. That was really embarrassing.
Name CHOPRA.
All right. In terms of just a little housekeeping in terms of presenting the evidence this
So
morning.
you know what? To be fair, we know what happened.
My
Wait, why am I?
thought
Wait,
was,
wait.
as witnesses are called,
Time out. Why am I doing this? We all know what happened. I watched a bunch of day 1 yesterday. We're just gonna fucking do day 2. Fuck it. We're doing it live. Day 2 only. Day 2 only. Let's just do it. We'll do it to it. That was dumb. Sorry, chat. That was moronic. Where the fuck is this guy we're waiting on? Ashley Mercer's got some big old boobies. Holy cow. You see those? I mean, look at those things. No wonder Fanny's mad at her.
Mr. Ward, we're just holding in place for taking witnesses out of order. Do you have any updates on Mr. Bradley?
Yes, so.
We can't go back, chat.
May last 24 hours. However, he's going to make himself available for Zoom if that's possible.
All right. Ms. Merchant?
I was outside looking for them.
Sure. We found it.
I'm sorry.
So he is asked whether the defendants would accept his testimony by Zoom.
As long as I can show him documents if he needs his memory refreshed, then that's fine.
It is not. The state would have an objection to this witness not appearing in person.
Understood. All right. Mr. Ward, I think we're going to need continual updates from you and also some kind of expectation of what this afternoon is going to look like. I was never informed of a medical appointment. And I think the notice in this hearing indicated it would last at least 2 days. So right now, I think he's in violation of his subpoena.
Ooh. That's not good.
Your Honor, I believe in
That's not good when the judge is like, hey, man, your boy ain't doing it right. That's not good.
counsel's given notice of his doctor's appointment. He missed one yesterday. He took the stand yesterday. We were hoping to keep a his testimony yesterday. I stayed here all day. This appointment started at 9, and it's out of his control with regards to, again, the issues involved with it, and as well as
I'm just trying to get more. I mean, we initially been told maybe it was going to be 9:30 and 10. Do we have any better idea to get a realistic expectation of when we think we can have him here?
If it's Your Honor's will, which come on in, and we have to go back to
Is he, without getting too much into the particulars, has he already been seen by the doctor and he's waiting for results, or is he still waiting to be seen by a doctor? I'm just,
The check it out his asshole, doc, sir.
and after he gets those results, he was supposed to have another meeting with them today as well. But potentially that meeting could occur later.
after they're able to figure out purposes of actual.
Okay. If you can get any kind of an update on how much time they think that those results are going to take. If it's more than an hour or two, I think we would want to start bringing him here, and he can have that follow-up consultation later. All right. Thank you, sir.
Did you all want to take up the 1.6 motion?
At this point, I think we've got something else that can occupy our time, and I think we need to move forward with that. All right. Of course. Yeah, absolutely.
And I didn't learn about the equipment.
Right. Okay. Understood. Ms. Cross.
Yes, sir. Mr. Abate will,
Mr. John Floyd.
Mr. Floyd, if you could have a seat, sir.
may I approach the witness quickly?
Thank you. I do.
Please state the spelling full name for the court.
My name is John Clifford Floyd III.
Say, good morning, sir.
Good morning.
Can you tell the court, are you currently retired?
Yes, I am.
And prior to being retired, can you tell the court a little bit about, did you work in the legal career? Were you a
I
lawyer?
was an attorney. I practiced law. I've probably tried 1,000 cases. About 50% of my practice was criminal law. 25% of it was family.
This is Fanny's dad, a militant communist. Member of the Black Panthers, and at one point shacked up with Angela Davis, one of the most militant communists that was chased down by the FBI, and actually you'd call her a terrorist. So, yeah, Daddy Willis should be taking a helicopter ride too, at some point.
Law, and the rest was whatever walked through the front door could pay for it.
Okay. And
Could we wait 1 second? Governor's come back. He might
I
ask.
do. My calendar shows it was October 26, 2021.
All right. And would defense counsel accept it as a stipulation, or is there any follow-up questioning needed on that? Mr. Barnes is still considered under oath on this point. All right. I'm just going to look for a show of hands or for someone to speak now on Zoom, and hearing none. Thank you, sir. You're excused.
And sir, can you tell the court, are you from Atlanta?
No, I grew up in South Central Los Angeles. I spent most of my legal career, I would say, in Washington, D.C. was kind of the circle, but I've tried cases all over the country, and I tried the longest. I was the first lawyer to try an international criminal court. I was with the International Criminal Tribunal for Rwanda. I was in trial there for 4.5 years in Arusha, Tanzania, and Hague in the Netherlands.
Okay. When you weren't there, it sounds like your kind of center of gravity was Washington, D.C.
Correct, but I've tried cases in West Virginia, Maryland, Florida, California.
All over.
Yes.
And do you, sir, can you tell the court, do you have any children?
I have one daughter, Fani Willis.
Okay. And I want to direct your attention.
Whoa, I just
to
noticed this.
2009.
Homie's got a bit of an underbite. Maybe that's why he called her Fani. Instead of Fanny, it's Fani Willis. Got an underbite like Clyde.
19, okay?
Yes.
Back in 2019, can you tell the court, did you move here to Atlanta?
I was living in Johannesburg, South Africa. And unfortunately, for some reasons, I could not get an extended visa. When I retired from the practice of law in 2018, I moved to South Africa. And I had to leave South Africa, and I did then come to Atlanta.
Okay, and do you, sir, remember about the time period in 2019 when you moved in with your daughter here in Atlanta?
It would have been the spring or summer of 2019.
And after you moved here, did you get a driver's license to kind of confirm your residency in Atlanta?
Well, my driver's license for the District of Columbia was going to expire on my birthday, which is in October. And yes, I did get a license here in the state of Georgia.
Your Honor, may I approach the witness?
Okay.
You can just take a look at what's been marked as State Exhibit
Okay,
2.
Your Honor, would you, if you don't mind, my eyes are very bad, which is one of the reasons I retired. And so I need a magnifying glass, so I'll be
Whatever you
constantly, thank you. Yes, I see it was issued on 9/28/2019.
Okay, so before we get there, do you recognize State Exhibit 2?
Yes, just my driver's license.
And is State Exhibit 2 a fair and accurate copy of your physical driver's license?
Absolutely.
This time, Your Honor, the state would tender what's been marked as State Exhibit 2 into evidence.
Seeing no other objections, it's submitted. State Exhibit 2 is submitted for the record.
Now, and for the record, Your Honor, the state is going to supplement State Exhibit 2 with a redacted copy of the license. The current copy is not redacted with the address and things of that
All
nature.
right. And do we need to mark that differently in any way?
I will mark it as State Exhibit 2A.
Perfect.
Now, you talked about when your driver's license was issued. Can you tell the court when was that driver's license here, your Georgia driver's license issued?
It was on 9/28/2019.
Okay, so September 28th, 2019. Now, when you moved into District Attorney Willis's home, who lived there?
Well, my daughter lived there. I lived there, and from time to time, my grandchildren would come.
Okay, and did your grandchildren, were they at school coming and going?
Exactly. I think they were in school in various jurisdictions.
And during the time, how long did you live at or with Miss Willis, and at her home here in Fulton County?
She was forced to move after she was elected. I don't know if you want me to go through the whole thing, but that, Your Honor, if Your Honor will indulge me. After she was sworn in on January 1 of 2021. And on or about the 3rd of February, at probably 5:30 a.m. in the morning, there were people outside her house cursing and yelling and calling her the B word and the N word, and just, it was bizarre. Okay,
Sorry? Pause, sir. Mr. Urbani. Here's the objection to you.
I would say it's effect on listener. He was present while all of these things were occurring, but I can.
No, that's, and he's saying he was personally present to hear these things?
Yes.
Okay, overruled.
Okay, and fortunately, the neighbors called the police and disbanded the group, and it was just, it was just, I hadn't seen anything exactly like it before.
Okay, and after that happened, can you tell the court that Ms. Willis would have to move from her home?
Yes, she was forced to leave.
Okay. And can you tell the court after she was forced to leave, shortly after she was sworn in, did you remain at her home in Fulton County?
Yes, I stayed there really until 2022, I guess.
And from what you described, did you fear for her safety?
Absolutely. Not only did I do that.
Interesting thing too. Remember how Fani said, like, my dad was old and he's it's COVID and he was old. It's like, does this sound like one of those people who's old like that? No, this is a scrappy old fighter. So all this bullshit about him, oh, he's like all old and COVID was like, I don't see this guy being scared like that. Not this guy.
The South Fulton police, they brought a man with a dog, because there have been so many death threats. And they said they were going to blow up the house. They were going to kill her. They were going to kill me. They were going to kill my grandchildren. On and on and on. It just, it became, and I was concerned for her safety.
And after those concerns came to your attention, and after what you heard and saw that day, you remained at the house?
Yes.
And can you tell the court, with what you just described, why did you remain living at the district attorney's home here in Fulton County?
Mr. Bond.
I believe it's relevant based on a lot of the questions that were asked yesterday of Ms. Willis as to about the security threat, and the fact that it was implied that those threats were not necessarily real, in the sense that Mr. Boyd remained in the home. There were many questions about the fact that he remained and her children could still come and go to the house. I think it's relevant based to the testimony that was elicited from defense counsels yesterday.
Overruled.
Well, these South Fulton police, first they put a car in front of the house that was there permanently, a police car. That was thing one. Thing two, they brought a person with a dog, sometimes more than once a day, twice a day, and they would circle the house to look for bombs. I knew that was a house that my daughter had worked for. It was a brand new house. She's the only one who had ever lived there. It's a 4-bedroom, brand new house. And somebody needed to protect the house. And I stayed there to basically take care of the house, to take care of the yard, to take care of that. Also, somebody sprayed, again, the B word and the N word on the house. And I don't think my daughter even knew that. I cleaned it off and called the police, and South Fulton police. They have, I'm sure, all the records of all the things that happened. And all of the neighbors, I notified all the neighbors to look out and to watch out. And it was so crazy. It was just so crazy. We'd have people, guy parked for probably 8 hours out in front of the house,
Now, at the time that you lived there with Ms. Willis, and I guess even when you remained, so during the time period of 2019 to the end of 2020. Are you aware if Miss Willis was dating someone?
Yeah, she did. She had a boyfriend when I first got there.
And did you meet her boyfriend?
Yeah, I met him often.
Okay, and did you know him by any specific nickname?
Yeah, Deuce.
Okay, and can you tell the court while you were living there, how often would you see him?
Sometimes every day, sometimes every other day. He
whoa, 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 whoa! What? She saw him every damn day? Uh-oh, Fani. Uh-oh. Uh-oh. Hold on. Uh-oh. 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 Uh-oh, Fani, that's not good. Deuce is right in more than one way. Oh, not Nate? Oh, it's not Nate? Oh. Well, who the fuck is Deuce? Oh. I was about to say, so it's not Nate. All right. We'll see. Okay. Damn. Fani lied about not dating and being lonely, though.
It's a disc jockey or something, and he had all this paraphernalia that I'd have to move out. There was a thing with the keyboard. Things that play music and so forth. So
now, when you moved in 2019, and then throughout the years in year 2020, 2021, had you ever met someone named Nathan Wade?
I did not meet Nathan Wade until 2023, about a year ago, when a reporter by the name of Issakoff interviewed me. I met him. That was the first time I had met him.
You said that was in 2023?
2023, right.
That's Michael Issakoff. That's interesting that he interviewed him.
And I know you said you hadn't met him until 2023, but when you were living at Miss Willis's house in Fulton County, did you ever meet Mr. Wade in the year 2019?
Absolutely not.
How about in the year 2020?
Absolutely not.
Did you ever see Mr. Wade at Miss Willis's Fulton County house in the year 2021?
Never.
And is it your testimony that the only time or the first time that you met Mr. Wade was in 2023?
Let me say something. Mr. Wade said that he remembers seeing me, and I do remember some banter. I'm a member of Kappa Alpha Psi fraternity, and there's kind of this thing that goes on between fraternities, and Mr. Wade is a member of Alpha Phi Alpha, and I do remember there was some kind of banter when my daughter was sworn in to be district attorney between me and a couple of guys, and he said he remembers me. I don't remember him.
And prior to that experience that you're talking about, as well as, I guess, your official meeting in 2023, had you ever even heard his name?
No, never.
I don't think I have any further questions, Your Honor.
Ms. Merchant.
Yes, thank you.
Fine. How are you, counsel?
Good, thank you. Just got a couple questions. On Monday, we heard you were in California. Do you have a place in California?
People always ask me about where do I live.
Why you
I guess
laughing,
I
Holmes?
live right here, sitting in this seat right now. But yes, the answer is I have a place in Los Angeles.
Okay, you do. All right. So do you share time or split time between Los Angeles and Georgia?
Actually, I'm working on a documentary film, and I'm supposed to be being filmed not for this trial, but I'm supposed to be being filmed right now. It was planned, and we had to stop it because they asked me to come here. But the answer is I'm working on a documentary, and I'll be in California until I finish the documentary if we don't have another actor strike and we don't have another writer strike.
So do you own property in California?
No, I don't. I live with a friend of mine.
You live with a friend of yours. Okay.
Yes.
And when did you first move?
His name's Alejandro. He follows me
Let me
out.
qualify with the dates. Did you spend any time in 2019 in California?
No, and the reason I didn't is that when I first came here, the answer is no, I did not. What happened was COVID. Once COVID hit, I was just paralyzed. I couldn't go any place. I couldn't go anything. I mean, I'm a theater buff. I used to go to theater at least once a week. But when COVID hit, I just couldn't. I couldn't go to the dentist, which I need to do. Or, you know, it was just a thing. So I was just stuck. I was just stuck there.
I may be wrong, but I believe COVID hit in 2020. So I was asking about 2019. In 2019, did you spend any time in California?
Before COVID was even here in the United States, remember I lived in South Africa and I've traveled the world. I knew COVID was coming before. I knew COVID was around before. They may have announced it in 20, but in fact, I knew about it and I knew what was happening in 19.
Okay, so let's walk through 2019 then. You said you moved here in September. So
No, I didn't say that. I moved here probably prior to September. In September is when I got the driver's license. I probably moved in the springtime.
I'm sorry, you did. You said spring, summer. I see that in my notes. So spring, summer 2019 is when you moved here. So up until spring, summer 2019, where did you live?
I lived in Johannesburg. Well, I lived in Washington, D.C., 2018. I had planned to retire for the rest of my life in South Africa. I had worked for Nelson Mandela and the Free Mandela and getting that. And someone I'd gone to law school, he had located there after Mandela was freed from prison and became president. I was going to live there for the rest of my life, but unfortunately, because of political reasons, I could not stay in South Africa, and I was forced, in a sense, to come back to the United States.
Okay, so let's just focus in on the period from, let's just start with October 2019. Okay, we'll call that the relevant period. October 2019 until the end of 2019. Were you in Georgia every single day of that year?
Absolutely.
So now let's move to 2020. Okay, and every single day, before I move on, every single day in 2019, you slept at your daughter's house, correct?
That's correct.
Okay, so let's start in 2020. All right, so 2020, the entire year, did you travel anywhere?
No.
You didn't travel at all that year?
No.
So,
And I didn't go to the movies, which upset me also.
So that entire year, 2020, you remained here in Georgia?
Right.
In 2021, did you do any traveling?
No.
So when did you move back, or when did you start this documentary film in Los Angeles?
What I had been doing to occupy time was I was writing my own memoir. As I delved into my family background, I discovered something, and that's what got me to working on the documentary. So I want you to understand what was going on in my life. I pitched I have a movie script called Bad Blood. I have a movie script we're trying to sell. So I tried to sell that, and I just happened to mention something that happened during the civil rights movement. SNCC, it's called the SNCC 5. The legendary Peter Fitzsimmons was interested, and so with Peter Fitzsimmons and Leah Smith, we're now doing the documentary. So
I don't want to interrupt you, but what I was asking was when you moved to Los Angeles, not what you moved there for.
Well, you keep saying moved. I haven't moved to Los Angeles. I spent more time in California, in Oakland, if you really want to just be, because Peter is basically San Francisco based. So we're working on the documentary.
Okay.
I was in Los Angeles because I was going to the Pan-African Film Festival. And that's why we were there. And the way Hollywood works is, you know, when you make connections, and film festivals are a place to try to sell ideas and meet people and organize things.
You still own property in Washington, D.C., correct?
No, I don't.
You don't own property at 1467 Roxana Road Northwest?
That's where I used to live.
That's where you used to live. Did you own that property?
Yes.
Okay. And you owned that property when you moved here in 2019?
Yes.
And you owned it in 2020, correct?
Well, you talk about a very complicated issue. I left the property. There was a dispute between me, and I had gotten a reverse mortgage company. And there was a dispute between me and the that, and I just
reverse
I walked away
mortgage.
from it.
Okay.
You got
walked
fucking
away from it
swindled.
with almost $300,000.
Yeah, what is the relevance of that?
Where he lived and registered to vote. That's what they brought in. So that's
Why is the money he got from the sale relevant at all?
it's the only proof I have of that he owned that address. So I can move on now. Okay. When did you sell that property?
I didn't. The reverse mortgage company took it.
Oh, okay. So in 2019, when you got your driver's license here,
Yes.
the next day you registered to vote, correct?
I think it may have been the same day, but maybe it was the next day. I don't remember.
But you didn't own property here in Georgia that day?
No, I was living with my daughter.
He let Tom Selleck take his house.
You said that you met Mr. Wade, that you remember you met in 2023, right? That was the first time you
Correct.
remember? Okay. And I wasn't really clear. You said something about meeting him. Was it with Mr. Isikoff or did Mr. Isikoff tell you?
No, I was being interviewed by Mr. Isikoff.
Okay.
And he walked
Michael
in.
Isikoff's a
and
reporter. He wouldn't
I
know
met him that was
anything.
the first time. He walked into the office and
Where were you being interviewed?
at the district attorney's office.
And Mr. Wade walked into that interview?
Yes.
And so Ms. Willis had not told you about Mr. Wade prior to that.
Absolutely not.
So she didn't tell you anything about their relationship before you met him that day.
No.
But Mr. Wade remembers meeting you in 2020.
He said that at my daughter's swearing in. I do remember that we having some banner about fraternities, but other than that,
Oh, at your daughter swearing in. Okay.
right.
That's all I have. Just one moment, Judge. Nothing else. Thank you.
Interesting. Oh, yeah. So
Morning, sir.
interesting.
Good morning.
Yes.
How are you, counsel?
I'm fine. I'll try to ask you some specific questions if we could, okay?
And I'll give specific answers if I can.
Perfect.
Okay.
The driver's license address, I'm not going to publish. That is State's Exhibit number 2. But is the address on that driver's license the home that you're referring to as your daughter's in South Fulton?
Absolutely.
Okay. It was unclear to me, maybe no one else, but it's unclear to me. When did you stop living at what I would call your daughter's home in South Fulton?
Things got so bad and threats got so many, even against me, that the house became basically uninhabitable. I got tired of sleeping in one room one day and no one that. I would say December of 2022, something like that.
December of 2022.
Right. That's about right. Yeah.
Now, let me change and go back for another date. You had
Strap
indicated,
in.
I
Ooh, it
didn't
gets
hear.
good. All right, here we
When
go.
was your daughter, Miss Willis, when was she sworn in as district attorney?
On January 1, 2021.
Okay. And did you indicate that there was an incident, and I know you've described it, was that incident on February the 3rd, 2021?
That's my best recollection.
Okay. So my question then is, after February 3rd of 2021, how much longer did Miss Willis stay at the house before she moved somewhere else?
Very short period of time, and I cannot be precise, but I would bet all the money I ever made, it wasn't more than a month and a half, if that long.
Okay, so we're talking about, best of your recollection, end of February into the beginning of March, give or take, of 2021, when Miss Willis would have moved to a different location.
Exactly.
Okay. And did Miss Willis return to the house, that is the house that you were in, at any point in time that you can remember?
From time to time, she and her security might show up for her to pick something up or take something or something, but she always would come with her security.
Okay, my
Bring her
question is
security.
poorly worded, I apologize. Did she come back permanently to her house?
Oh, absolutely not.
Okay,
Absolutely not.
So as far as you're aware, that once Miss Willis left the house, her house, South Fulton House, so the record's clear, in either late February or into March of 2021, best of your recollection, she's not returned to that home to live.
No, it became uninhabitable. I mean, it just,
That's okay.
I would have to walk around that house looking out of every window. I made a habit of having to walk around the whole house. I got lights so that if somebody would come at night in the back, so that those kinds of reflecting lights, I had those put up.
I don't mean to again cut you off.
Okay.
All I was interested in is whether she had ever returned.
No, the answer is no.
Okay. Now, when Miss Willis, when your daughter left the home, time period, end of February, beginning of March, give or take, 2021, do you know where she moved to?
No, and I didn't want to know. I intentionally did not want to know.
Ooh.
Because I was not, if somebody stuck a gun to my head and I could tell them, I wasn't going to tell them anyway, or I'd have made up something, but I didn't want to know.
Okay, so would it be fair to say that if you didn't want to know, you never visited her at the place that she moved to?
Oh, I never did.
Never did.
Never did.
Okay. Do you know how long she stayed at the first place that she went to after she left her house before she moved to a second place?
What I know, and this is hearsay, counsel, is that my daughter has had to move something like 4 times.
But do you know any potential?
No, I don't know any place. I was taken one time for Christmas Day. I've only seen my daughter, and this is very hard for me to say, but during the period my daughter left, I've only seen my daughter 13 times. Because I can't, and we've never seen each other more than maybe 3 hours because of, the nightmare threats against her and me.
And I understand that, and from the perspective of being a father myself, I understand what that means. So I'm going to move away from that. I was just trying to get an idea date-wise, okay? So let me try to get one more date. In 2023, when you were being interviewed by one of the gentlemen that wrote the book at the DA's office, and Mr. Wade came in, can you give us, other than 2023, what the date would be?
I'm sorry, I can't, counsel.
How about spring, summer, any idea?
I would guess spring or summer, but I can't.
Okay.
I don't. I'm sorry.
And you've already indicated, at least to your recollection, that was the first time that you'd met Mr. Wade.
Oh, absolutely.
Okay, I'm not arguing with you about that. I want to go to Miss Willis's boyfriend that you referenced. Okay, you met Miss Willis's boyfriend, as you've characterized it, when you came here in 2019.
Correct.
And you met him on one occasion, several occasions?
Oh, no, I saw him often.
Oh, so you mean there was no secret that she was dating this man?
Not from me.
Not from you.
And he was a disc jockey of some kind. I think he had a government job during the day. I don't know what it was, but apparently he would do weddings and so forth and so on. He was a disc jockey, play music. So he had all his stuff was always in the way, and I was always having to try to push it aside. And anyway.
But Miss Willis, your daughter didn't keep him from you, correct?
No.
No, I mean, there was no doubt
my daughter and I lived in the same house. I mean, he came and went,
Right. Now, when did you learn that your daughter had a romantic personal relationship with Mr. Wade?
Well, about 7 weeks ago when as a matter of fact, I just found out when other folks found out. Okay.
But as your daughter, as I understand it, never told you one time in the year of 2022 that she was dating Mr. Wade, correct?
That's correct.
And until recently, you didn't know from anyone, including your daughter, that she dated Mr. Wade, correct?
That's correct.
That is, whatever the relationship is between father and daughter, she kept that a secret from you, correct?
Correct.
That's all I need to know.
Mr. Stockton.
No.
Good morning, Mr.
Good morning.
Correct.
Good morning, Counsel.
When your daughter moved or left the house that she owned, did she say anything to you about having a large savings of cash?
Oh, no, no. See, maybe, excuse me, and Your Honor, I'm not trying to be racist, okay? But it's a black thing, okay? You know, I was trained, and most black folks, they hide cash or they keep cash. And I trained, you always keep some cash, because I've been places, and just because of the color of my skin, for example, I took a fellowship at Harvard when my daughter was just, if I might, Your Honor, when I was just, she was just, maybe 3 years old. And I remember going to a restaurant in Cambridge, Massachusetts, and I had a American Express credit card and maybe a Visa or whatever. And I had a lot of what they call traveler's checks. I don't even know if they still have traveler's checks, but traveler's checks. And there was a sign said, with the credit card. For whatever reasons, the man would not take my American Express credit card. So I pulled out my Visa card, and he wouldn't take my Visa card. So then I pulled out my traveler's checks. He said, we don't take checks. Now, these were traveler's checks. This was money. I had a $10 bill. I'll never forget this as long as I live. And he said, the bill for my wife at the time, Fani's mother, Fani, and myself was like $9.95, and I had a $10 bill. That was all that. I always remember that. But even before that, I've always kept cash, and I've told my daughter, you keep 6 months worth of cash always. For example, I had 3 safes in my house. I put some of my clients' stuff there too, things I didn't want other lawyers to be, because you're always in a firm, and I knew that there were special conditions. So some of my clients' things I would bring home, put them in the safe. But I've always kept safes. And as a matter of fact, I gave my daughter her first cash box and told her always keep some cash.
So is that a yes?
Yeah. Oh, absolutely.
That's all I got, Judge.
Mr. Durham.
No questions.
Mr. McDougald.
No questions, Your Honor.
Thank you. Mr. Rice.
No question, Your Honor.
Mr. Gillen.
It's still morning. Good morning, sir.
Good morning, Counsel. How are you?
Just fine. Just a few questions following up. When you were talking about when you learned about Mr. Wade and your daughter, correct?
Correct.
Now, did your daughter tell you in around October of 2022 that she had gone on a Caribbean cruise with Mr. Wade to the Bahamas?
The answer is I knew that my daughter had gone, but I did not know who she went with or what the circumstances were. So I knew that she had gone out of town, but I didn't know with whom.
I see. And did she tell you in November of 2022 that she had gone to Aruba and stayed at a Hyatt Regency resort there in Aruba for 3 days with Mr. Wade? Did she tell you that?
The answer was, again, I knew she went out of town. I didn't even know where she went. I knew she was going out of town. She told me she was going out of town. I think she might have said she was going out of the country or something. She'd be gone. But other than that, that was all.
Okay. And did she tell you in March of...
Goddamn StreamYard. Okay. Chat, you guys are telling me to buckle down. Like, get ready. It's getting bumpy. When's the bumpiness happen? Because this guy's kind of bumbling around like a moron, but nothing huge yet. To me, at least.
Of 2023 that she was going to Belize for several days with Mr. Wade?
The same answer, that I knew she would tell me she was going out of town, and she may or may not have told me where she was going, but she'd be gone for a couple of days.
Okay. Now in 2023, you were in many days you would be out in California, correct?
Some days I'd be in California, correct.
Okay. Well, did she tell you in May of 2023 that she was traveling to Napa Valley with Mr. Wade, so maybe y'all could see each other when she visited California with Mr. Wade.
The answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
Mr. Kucherov on Zoom.
Yes, Ron, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either,
We
but
can take a moment.
good morning, counsel.
We can take a moment. Let's just pause, see if we can change the screens to show Mr. Kucherov. Sorry. We need.
Your Honor, I'm on a phone, so it's kind of difficult.
Can you turn your screen on now?
I'm trying to. Does that work?
Just to hold one more moment. All right, there we go. You can proceed, Mr. Kucherov.
Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing. How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it and I was prepped by the lawyers and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
What?
Did you speak with your
prepped?
daughter about your testimony?
Uh-oh.
She may have been present when the lawyers were. I really don't remember.
Uh-oh.
If Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
What do you? Maybe I'm not understanding your question, counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right. Yeah,
Mr. Wade, if Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating. And when were you talking about the cash? I didn't know that. I don't know what you're asking me. What I told my child
Holy shit.
from the time she was a child
Uh-oh.
is always have some money. Always have some money. If you go on a date so that people don't try to stick you and you want to leave whoever,
Gotta stick some
always
deck.
keep some cash, okay?
Mr. Floyd, you answered the question that the attorneys prepped you for that. So that's all I wanted to know.
Anything else, Mr. Kucherov?
That's it, Your Honor.
All right, Mr. Cron.
And he's not like he's there's nothing and he's not catching on. Oh my god, I just admitted I got prepped. And I'm not being I'm like, but wait. That's not what I meant. No, you don't strike the testimony, T. You don't strike the testimony. You allow it in to show that they are fucking around. You do not strike it. You keep it in. Yes. Buck status. Broken AF. Broken. Yes. 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 Total commie death. He strikes the testimony. I wouldn't strike it. I'd leave it on the record to show that they were screwing around. But I guess. All right, here we go, guys. And I have to take care of something, so I'm going to leave the speaker on.
Well,
No questions, Your Honor.
Mr. Abadi?
Your Honor. Mr. Floyd, now, it wasn't common for your daughter to confide in you about her romantic life at all.
No, and I haven't confided in her about mine before when I had one, okay?
And you wouldn't have known about her boyfriend, the disc jockey.
Hey, Debs.
An objection?
I think that might have just been still off mute.
Okay.
Let's keep going.
Now, you wouldn't have known about her boyfriend, the disc jockey, had you not been living with her, correct?
That's correct.
I'll allow overruled.
I have nothing further.
Did he answer the question?
He said that's correct.
All right. By show of hands, any redirect on those points only. Ms. Merchant.
I just want to know when you were prepped by the lawyers, when this prep session was.
I just got off the plane on, what was it, Tuesday night? I think I was probably drooling at the mouth. I was so tired. So it must have been, I got in Wednesday. It must have been Wednesday.
Okay. And did you talk about any of the testimony from yesterday or watch any news reports or anything like that?
Oh, absolutely. You can't cut the TV on without seeing this. The first thing, and I listen to conservative radio a lot, and, you know, last night for 5 hours, all they talked about was this case.
So you were aware of what the testimony your daughter gave yesterday was?
Yeah. Unless you don't cut the radio on, unless you don't cut the television.
That's convenient. Oh, it's all in the radio. I'm sure Fanny didn't prep you. I'm sure her team didn't prep you. But chat. Ooh, boy. Oh boy. Oh. This guy's a lawyer. Yeah, well, just here's the deal. And I am living proof of this. Just because you hold a law license does not mean you are smart. Number one. Number two, his career is being an attorney. His job is to be on the other side of this box throwing punches. He doesn't have experience bobbing and weaving. And he's just taking blows. He doesn't know how to react. I mean, but yeah, trying 1,000 cases is fine. You can be 1,000. You can play 1,000 games as a quarterback, and I'm throwing in a cornerback, and you won't be good at it. I mean, that's what happens, man. I can't see. There is no judge's reaction because we can't see it. So you couldn't see the reaction for the judge, but here we go. Let's go.
Television on, unless you don't read the AJC or any other, the New York Times or whatever, which I do every day. Yeah, of course.
So is it fair to say nobody instructed you that you were under the rule of sequestration?
Right, and I'm not under subpoena either.
Thank you.
All right, anything else? Seeing and hearing none. Thank you, Mr. Floyd.
Thank you very much, Your Honor. It's a pleasure to appear in front of Your Honor.
Take care.
Thank you.
All right, Ms. Cross, let me check in. Was the state planning to call additional witnesses?
Not at this time, Your Honor. We're again trying to accommodate if there's a
Sure.
lapse in schedule to be able to this afternoon. But right now, that was last witness.
Okay, so even if Mr. Bradley testifies to some extent, it's still the potential that the state has no further witnesses?
I anticipate at least one more will be available this afternoon, but that would be it.
Okay, so there are potentially more state's witnesses. All right.
Judge, before we move on, I'd move to strike the last witness's testimony.
All right, so I think the rule is invoked and the instruction was for the parties to tell all witnesses subpoenaed or expected to appear about the rule. I don't think the remedy is necessarily striking. I think it can go also to this credibility as well. So to that extent, unless Ms. Cross, you want something else to be heard on that, point is made. All right. Do we have an update for Mr. Bradley?
Yes, Your Honor. Yeah, he should be here at 12:20, 12:25.
Okay. Then what I think we should do is have these preliminary conversations about privilege, see if we can make any headway, and then take our afternoon break. So to that end, counselors, I don't know if you just want to argue in place there or go to the table, whatever makes you comfortable. But Mr. Chopra, I think maybe it was relayed to you since you weren't in the court earlier this morning. We'd had some initial conversations about the distinction between the privilege and Rule 1.6, and it sounded like you wanted to be heard on that.
Your Honor, it was brought to my attention. And I apologize because I don't have. Thanks.
What do you need?
Well, a copy of the case in front of me would be helpful, but it's not necessary. It would just take me a second to keep looking at my phone and responding to the court.
Whatever you need to do.
Your Honor, I believe the case for in anticipation of piercing the rule 1.6 is on Corning fiberglass versus American C10. Is that correct?
It's difficult hearing counsel. Could you
So no, I was not going to the bathroom, not yet. Holy cow, Fanny's dad. Oof. So, my question though is, you guys are saying something about, was Fanny there? I didn't see them talking about Fanny at all. So, just the lawyers. So I don't. Yeah, that was awful testimony. I don't know. Did he think that was going to be a great job? You know, do you think he walked off thinking I did good by my daughter? You know, that wasn't good. So, yeah, that was awful. I didn't say he said he was there. I didn't hear that part. She was present for the prep. Okay. Did I miss? I must have missed it. Fanny was there for the prep. Hold on, because we need to go back. 'Cause I don't recall that. I'm gonna go back to like maybe about. Let's see if we can do it from here. Okay. Hold on.
Thank you, Mr. Rice.
Oh, hold on here. Okay.
Mr. Gillen.
It's still morning. Good morning, sir.
Still have traveler's checks, but traveler's checks.
Okay, so yeah, we're
And there was a sign said,
okay, hold on here.
I did not know that they were dating.
Yeah, here we go.
Maybe I'm not understanding your question, counsel. So maybe you want to restate. What is it that you're asking me?
Yeah, if it wasn't clear, I can re-ask the question. I'll rephrase it.
Yeah, right. Yeah.
Mr. Wade, if Mr. Wade and your daughter were dating, you wouldn't have known that unless your daughter told you.
I did not know that they were dating. And when you're talking about the cash, I didn't know that. I don't know what you're asking me. What I told my child from the time she was a child is always have some money. Always have some money. If you go on a date
with Mr. Wade,
the answer is no.
And so the first time that you ever met Mr. Wade or learned about Mr. Wade, to your recollection, was in 2023?
That's correct.
That's all I have, Your Honor. Thank you.
All right, hold on, guys.
Kudrow. On Zoom.
Yes, Ron, just a couple quick questions. Good morning, sir. I know I can't see you.
I can't see you either,
We
but
can take a moment.
good morning, counsel.
We take a moment. Let's just pause, see if we can change the screens to show Mr. Kudrow.
Phone, so it's kind of difficult.
Can you turn your screen on?
Does that work? Sir, you seem to know about the issue of cash in this transaction. You said it was a black thing.
Here we go.
How did you know that the cash was going to be an issue in this testimony?
Because I was asked for it and I was prepped by the lawyers and they asked me about it. What else?
And did you speak with Mr. Wade about your testimony?
No.
Did you speak with your daughter about your testimony?
I know he didn't give an answer here, but let me.
She may have been present when the lawyers were. I really don't remember.
Oh, fuck. Oh. Wow. You dumb motherfucker. You stupid motherfucker. You know, some might call that witness tampering. And I would. You know, you might call that suborning perjury. I would. Holy shit, Fanny. Fuck, you are one dumb motherfucker.
If Mr. Wade and your daughter were dating.
Fucking A.
The case that I had cited to this morning showing the distinction between the two was tenant health.
These dumb motherfuckers. These stupid motherfuckers. They thought they were so fucking smart. These stupid motherfuckers. Good catch, Island. Yes. Thank you guys for bringing that up. Yeah, he really wanted to lie and say no. That's why he stopped. Yeah. I was prepped by the lawyers. Yeah, he was really, yeah, this attorney asked, merchant clarifies. Well, yeah, but they got it. God damn. Yeah, they're the worst. They're greedy and stupid. I mean, fucking hey, this is. I mean, I've done cases all over the world. Do you like? Are you globe trotting the world and stepping on your dick everywhere you go? Because that's what it kind of looks like right now. Literally, you just like uncoil your dick on the floor and you go, you know what I'm going to do? I'm going to show all you people in Rwanda the song to dance with my people. We call this the LA Stomp. And you just stand there, just river dancing all over your dick. That's literally what you just did. Well, actually, this time I'd say it wasn't your dick, it was Fanny's dick. But God. Damn. Yes, Vince is like, more dick stomping, more. Yes. Holy crap. Fuck. Can you explain why Joe said he wanted his testimony struck by the defense? Who's Joe? Joe said he wanted his testimony struck by the defense. I don't know what you mean, Charlie. Yeah, send the super chats from more events. Send a lot of super chats. I don't know why Joe wants that testimony stricken. You want it in because now you show she was there. You showed she's interfered with the witnesses. She's interfering with this case. That makes a conflict of interest even worse. That makes her conduct unethical. You want all of this in there. Why would you ask for, Your Honor, I want you, all this shit that really hurts the opposing party, I want you to strike it. No. That was 100% responsive. They gave you what you need. You keep that shit in. You keep it on the record. Striking it is not good. I don't know why you'd move it. There's no reason to move it. There's no reason to strike your testimony. Yeah, like I said, you might call this witness tampering, and I would argue, yes, I would too. That is witness tampering. Especially when the star, witness, because remember, Fani has not done her cross yet. The state has elected to call her later. So Fani hasn't done her cross yet, so it's even worse. She's still in the middle of her testimony, and she's fucking with witnesses. That's even worse. That's so much worse. I don't think you guys get that. She testifies and is done. Fine. She still has not had her cross-examination where the state gets to talk to her and lead her. That hasn't happened yet. She didn't start. So, no, you need her back. But in the meantime, she's out there fucking with witnesses. No, you don't strike testimony like this. You keep it in there. You keep it in. I would fight tooth and nail to keep that shit in. So, here we go. I want to hear about this guy not showing up for subpoena, though. Because I have been this attorney before defending a guy who's not there. And you're like, well, Judge, funny story. So, let's hear about this.
And try to
Hear what he's saying. Thank you.
either try to lift that microphone up and speak in the jury box or make your way over to the podium or table. Sorry.
Is that any better?
All right. And no, that was authority provided by Mr. Sadow over our morning recess. And I think that was indicated to go more towards a potential crime fraud argument. I don't think we've really gotten there yet.
It's not crime fraud per se. It's the same notion. It's fraud on the court, different proposition.
Okay.
But yes, and to attorney-client privilege waiver,
Right.
1.6 confidential and secret.
The case that I had cited to this morning showing the distinction between the two was tenant healthcare. So that's where we were on the threshold issue. Did you have something that you wanted to
So I don't know what
address on
this is about yet.
Review that, Your Honor. I was unfortunately.
that? All right, Mr. Ward, you're co-counsel with Mr. Bradley?
I'm not here that.
Remind me why you are here.
I'm not here just assisting. You're just assisting.
That makes you co-counsel. You're assisting him.
Okay, so you are co-counsel on this.
morning.
I'm co-counsel, but I didn't fucking do anything, Judge, is the answer you should provide. That's why he's trying to say I'm assisting. I'm not co-counsel. Oh, wait, I was supposed to be doing work? That's what he's trying to do there. It's like, look, Judge, I didn't sign up to take this test. I'm not in this class. I have been that guy too before. Wait, fuck, you wanted me to do something? Whoops.
Everybody knew. That's what I was doing.
Okay.
Oh, this is, Judge is saying it's 10.
Right. And the citation for that is 273 Georgia 206.
Judge,
And I'll give you time to review that. In the meantime, what other things did you want me to know? And perhaps at this point, we just take our break now, unless you also want to talk about the questionings that are provided by Ms. Merchant, seeing if there's anything we can achieve.
so that I can be clear, it is apparent that at this point, we're going to go into whether or not 1.6 provides privilege for Mr. Wade, even though he has specifically stated that he does not waive that privilege. Therefore, it would be incumbent upon the court to issue an order to demand that Mr. Bradley, over and above the privilege afforded in.
Oh, this is his former partner who like represented him. Ooh, we got a privilege issue. 1.6. Oh God. I heard this like was a big problem. Oh God. This is like, you guys don't get it. This is like the shit you learn about in law school that never goes down. Like this is like an ethics problem. We never get to see this. This is cool. You guys say I'm being a dork and I don't care.
1.6 is required to testify. Is that correct?
That's right. That's what we covered this morning.
And so I would ask the court, is the court then going to travel under the fraud exception?
We haven't quite gotten there. We haven't decided whether attorney-client privilege applies. I think there are some other things that we would have to do to, I think we got held up yesterday on 1.6. As I understood it, I was waiting to hear from you whether we are now beyond that. And then if we're in the land of attorney-client privilege and only attorney-client privilege, so Rule 505, then I think Mr. Sadal has some arguments on crime fraud. And I think there's also just the general arguments of, does it exist? Were certain statements in furtherance? Does Mr. Bradley have any knowledge independent of those?
Certainly.
Right.
And in order to keep the court abreast, yes, we are still traveling under, there should be a privilege afforded to Mr. Wade under 1.6. And we are aware of how they will try to convince the court that that should be overcome. So hopefully I can read this case in less than 5 minutes.
All right, that's fine. Anything, I guess, as he reads that, let's do this. Assuming we do get beyond 1.6, if you can work with me here, anything we want to add to that?
I'm afraid I would have to hear what the arguments were that got us past 1.6.
Okay.
Judge, I'm not here to insinuate to the court that we would do something else. I don't
Okay.
know.
But there was a line of questioning that Ms. Merchant decided to write out and share with the parties. Were there any initial thoughts, comments, reactions to that? Again, just trying to make sure we make the best use of Mr. Bradley's time once he arrives.
Your Honor, I just want to say that that might just reiterate that my client is not waived attorney-client privilege. The questions that we reviewed this morning, Mr. Bradley is not able to testify about anything relating to Wade's marriage or dating history after December 2018. That's going to be the operative date. Nor does any of the questions.
Wait, hold on.
To any external.
He said my client, he's the DA's office, I thought. I thought these two were both DA's office attorneys. How the fuck does he get to say my client? Your client's the state of Georgia. Unless it's been Wade's attorney the whole time. I just didn't. I thought they were both DAs.
Knowledge or sources. Anything he will say would be derived entirely from.
Never mind. That's the guy. Those two are the DAs. That's his attorney. Okay, I got it.
Client, so we just want to renew our objection.
Okay. So certainly the assertion of the privilege is confirmed and for the record. And I think, again, this is where we got held up yesterday is that I know you're asserting that certain answers to these questions would be covered by privilege. I think there's still some boxes we would need to check before we can confirm that. And we'd have to check those boxes with Mr. Bradley before we can get there. Okay. If there's nothing else, then let's break until 1 o'clock. All right. Thank you all.
Okay, well, well, huh. All right, guys, don't spoil this shit for me. I want to see this. Did I get to the part? Did I? And see, here's the thing. All these attorneys know each other. These are going to definitely be some of the higher end attorneys in the city and the region. So yeah, all these guys know each other. That's not uncommon. I mean, your guys are all in the bar, you know, like you may have worked together in a firm or in an office together. So no, like everybody knows each other. That's what happens. But yeah, does he Wade burst in and naked and helicopters his dick around? Oh, don't tell me. That's gonna be great. All right. So we're gonna do some time travel here. Hold on here. It's about to get lit. We're 3 hours in. Hold on. We need a Clyde welfare check. Hold on. Clyde, come here, Bob. Come here, buddy. And he'll come in a second. Hold on. Hey, Clyde, you want a treat? Come here, bud. Come here. Come on, bud. Up. Ah. He's alive. There you go. Hold on. Brandon, because Brandon asked. We'll start here. For $9.99, Brandon, thank you. It's about to get lit in 3 hours. Clyde welfare check. Hi, Clyde. Hi, Bubba. You want to talk on the microphone? Or no? You want to give me some kisses? Hold on. Naza Pena, Namami Tsumama, Sum, Hey Yamane. All right, buddy. Where are you shaking, bud? Bubber. All right, I'm gonna let you go, buddy. I love you, Clyde. You're such a good boy. Thank you, Brandon. Referred convict sent me a screenshot of the judge on DMs. Yes. Oh my God, this is so funny, and I'm gonna share this. As Fanny's dad starts talking about what happened, here's the judge, just like, oh, he's just like, sons of bitches. You know, I wasn't joking earlier today. Judge McAfee's like, why does this have to be my case? I want to golf and do all the shit other judges get to do, but I have to listen to these dumb fucks. So, Jim is a member for 12 months. Jim, thank you so much. I appreciate that support. It's cool seeing, you know, numbers like that. Almost a sleaze is accusing Bradley of grape. I don't know what that's about, so let's try not to spoil. John Smith for $2 says it's the cash story. Make note, it's coming up. Oh, yeah, that was definitely interesting. Yeah, you're right. I'm losing my mind over this. This is fucking ridiculous. Unhung Hero for $2 says, "Oh, I'm gonna come. If you want to come tonight, you can. It's okay, baby. I'll let you come. You've been a good boy." Unhung Hero says for $2, the shiz apple doesn't fall from the shiz tree. Yes. Yes. And Parallax has been a member for 15 months. So cool. Like I said, these things are it's flat. It means some, like, I don't think you guys get it. It's really cool seeing it. It gets you in the feels. Says off topic, but Boss Man Jack got his bong and gold coin. It's all about those milestones, folks. Maybe for Boss Man Jack, one of those milestones is going to be sobriety in the future. We'll never know. Let me see, though, where you guys are at. Clyde got misinformed. I didn't give him his treat. Well, he'll be all right. He's probably getting a treat from 2.0 right now. Art is a new member. Thank you. So YouTube randomly cancel all my memberships. I don't know. YouTube screws with everything. My dog's whimpering after hearing treat. I am so sorry, Slap. Am I allowed to appropriate that song? Well, how do you know what? I mean, we all come from Africa's our motherland. It's the cradle of mankind, isn't it? and like the Olduvai Gorge out in Ethiopia. Isn't that where we started figuring out how to do shit as monkeys? I mean, so we're all African technically, and to be fair, I have Sicilian ancestry, and there's a reason why the wops in the south of Italy are a little darker than the wops in the north of Italy. Has something to do with the Muslims coming through, the Berbers and the Moors. The Muslims burned a lot of coal. I'll put it like that in southern Italy. You'd think the Industrial Revolution was going on. Duncan Felony says, "Oh my God, he's so cute." Well, he is. Say, my cat heard treat. Thanks, Sean. Yeah, well, he's a good boy. He's a heckin' good boy. Except when the cops get mad at him. Yeah, hold on. Tilly's saying, hold on, yes. Alexa, set reminder to masturbate at 3 a.m. Aunt Jemima says, as a black person, I give you all the N-word pass. Aw. See, chat, this is about its community. It's like family. All right, we're going to get going here. It feels like White Claw emojis are in order. Well, it's 8 o'clock on a Friday night, man. Just saying, you know what's up, Brandon. You know how the world works. All right, but here we go, guys. Let's do some time travel here because I think we're done. So, whoop, 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 whoop. They're using Pelican cases. Ooh, fancy. They're using Pelican cases, and I know what those are. FedEx secure deliveries. I've seen those tags before when I worked at FedEx. Uh-oh. Here we go. Yahoo! So yeah, okay, guys. I didn't realize this, but apparently the state already declined to release Fani and declined to testify, have her a testimony, which I think is good because if the state went, then Ashley Merchant and Sato would get one more chance to hollow her out in court. And now that would have been, if they were going to wait the recaller, especially after Dad testifies, that's like your dad said you were there. Is he lying? Your dad said that. Is he lying? That would have been it. So, yeah, here we go.
Good afternoon, Mr. Bradley.
Good afternoon.
Before I begin, I wanted to ask you if you wanted to clarify any of your statements that you made yesterday.
Go ahead and begin.
I wanted to ask if you wanted to clarify any of your statements that you made yesterday.
Go ahead and ask whatever you're going to ask, Ms. Merchant.
You initially became involved in this matter because you called me. Right?
Absolutely not.
I didn't call you.
No, it was through a third party.
You called me after you read an article and I don't even know where it was. I found one in the Washington Examiner.
I've got an objection. Can we approach the bench?
Okay.
Well.
Well, I can alert the court broadly to my concerns. This witness, it appears from the questions that Ms. Merchant had proposed, don't differentiate between what I'm considering three kind of buckets of information that this witness might have. One is communication derived from his representation of Mr. Wade.
This is Wade's former partner. Now, I think did he testify yesterday? He had something he said. Terrence Bradley. I mean, he was there yesterday morning, so he was the first guy up. And am I wrong about that? Because I didn't get to see him first, so I don't know what happened with him ultimately. Yeah, he was the first on the stand. He was the unofficial partner. Yeah, they don't have the official partner. He was the divorce counsel previously. Yeah, this gets messy, and that's the problem. And this is the issue. There's so many objections, and they moved on. Yeah, and this is the problem when you like get involved like this, and it just this crap happens. Totally happens like this. This is a mess. Since I honorably actually signed up. Well, the issue is apparently you can only use like one email, and I switched everything around, Brandon. So I switched it all to my potentially criminal at Gmail thing, and the bank hadn't caught on yet, so I had to fix that. Okay, so Debbie's saying you testified and claimed privilege on everything. Ooh. Ooh. Ooh, okay. Okay. Ooh. That so they recalled him now that they've had a chance to hash stuff out. Okay, but it sounds like that has not been settled. He didn't show up this morning. He said he'd be at the doctor. Yeah. No, I get that. He's the guy who wasn't there yet. Yes, Island, yes. I know there's no official partnership, but they're calling themselves partners. So, yeah. Slap says, why does it have RICO all over it? Why does it have mail fraud, wire fraud, corruption, bribery? Like, there's all kinds of cases right here. So, let's go. Let's go, chat. Let's go.
Second is any information that he might have from personal knowledge. The third category, which I believe is the substance of what Ms. Merchant wants to go into, is information not derived from personal observation, not derived from communication with Mr. Wade, his client, but gossip, secondhand, thirdhand, speculative things. Ms. Merchant's questions don't differentiate those categories of information. And I'm concerned about the questions being proposed without that qualification so that Mr. Bradley doesn't know when to invoke a privilege. I think the testimony yesterday was he didn't have any personal knowledge of any of this. That was my understanding of the testimony. I believe that was Mr. Bradley's sworn testimony yesterday. And my concern is that the gossip part, the unsourced hearsay, is where we're going to get to really fast.
Sure. And I think that's a fair point. I think she's following the script that she already provided you. So we have more than enough notice of when that might be coming. I think.
And here's the thing. I'm worried he's going to invoke privilege or we're going to run into it. Then let him invoke it. It's just like if somebody's going to invoke the fifth, like in the Jennifer Crumley trial. Oh, well, if we bring him in, he's going to say the fifth. Fine. He says it. You have to make him do it. We're not just going to guess it's going to happen. So, this is just nonsense to me at this. Well, I'm worried something's going to happen. Too fucking bad. Deal with it. So, yeah, if they've got a script, follow the script and deal with it.
The second she asks a question that you think might weigh into that, make the objection, and we can rephrase if necessary. All right, Ms. Merchant, you can re-ask that last question.
Read an article that was on September 11th discussing how much you and Mr. Wade were handling me, correct?
That is correct.
And you called me that same day and left me a voicemail on my cell phone asking me to call you back.
I do not recall that, but I do not recall that.
You don't recall that?
I do not.
So it's possible that happened.
I do not recall calling you after the article came out. I was shown the article, but I do not recall calling you after the article.
Can you tell us your phone number?
It's 334-717.
Wait, hold up. Why is that relevant, Ms. Merchant?
Because I need to establish that his phone number is the one that all of the texts that he had with me.
Can you just ask him if he has texted you at some point? We can stipulate that as a matter of record. We don't need that on the record.
Okay, we don't have to put it in the record. How about this? Can I show him a copy of his what he saved in my
Sure.
Okay, I'll just do that. May I approach Judge?
You may.
Take a look at that and just verify if that's your number and your cell phone.
That is my number and my cell phone.
Okay, and is that also your email address?
That is my email address.
Okay, great. Thank you. And I'll keep that separate, Judge.
You see, Michelle, that's the sauce, though.
Redacted.
That's the juice. I gotta see that.
So after whether or not you left a message on my voicemail, The next day, we were all in court in front of Judge Harris on September 12th, 2023. And do you recall that?
I do recall being in Judge Harris. Yes, I do.
And
Chris, I am so sorry. My bad.
And your attorney, BC Chopra, was there, and I was there, and another attorney, Burt Cohen, were there, correct?
Those people were there at the time. BC was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But BC Chopra was there.
I'm going to object to the relevance of this.
Ms. Cross, as I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay. All right. Ms. Merchant.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Bert about a case, and BC was there to speak to Bert about a case. Yes, I think I do recall that happening, but I can't recall who else was there. It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in the front of the building.
Correct.
And it's not a public room, it's sort of like a jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Bert there, but people were coming in and out of the courtroom, so I cannot sit here and accurately say that somebody else wasn't there at the time. Correct.
And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
And then based on our conversation, I told you I was going to do some additional open records requests.
Which open records request are you talking about?
Just any. Just asking if we talked about that I was going to be doing some follow-up to Fulton County. That's right.
Because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade, and all of the access that you all have to the office.
Yes, and you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office, and leave out.
Right. Okay. And so we talked about that badge access card and asking for that, and I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text, and when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone?
Not at all. On September 14th, at 6:38 p.m.
And what day was this?
It was September 14th.
September 14th, correct.
And I sent you a screenshot of a Fulton County open records request I did.
Yes, and I said, wow.
And then, and then we continued to text.
Wait.
Okay.
And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond. You sent another text about some other badges, and with a circle around it, and I did not
I
respond.
object, Your Honor.
Okay.
I'm sorry, thank you.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you, sir.
actually, I have an additional.
Okay.
Thing I want to raise. Ms. Merchant provided some text messages that she let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange, as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this it is true, accurate, and complete? And perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object. I understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've identified.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made and line with the outline you provided me, and I think we're on track with that. Were you planning to tender these text messages?
I was planning on discussing them with him. Now, if yesterday he said we didn't text about this case, so if that was his testimony again today, then yes, I will at least show them to him to refresh his recollection or to impeach him. But their first part of their argument is foundation. Is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots, and so I took screenshots. If there's a way to submit my entire text history for Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to just lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So.
Well, I'm not sure what their objection is. So I asked him about one question and he read
Sure.
off several other.
Why don't we just go with your next question and we'll see where we go from there.
All right, let's move on.
But, so.
Mr. Bradley, why don't you wait for her to ask a question?
And I understand that, Judge, and I'm not.
Well,
trying to
apparently you
dis-
don't, sir. Wait for her to ask a question and you'll have a chance.
Lawyers are the worst
So I think
witnesses.
the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about though.
Some text did, yes.
Yes, okay. And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
You don't recall that? Okay. And do you recall the following Monday?
Your Honor, I appreciate the question as it is on the form. And if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer the source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that, then I do have an objection to the question.
Okay.
That's not a valid objection grounds.
Why is it that we're not allowed to ask?
It's like she's asserting privilege for him.
The question is asked. There's an objection made either by the state or the lawyers for this particular witness. It appears that what the state would like to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that when we are obviously in the same position to say to them, tell us every question you're going to ask first. I realize it's a privilege, but that can be the questions asked, state objects, chauffeur objects, in the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial. I don't think that, I'm just suggesting.
Sure.
I don't think
So, Mr. Stan, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say. And that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come.
Yeah, this is just not like it's almost like they're arguing privilege for him, too. On top of that, it's like that's not their privileges to argue. Yeah, I think Merchant's doing it the right way. I mean, there's only so many ways you can argue this. And also, let's go, Brandon. Got your Zelle. We'll get that going for you. We'll finish this up first, and then we'll get to the claw.
But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that you wouldn't be in a situation where we were objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that objection to question 18. I did give the state copies of it as well, trying to be completely transparent. I also, I have to establish that his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that was said under oath yesterday. And that I did not get this information, and so I have a right to
which I've already said we can do and we can go over. But and we've already started doing that. But the next question, as you plan to ask it, may presuppose again some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
No. Well, I don't believe so. No. I mean, if we're going to talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege. If we're going to talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very carefully to craft something to avoid that. But I'm happy to just ask outright the question.
Right. I don't see a way around that, Ms. Cross.
I understand, Your Honor. I'm going to do whatever you tell me to do. The problem in the context that Ms. Merchant is posing the questions is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels that she needs to establish there was contact and communication, then I don't have an objection to that. However, number one, the text message that exchange that Ms. Merchant gave me is apparently not complete. And so I don't know, without making her a witness, how the state can, and we're entitled to, if she's been referring text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone and that's what he's got. He is under no obligation. Ms. Merchant provided this to us and I appreciate it. But I can't tell as I'm sitting here to object to an incomplete or an inaccurate recitation if what she gave me isn't complete.
This is one of the dangers when you're an attorney and you can say, well, I know this or I know that. Yes, Ashley Merchant that said though, she's very good. She is she's running a very fine line of becoming a fact witness herself. But she's staying outside of it because she's saying, I talked to you. Does this sound right? What did you do? So she's doing the right things, but yes, this is very delicate. This is easy to fuck up. Fani would not get this right.
So a couple things come to mind. One would be that anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that if you decided to do that. The other is
I understand
as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in.
Thank you, Hell. I appreciate it.
He either takes her answer or he doesn't. That's how it works. So I don't see the foundation issue or the completeness issue really playing into it as it comes to impeachment.
Okay. And if they asked me for the relevant screenshots, I told them, he doesn't have an iPhone, I can't download the entire text message history. I told him they could go through my phone. Like, I'm hiding something.
All right, Ms. Merchant. I think.
Wow, she's like, I'll let you look through my phone. This is a very fucking confident person here. I don't know what she's got in her hands, chat. Those texts have to be good, but she's holding a fucking heater of a hand. If she's standing there saying, I'll let you look through the motherfucking phone here, that's how confident I am. Woo. Damn. This is going to be good.
At this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes. So proceed.
I asked you where I could get an affidavit from about the affair, and you responded no because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I don't
Do you have your text if you need to refresh your memory? September 18th at 3:11 p.m. in Houston.
Can you repeat the question?
The question is, did I text you asking you if you knew who I could get an affidavit from about the affair? And you responded, no, no one would freely burn that bridge.
Yes, I do see that.
Then I asked you if Chris Campbell knew, correct?
No, you asked me if under oath he would testify.
Your Honor, again, I'm gonna object to the source of the witness's information about that, whether that's firsthand information or not, and Mr. Campbell, of course, has a privilege too.
Well, since Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
I'm just, it's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking. I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And it's not clear in the text exchange what the source of Mr. Bradley's information that he's providing is. And so that is, I'm struggling,
Sure.
and I know everybody else is too.
And again, I think you're focusing more on the merits than the impeachment value, right? If the sole purpose this is coming in is on those grounds, then you being able to match them up word for word, I don't see that as being a necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions, and you could always come back to that if somehow he has made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with a business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
This isn't a privilege issue, this one. It's not a privilege problem. Thing I'm gonna say here, chat. Normally the state would be screaming and crying about. Also, I want to say Brandon did do $100 Zelle, so I got to square up on that. I'm waiting on my clause, but they're not fighting to see his phone. Hold on one second. Oh. Okay, guys, so where are we at now? The state's like, well, we haven't seen that phone. Here's the thing. The Fani Willis and those guys from the DA's office, they don't want to see that phone because they know what's going to be on there. They know it's bad. So he's talking about, well, it's a phone I haven't seen. I don't know if it's true or not. They know it's on the phone. I guarantee you, they've talked to Fani. They've talked to Wade. What the fuck is out there? Yeah, they are in big trouble, and there's a reason why. Like I said, guys, remember I've told you this before. It's not what somebody says or does; it's what they don't do that tells you a lot about their position and their posture. Notice what these attorneys are saying. They're talking about, well, I haven't seen it. Okay, well, notice they're not screaming like, Your Honor, I need to see these texts right now. No, they don't have that. They don't have that. Well, they don't want that. Is the bigger thing. So I'm just saying, like, that's, you can tell they don't want that. And they're okay, like, because this, if this, like, in most settings, this would never fly. The witness is up there scrolling along on something that we don't all actually know, because technically Ashley might have, like, his text with her fine, but he could be scrolling through all kinds of stuff we don't know about. But yeah, he's stalling. But it's just something to think about. Something to think about. Kitchen Knife Rescue saying, "Oh, look, it's Leo. How you doing, Rescue? Hope you're grinding away tonight." So, but yeah, guys, and this is the thing. Yes, Merchant knows them all. This is all that. That's what happens. These are all the high-powered attorneys. And Ashley Merchant's a fucking headhunter. She's collected scalps tonight, and she's a true mercenary. She works for who's paying. Also, yes, Hella sent a sticker. Yes, tomorrow is birthday for future Mrs. Martin 2.0. You'd like to reach out and tell her happy birthday. I'm sure she would appreciate it. And let's go, Brandon, for $4.99 says, remember when they asked for sanctions because they never spoke? How are they not defrauding the court? I mean, like, how are the attorneys not sanctioned? Because they have enough plausible. They are doing this right. They have enough plausible deniability. I'd like to think they're smart, but Fani hired them, so they might be blithering fucking retards. But I'd like to think they've got enough plausible deniability they can hide here. But anyways, 383 people, guys, please crush that like button. I would appreciate it. And leave a comment even if it's to say I suck. That drives the algorithm. And Brandon, for you, buddy, well, it's White Claw time. So here we go.
So what I have is a text message from you saying, "Oh my God, Nathan took Fani on a trip to Napa and paid for it with his firm."
Okay, continue reading.
And you said, "Is he that dumb?"
Mm-hmm.
And I said, "Wow."
This is them talking as friends because they know each other.
"I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
"Then I will call you as soon as I land in Wow."
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
Oh, he's the source.
Okay, so I don't have that, and I can show my phone, but I don't have that in my phone.
So the question is just, do you recall?
I do not recall.
Communicating that to
I do not recall.
All right.
Do you recall telling me that it was when she had to move her daughter a trip to California?
I do not recall that.
And Judge, may I approach the witness?
You may.
Thank you. It's in the packet I gave you. Oh, I see it. Take a look at that, see if that refreshes your memory.
Yes, I see this.
Okay. Does that look like, does it refresh your memory?
It does not. I mean, I see what's on the text chain.
Box
but,
raid. What the hell's going on over at Twitch? Holy cow, chat.
You said this happened January 5th?
I can tell you exactly when it happened. Because there's no date and time stamp on that. Let's see.
Okay, from Kirsch. Oh, shit. Thank you, guys. Thank you. Not Cal Fox. Hi, guys. Thanks, guys. I appreciate it. 455 people over there. Holy cow. Okay. So I'm going to pause real quick because we apparently got a gajillion people over here from, yeah, it's Kershaw Boomer. I got it. It took me a second. So you guys are coming into the middle of the disqualification hearing about Fani Willis and Nathan Wade, the two attorneys basically leading the RICO case against former President Trump. Now, we've learned through Nathan Wade and Fani Willis, who testified yesterday, that they are dumber than doornails. And Fanny's dad testified this morning, and he's not much brighter. And now this is Nathan Wade's former law partner in quotation marks. They weren't really good. Kirsch. Oh, Kirsch. Hey, how you doing, girl? Hi. Said I read up on all that stuff. I'm going to get back to you. It's very interesting. So, this is his former law partner, and they did not have a good relationship. Things have kind of crashed and burned. So, well, Fanny wore the dress backwards so she could put that tie over her fupa. That's why she did it, chat. She was protecting the fupa. So this guy is an attorney who represented Wade at some point. So there's attorney-client privilege issues, but there's problems with attorney-client privilege. There's ways you can break it. One of the ways you can break it is if you were a conspirator. It's called the crime fraud exception. If you were engaged in a crime with your attorney, that no longer insulates your communications. So there's multiple ways you can break it, and I have a feeling that's the route they're going to go. So there's a, it's, yeah, so here we go, guys. So is this going to work, though? We're going to go here, okay? And if you guys aren't aware, I know some of you guys, Kirsch people, attorney-client privilege is like one of the most sacrosanct things. The confidentiality I have with anybody that that talks to me, whether they retain me, I talk to them in a consultation. So, like, if you come to me a consultation and you talk to me or you call me on the phone saying, hey, I got some questions, I take that to the grave unless you release me from it. I can't tell anybody about it. So right now, Crawdad, if you were to call me like, hey, Sean, I got this going on, nobody ever gets to know unless you give me a written permission slip saying I can tell the world. If you hire me, well, definitely there's attorney-client relationship. I don't know how this ends. No, guys, I was well, I had a case for this morning, and my client didn't show up, and then I had to get work done. I was on with Eric Hundley for a little bit. Then I was getting an appeal set up, and then I had to go to the eye doctor. So no, I don't know how this ends. I don't know how this ends. But yes, attorney-client privilege is one of those sacrosanct things. That is Rule 1.6 of the code of the Model Code of Conduct for attorneys. And pretty much every state, your rules of ethics, if you Google Rule 1.6, it's confidentiality. And it's paramount. And it must be protected. This is one of the things you get disbarred for is spilling tea. Stealing money, yes. Spilling tea is the other one. Those are the two cardinal sins. So it's stronger than doctor-patient confidentiality. Yeah, it is. Yeah. This is huge. Tilly says, do we get lawyer chat privileges? No, you don't. So we're going to keep going here. This is going to get going. All right, guys, let's do this.
I believe it was January 5th.
Judge, I just want to, on behalf of Mr. Wade, just to review the objection again. We still don't.
To which question?
The current question, we still don't know the source of this information, whether it was privileged or how we obtained images.
I'm wondering now if there's a timeliness issue on your objection, since he said he doesn't recall.
Right,
So
he just gave the date. He didn't start answering.
Well, his answer was he doesn't recall, and his memory has not been refreshed. So I think it's time for the next question.
May I purchase witness?
Okay.
Can I see what you're purchasing witness?
It's not HIPAA, but I get it.
So is this the complete text chain?
Yeah, it's the complete text chain. While they're looking at that, can I just ask you, did you delete any text messages?
I have several messages in the phone with you.
I can talk to you about that.
I've never deleted. I mean, there are messages about family. And
should be an email in the description link below.
Things like that. You asked me to be on some panel.
Yes.
And so
Sorry. I wanted to make sure I got the answer to the thing right here. Speak Life, send me there should be an email below, potentiallycriminal@gmail.com. And I can talk to you about that privately if you're serious.
No, I think it's complete, but
Well, no, my question was, did you delete
no,
anything?
I haven't deleted anything.
Okay.
I have not.
And I offered them to look through my phone earlier if they are welcome to.
You never provided it to us.
Said you would.
Physical phone, you never provided it to us.
It's the only phone I have, Judge.
I understand and I don't want to keep popping up, but my concern, of course, is that these exchanges are just two lawyers gossiping about information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching, the contact is impeaching. So
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand an object to refresh his recollection again. So we'll see where we get with that.
And I don't have any way to download it because I'm not.
May I, one
Mr. Shada.
the court is a trier of fact. You're going to be able to determine whether something that has come in, if you choose to, is hearsay, whether it's admissible, whether it's relevant.
He's the
whether
gatekeeper.
it's impeachment. You're in a position that if it all comes in, but you reserve the right, or all parties reserve the right to object, we can deal with it. This is not a jury. We don't have to worry about a jury hearing something that it will no longer consider. All we're doing
Exactly. That's why if in these situations, it's why you let Fani act like an asshole yesterday. He's the trier. He's the fact finder right now in this hearing. There's no jury. The rules, like if you try to object to evidentiary issues, he'll throw out what he needs to and what he doesn't. This is basically a bench trial. So yes, this Sato's making the right argument. You're going to make the call. We know you're not an idiot, so just let us get it out there. You discern the fact, what matters, or what's relevant. He's finally cut through it, cut through the bullshit, and he's doing it.
Now, with all due respect, and I understand there's a process. The state doesn't
I'm
want
roboting,
something
damn
to
it.
be heard.
I object to that.
They've repeatedly attempted to stop questioning. You're honored to
Is
hear
that
it
better?
all and then decide what is and is not relevant or admissible.
Is this better now?
We don't have to go through every single one of these. The only time you have to go through this is if it is in fact a communication and it's a privileged communication, and an argument has to be made at that point as to whether or not it should be elicited or it is subject to being stated in open court. Otherwise, all of this can come to the court, and the court can then decide how it wants to treat it. That's the suggestion.
I appreciate that, Mr. Sayyam. I think it's certainly accurate that we could have an approach where if it's a close toss-up on an evidentiary question, we can have it all come in and sort it out later on the record. I don't think we've quite reached the point where I need to do that. I think we still have time to get into these, and it'd be my preference to keep the record as clean as possible and without questionable evidentiary issues. But we may get to that point. So the question from Ms. Merchant was to approach the witness and with an object to see if that would refresh his recollection to the last question asked.
Yes.
All right.
Now, I'm sorry, the state scrolled through it, so it's not right there again.
No, we didn't move it. Can't move it.
No, I mean, like, it was on the screen.
Guys, if you're over on Twitch, please give me a follow if you don't mind. I would appreciate it. If you guys are here on YouTube and you're new, please give me a like. That would be very much appreciated. So, okay, this is some dead air here. Jesus. This is some dead air, folks. I'm going to try to scoot ahead here. This guy, look at him. He is, you want to talk about people who are not thrilled to be somewhere? this man, like, I don't know what all he did, and I don't know what's about to happen, but this man's got the look on his face of like he's staring down the barrel of a couple different guns depending on the route he goes here. Like, I bet one of them's criminal, and I bet one of them's barred, like, legal discipline from the state governing board. So he looks like he's kind of backed into a corner, and he knows it, just from looking at him, to me at least. Oh, there we go.
Now I can't find it. I'm going to move on to the next question that I actually can't find, and then I'll find that and come back to it. I sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met, or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Okay, so I answered to Bradley just a second. Mr. Chopra has risen.
All right, Your Honor, I do have one purpose here, and that purpose has now been met. Any information that Mr. Bradley may possess would in fact have come from his representation of Mr. Wade. This falls within the purview of his divorce proceedings, which, as we testified earlier, commenced in December of 2018. There's no pierce or shield associated with it, and so we would say that under Rule 1.6, we should not be compelled to give any further information.
Okay, and as we discussed about before the break, Mr. Chopra, if I ruled earlier this morning that this witness is going to be directed
Here we go.
to respond to any question to the extent it falls outside of attorney-client privilege and only attorney-client privilege, meaning 1.6 is not going to bar his testimony in this case. What would be your response then?
Then Mr. Bradley would have to consistently assess on his own, unless I'm jumping up and objecting for him, whether or not this came within his knowledge based on his representation. And I can say, based on the phrasing of the question from Ms. Merchant, it would in fact come within information obtained from his partner client at the time associated with the activity in question.
All right, Mr. Evans, same issue.
That's a good
I just want to
argument.
reiterate that it's a compound question anyways, so it needs to be separated out, but it's still based, we just renew the objection that it's still based on gossip, either gossip or privileged communication. He doesn't ever cite the source of where any of this information is coming from, so I just wanted to make that objection.
Okay.
Judge, as far as privilege, any privilege objection, it's been waived, particularly for this issue because Mr. Wade
He did testify on this subject.
testified on this subject.
Well, he didn't testify as a communication with his attorney about any subject. He testified factually about what trips he took and events that occurred. He didn't testify, to my recollection, about any communication with his attorneys.
But he testified about the subject matter of the question that was just asked, which was when apparently they first met.
Furthermore, Judge, my client wasn't privy to that testimony. We have been under subpoena and therefore under the rules, so we do not know what was or was not testified to. Everything he says would be a violation of that privilege unless we know specifically what all has been waived.
Sure. Unless I make a finding that there was an express waiver on behalf of the client.
Yes.
Per question.
Okay. Sure. Got it.
And guys, I still don't know what's up with the microphone here. I'm going to turn it down, try to turn it back up, but if it's choppy or blowing, I don't know what the deal is. Yes, the only other way you can waive privilege is, like he said, Nathan Wade would have to come in and either he would do it on the record or he would have a signed release saying, I authorize Brandon up there to waive privilege and discuss what happened. Now, it becomes a sticky issue because is it part of the relationship as them being attorney and client, or bros working in a law firm? Hey, man, I'm drilling a new chick. I'm hauling her out on the weekends. Check it out. It's hard to tell where that came from, and that's a bit of an issue here. So
for this question, particularly, Judge, we would ask that you find that there has been a waiver of the attorney-client privilege because Mr. Wade testified to something directly different than what this witness, we believe, has heard.
Yes, Mr. Wade testified as to when they met. That is not the entire substance of the text message that Ms.
and began a romantic relationship.
Yes, he did not testify that they were serving as magistrate judges when they began a romantic relationship.
All
He
right.
testified differently.
Okay, Ms. Merchant, I think you're going to need to establish whether this witness ever gained that knowledge independently or during the course of a attorney-client relationship.
Did you have any, thinking back to the source of your knowledge, and let me just, before I do that, let me remind you of what is covered by attorney-client privilege. It's communications that relate to matters in which legal advice is sought, and communications that have been maintained in confidence, and no exceptions to the privilege. So it's communications that are in furtherance of legal advice.
I mean, technically, if you're telling your attorney, hey, I'm fucking another chick while you're getting a divorce going, that kind of can raise to the issue of, you know, how that figures in there. Just saying. Just saying. I mean, that's not an uncommon thing when you're doing a divorce case. Like, are you fucking anybody? That's a very common question. Like, is there a land? Are there land? Have you laid landmines out there that we might have to run through? So that's a very, I don't know. Fuck, if he's, then it becomes an issue is if he says anything, is Nathan Wade going to fucking pursue him with a grievance? I don't know. I am fucking giddy right now. Let's see what this does.
Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer.
Okay. Real quick, Brandon. Yeah, have you ever seen the prosecution fight so hard to obfuscate how you conceal facts? Yes. Every day. Every trial, they fight this hard. Yes, it happens all the time. All over America. But yes, I have. So here we go. We're going to rewind it just a hair.
That question.
Exceptions to the privilege. So it's communications that are in furtherance of legal advice. Your knowledge that their affair began, that their romantic relationship, began while they were both serving as municipal court judges. Is that from your personal information, your personal knowledge, or is that from?
I'm going to overrule that objection, Mr. Chopra. He can answer that question.
State that question again.
Your knowledge?
Is any knowledge, if any
knowledge of Nathan Wade and Fani Willis' relationship, romantic relationship beginning while they were both serving as judges, is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge, so I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier.
Yes, sir.
That it's a bit narrower than that.
Okay.
1.6 is.
I have no personal knowledge, Judge. I apologize.
Okay.
If you were,
that's not a problem. The issue is attorney-client privilege, and so whether what you learned, if anything, was during communications with the client.
It was.
Okay, Ms. Merchant.
and was it that any knowledge that you had as to the truth of that statement, was it told to you in furtherance of legal advice?
I'm going to object to it. If that statement is true,
That's all right.
and the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that, so could not testify.
Prior inconsistent statement, Judge. Do it all the time. That is what the state does
It's not a
regularly.
statement.
They bring in, it's a prior inconsistent statement of another witness, Judge. If Mr. Wade
Which other
testified,
witness?
I'm sorry.
Okay, Mr. Wade testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And so we haven't gotten over the privilege.
But you're not impeaching him with the privileged statement. Nathan Wade made a statement on the record. So you're not impeaching him with, you're impeaching him with Wade's prior statement. So you're not really impeaching him with the privileged statement. You're asking about the privileged statement and saying, well, Wade said this. Is that correct? I get where he's trying to get at, but this is a way you can get around. This is a way you can kind of get around it. Like, is this to your knowledge Correct. But I get what he's trying to do, and the judge is being very good about trying to protect attorney-client privilege. I get it. I get it. But it's like, a little bit frustrating here, bro dog.
The hurdle.
The privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies.
Okay, well, there we go. And here's the thing, if she could blow the door open with the fraud, then it all comes in. And he can't make any excuses. But, the judge is saying, okay, well, now you've given me the option, so tell me why it applies. So here we go. He's like, I'm losing all my hair, lady.
You can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
Which crime and or fraud was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For the crime fraud exception says the privilege doesn't apply if it's if the existence of it, essentially if he has to keep something secret to allow a fraud upon the court to continue. So we've got that. We've also got
no, it has to. The legal communications have to have done in furtherance of a crime or fraud. How has that been established?
Mm-hmm.
And what crime or fraud are we talking about?
We're talking about perjury, lying to the court.
In the affidavit filed last month.
Yes.
And so what have you done to link the communications that he made maybe, years ago to the affidavit filed last month?
The communications he made years ago, it's proof of the affidavit being incorrect, being false. He's given a prior inconsistency.
But the legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under.
If he had an affidavit wasn't even going to need to be filed until a month ago.
Right.
These communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
It's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that. When he waives the privilege, and he waived the privilege, he testified about this yesterday.
Okay, Ms. Cross.
I don't think that's even close to an accurate representation of what.
I get what she's trying to do here. Like, here's the thing. I totally get it. But yeah, I can't. I'm not buying that. Like, I'd buy that for $1. I get it. She's trying. She's John Coffey. She trying real hard, boss. But no, it's not enough. I get it. Yeah, there's no way to know that they would have known like they were intentionally engaging in fraud at that point. So, no, not yet. She might be able to dig it up later, but I'm not buying it right now. If I was the judge, I'd say no.
The law in this area is, and beyond the real kind of throwing out fraud and this and crimes, which what you have, Your Honor, is a conflict in the evidence at this point. I know which way the weight of the evidence appears to me, that that's going to be for the court to judge. But conflict in the evidence, that is not a crime. That is not a fraud. That is not a perjury. That's a conflict in the evidence for the court to decide.
So I agree with you there that you would have to first establish a crime or fraud occurred by preponderance. Got it. And anything else?
It's just that she can't, under the guise of impeachment of this witness, number one, establish that. Number two, the witness has already said he doesn't have any personal knowledge of that. And there is the kind of specificity that is required to lay the predicate for a crime fraud exception to the attorney-client privilege is nowhere close to being met here.
Okay. Anyone else want to be heard? Mr. Seda.
Yes, Your Honor. This is what I said to the court earlier. This is not crime fraud. The scenario in the case I said, you want me to cite it?
Go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And
Lucas County, Ohio, that's Toledo. I've been in that courthouse. I practiced there for many a year when I first got out of law school. So that's cool.
references. I'll make sure I get the right page here. Let's see. I think it's page 256. The point in the case, or the holding in the case, is if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship did not begin until 2022, that if there are attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that, here that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired, that if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date, and the attorney-client privilege under those circumstances where that material fact is pierced, and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds.
Okay. So because Wade is committing fraud on the court and he's using his attorney to run interference because he fed his attorney a bullshit story, or told his attorney the truth, then he came into court and fed a bullshit story, Wade sabotages his own privilege and he pierces it himself by engaging in one-man fraud because he defrauded the court. And when you defraud the court, that is one of the times where an attorney has to break, because that's a duty of candor issue there too. But to be fair, this attorney doesn't know what Wade said because he no longer represents Wade. So he didn't say anything to Wade before the hearing. Would he have a duty? He doesn't have an automatic, okay, because as an attorney, I have a duty of candor to the court. And if you commit fraud on the court, I'm allowed to break confidentiality to protect the court from the fraud. Except in this case, that guy's not representing Wade anymore, and he doesn't know what Wade said because he's being a good boy and not doing it. That Wade implodes his, he stabs, he pierces the veil on his own privilege. I like it. I don't think it's going to work, though, at all. And anyways, we're going back. I got to take the citation out because I want to read that real quick. Guys, we're actually going to look this fucking case up for 1 second here because we are a law channel here, and we're going to do some fucking lawyer shit here, okay? We're going to do some lawyer shit. All right? Brent says, both the attorney and Wade are committing fraud. I don't necessarily think so yet. You can't prove the attorney's committed fraud yet. Is he supporting fraud? I don't think so yet. I don't think so. Yeah, we're gonna go back. I want to hear this. We're gonna take the citation down.
Insurance company. What I said to the court earlier, this is not crime fraud. The scenario in the case, I said, you want me to sign it for the record?
Go for it.
Okay.
Hold on, Chad. I'm trying to get my case search engine up. Okay. Now, before you motherfuckers try to laugh at me, we use this because the State Bar Association provides for $13 a month, and if I need Lexis or Westlaw, I can get it for I can go and get it free when I need it. This does the job though because I know how to write and research. Okay, so cases out of Ohio. Here we go. What does he say? Okay, hold on here. Let's see if I can pull it up through Google better. Maybe that's not the right citation here. That's not right. I don't think he gave me the right citation. Hold on. Let's go back to this. Okay.
0
Here we go.
versus American Centennial Insurance Company et al. And it is at 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And
He said 812?
I'll make sure I get the right page here.
812. I can't find that.
Court of Common Pleas of Ohio. At 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County.
Okay, hold on, chat. I can't find this right now. No, it would be 812. It wouldn't be A12. It's a criminal court of common pleas pleading. No, because if it got in, that would have been some sort of this would have been some sort of it would have been an appellate pleading at the very least, maybe Supreme Court here. But hold on, I'm going to try the parties. Let me try the parties.
The scenario in the case I said, you want me to sign?
Go for it.
Okay. It's Owens Corning Fiberglass Corporation versus American Centennial Insurance Company et al. And it is at 660 Northeast 2nd, 812, out of the state of Ohio, Lucas County, Court of Common Pleas of Ohio. And it references, I'll make sure I get the right page here.
Okay. Court of Common Pleas, that's all right, here we go.
I think it's page 256. The point in the case, or the holding in the case, is if the party or witness chooses to testify falsely, and our position is that Mr. Wade testified falsely when he claimed the relationship would not begin until 2022, that if there are...
Okay, I found something, but I don't know if this is it. So this is Owens Corning Fiberglass versus American Centennial Insurance, Lucas County Court of Common Pleas, February 22nd, 1995. Okay. So, you know what? I have this citation. I can run this because I don't know how this was reported. I don't know how this guy found it because I can't get it to pull up. No, I think this is... Where the fuck did he find this? Priv. Yeah, I can't even get privilege to show up in here. I don't know if this is it. Okay. Let's talk about indemnification. Blah, 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 blah. Insurability of punitive damages. Okay. Yada, 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 yada. Okay. Bestis. Okay. Owens Corning. Inspector Tenant Loss. Guys, I don't think this is here. I don't know what the hell he cited, but I can't find it. Oh, you're saying 74 Ohio Miss 2nd 183? Okay, this is that. This is it then. We got it right, J-Rock. Okay, you and me are on the same path here. I don't see any issue about... No loss doctrine. Yeah, I don't see any. So, search for the case by name. Yeah, it is a real case. I do know that. All right. Damn it, YouTube. Hey, Jeff, if you want on, let me know, dude. J-Rock, I got that. Yeah, we're all set. Pull up Maverick. Yeah. Okay, I can't get it to pull up, but it is a real case. So, whatever. Let's go back to the attorney arguing it. Sorry, guys.
Attorney-client communications in which the same individual witness has told his attorney something contrary to that, inconsistent with that. Here, that the relationship, the personal romantic relationship between Mr. Wade and Ms. Willis began prior to November 1st of 2021, which would be the day that he was hired. That if that communication took place, that is the attorney communication, that the fraud upon the court is Mr. Wade lying under oath about the starting date and the attorney-client privilege under those circumstances where that material fact is pierced and the attorney may be forced to testify to the contrary or inconsistent statement so that the fraud on the court no longer holds. In our situation, that is precisely what we are trying to do. If this witness's testimony, again, and the court may have to hear some of this ex parte in camera to determine, but if this witness is able to testify that Mr. Wade told him, under whatever the circumstances may be, that the relationship with Fani Willis began before November 1st of 2021, then we know from what the witness has testified to Mr. Wade that he lied under oath to the court. And that.
Okay, guys, wait, I found it. I found what we're looking for. So it's a footnote in the opinion. So here we go. OCF is Owens Corning Fiberglass. They should be held for responsible by any alleged failure to disclose pertinent information to insurers. This argument is without merit. Principal is bound by the fraudulent representations and non-disclosures of its agent. Okay. And that's what they talked about DeSantis. Okay. And principal is liable for an agent's fraud even though the principal did not benefit. Okay. Both the agent and principal are liable for an agent's fraud. Yeah, I guess that's where we're getting at here because that's yeah, okay. I mean, I still get where they're going at with this. I will tell you the problem, it's reported. It's a reported decision, not unpublished. Unpublished is really bad. So it's published. That's like one check mark. Yay. Downside of this is from a judge, a county judge somewhere in Ohio. This isn't an appellate. This is not appellate. This is common pleas. So this is basic bitch, basic court of law. Okay. And what judge is this, by the way? Oh, Richard Knepper. Oh, Judge Knepper is I think the guy's dead. So nobody's ever heard of it. But this is probably the best they could find, which I'll give them credit for finding it because this is a needle in a haystack.
Fraud upon the court and the attorney-client communication in that specific matter is pierced and needs to go into the record. Now, how best to do that? The only way to do that, if it's not in writing, and apparently it's not, is for the court to hear.
Also, I'm sorry, everybody that left for that whole
what the communications were that are sought to be kept privileged. If the court deems that it is not inconsistent or contrary to what's testified, then you wouldn't pierce the privilege. If, on the other hand, this witness honestly, that is, now we're talking about Mr. Bradley, actually testifies to what he has told in text messages to Ms. Merchant on behalf of Mr. Roman, that he absolutely knows that the relationship started before November 1st of 2021, then he's testifying that his client took the stand and lied under oath and therefore did a fraud upon the court. So my request is, in this regard, the court's going to have to hear from counsel and that is the counsel for Mr. Bradley, and for Mr. Bradley to determine whether or not he actually said what he said to Ms. Merchant, and whether or not it was based on communications, whenever it took place with Mr. Wood.
All right, Mr. Sada, I understand. Thank you for clarifying your argument there. So I understand this fraud upon the cart theory. And what I've been going back and forth with Ms. Merchant on earlier was that, as I understood, crime fraud applied in Georgia was that the communications had to have been in furtherance of a crime. And to me, that presupposes the existence of a crime at the time, or the forming of one at the time of the communications. The theory you're putting forward is one where we go back in time and can reopen that box because it's now become relevant for something completely, potentially unconnected to the communications whatsoever. Is that fair?
That falsity has occurred now by the very person who is attempting to use the communications as a shield to protect his lives.
Okay.
And when I say crime fraud, it's a fraud waiver is what, and that's what Millich calls it is essentially. Millich says that it doesn't offend the privilege to ask an attorney to testify to matters already freely discussed by the attorney and a client at another hearing or proceeding. Allowing a client to selectively waive and reassert the privilege as tactics dictates.
So Sadow said it. He said it more elegantly than me. Yes, it wasn't a fraud then, but it's a fraud now. But that's what I was getting at earlier. Wade lied, and now he's trying to hide the lie behind privilege, and that's the fraud exception. And now his attorney has to clear up the fraud because his client is committing a fraud against the court. I don't know if he still has that same duty to correct, but that's another issue under 1.6.
Suggests that the client is using the privilege as a sword and not merely a shield.
So I think it was quite explicit that Mr. Wade never waived anything regarding to communications between him and Mr. Bradley. He was willing to discuss the subject matter, but he was never willing to get into communications that occurred between him and Mr. Bradley. So as to Mr. Sadow's point of this fraud upon the court theory, my question was going to be, has it ever been applied in Georgia?
The answer to that is it's not appears to have been applied in Georgia. I cannot find a case in which it has been applied. The cases that I have, case that I gave you plus the cases cited in there are the only thing I've been able to locate. Although I think that the bar rules, we're going to go back to those, and I don't have it in front of me, that a lawyer should not allow his client to commit a fraud upon the court. And I think that, along with this, gives the court the discretion to do that. And the only way to make the record, even if the court suggests that this is the law that the court should apply, but even if the court disagrees, there's no way for there to be a record about it unless Your Honor does an ex parte in camera to determine the nature of the privilege, which of course Your Honor knows from earlier days is how judges can do it with the Fifth Amendment privilege. They can do it with any privilege as long as it's ex parte in camera. So what I'm asking the court to do, because when I get up, I'm going to ask you the record. I'm not going to go through this that's going on now, to find out whether or not Mr. Wade has ever told Mr. Bradley, in his capacity as his attorney or otherwise, that the relationship started earlier than what Mr. Wade testified to.
All right, understood. So the big takeaway I'm hearing from that, Mr. Sadow, is that once again, we're hearing the words a matter of first impression here. Noted. Mr. Gillen.
Yeah, very quickly, Your Honor. Number one.
This whole fucking thing's a first impression.
Now he's claiming, which he certainly did not assert when he was communicating a text with his birth.
Sure, but do we have any indication Mr. Wade didn't allow him to communicate by that text?
Well, we know what he did. We know what he did.
So how is that implied?
I would assume that as the attorney, that he would know whether or not he should protect a communication.
That's a pretty big assumption, right?
Not all communications are protected, number one. Number two, let's not forget.
That's an assumption. He has a duty imposed under the rules of professional conduct. Wade said X, Y, and Z. Is that true? On the record, your client said blah, 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 blah. Is that correct? You know, there's ways they can get that in. So it's not an assumption. It's his fucking duty under the rules. I mean, you are trying way too fucking hard for the state here, man. Come on, Judge. Also, guys, if you didn't know, this dude right here, the bald guy, that is Trump's attorney. This is the pipe hitter Trump got. He finally picked a good fucking lawyer, chat. A good one.
How we started on this journey with the state getting up and making very serious allegations against Ms. Merchant, asking for sanctions, saying all of her representations were inaccurate. And now they are doing whatever they can to block access to that information, which shows exactly what she said was exactly the truth. What they're trying to do is they're trying to say to the court, the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you what he knows. Because what he knows is that this relationship is based upon what we see from the text and what we've seen in the context, which show that the relationship started before November 2021.
Brimstone, you're correct. I can't put a client on the stand knowing they commit perjury. But this is the issue of my former client is now committing perjury. Do I have an automatic obligation under Rule 1.6 to prevent that fraud from happening? And that becomes an issue because it's a former client. I think you're kind of stuck in an issue there of how like your duty going in that point. I mean, I think the Bar Association, the Supreme Court of Georgia would say, yes, you have a duty to correct those frauds. But there's a heck of an argument that he's not your client anymore. That ship sailed. And I think that's what Bradley would try to argue right now. But I think they're on the right track that, yes, he still has an ongoing ethical obligation of candor to the court, and the fraud of Wade would permit this. But he doesn't necessarily know what Wade said if he's being a good boy and doesn't listen to what was done before. So he's kind of being able to successfully hide behind it because he hasn't been given what Wade said, I would argue.
So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor. The issue about crime fraud is whether or not, in any context, the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this.
Island, yes, there's privilege. But for example, if you're my client and I put you up on the stand and you commit fraud, or something's happening where there's fraud going on before the court because of my representation to you, because of something you're doing, I have an obligation and a duty to notify the court, and I'm allowed to break privilege. So there are exceptions to breaking privilege. There are limited exceptions. I mean, we'll do that here real quick. Rule 1.6, the confidentiality of information. And we'll just do, hold on here. Georgia. Georgia rules professional conduct. It's not a complete bar. There are times where it is important, but it can be waived and it can be destroyed. Okay. So this is where we need to look. All right. So here's the part that matters, okay? And this is their rule of professional conduct. Confidentiality. A lawyer shall maintain in confidence all information gained in relationship with a client, okay? A lawyer may reveal information covered by paragraph A when the lawyer reasonably is necessary to avoid or prevent harm or substantial loss to another client or to another as a result of the client's criminal conduct or third-party criminal conduct, including violation of law. So this is where he does it. It is a discretionary issue for the attorney. Okay. To prevent serious injury or death, not otherwise covered by subparagraph 1 above. So if you tell me you're going to go kill someone, I don't have to tell anybody. To establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and client. So for example, if you're my client and you sue me and say I didn't do a good job or something happened, I'm allowed to break that privilege. I don't have to, but I have the right to. Because now you're forcing, like, you can't silence me and use that as a bludgeon, okay? If it's a defense to a criminal charge or a civil claim based upon my conduct. So if you try to implicate me and say, oh, Sean was in on it all along, I can say, no, that's not what she told me. She told me she did it. Yeah, I'm allowed to save my ass. To secure legal advice about compliance with these rules. So I talked to attorneys before, hey, am I in trouble if this is an issue? And I have attorneys call me, hey, is this a problem? I'm like, I don't think so. Okay. So to detect and resolve conflicts of interest arising from lawyers' change of employment or changes in the composition or ownership of a firm, saying, hey, look, I'm leaving. Here's all the stuff you need to know about this client. Okay. So there are times where you're going to do that, or the information would not prejudice the client. So if I'm leaving a law firm, I could tell them, hey, here's what we all talked about. Get ready to represent them. So that is an issue. Okay. But here's the part. Lawyers are part of a judicial system charged with upholding the law. One of their functions is to advise clients they avoid any violation of law and proper exercise of their rights. Okay, well, but now we have to get back to, like, there are rules, but they're not unlimited. This thing is not necessarily Wade's to waive if he's fucking around. But this whole thing is a mess and a half. Okay? So just something to think about. It is not, and ultimately, in the course of representing a client, a lawyer shall not knowingly make a false statement to a third person or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal act or fraudulent act by a client, unless the disclosure is prohibited by Rule 1.6. Well, and that's where you get to, well, what are we looking at? Was there an issue of fraud? Was there an issue there that would kind of trigger this? Because remember, what are the times where you can do it? Preventing substantial harm or substantial financial loss. Okay. Are we preventing serious injury? No. So there might be a way to get around this. Okay. But that's where we are. So it's not exactly just his to waive. Like I said, you could self-destruct this on yourself. But let's get back to it.
Blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by this merchant.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard, outside of communications with a client? When you say you lack personal knowledge, does that include anything they have seen or heard outside of?
Okay, Island, no, don't just shut up and knit. You're asking good questions. Don't be afraid to ask more. I promise. You're not. Please don't stop asking questions.
Communications with a client. And you can tell me if that question was horribly phrased. I can try again.
Yeah, and this is the problem here. There's so many competing rights, privileges, duties. This is a mess. This is a law school problem, guys, because there's no clear answer. So, does the lawyer have to acknowledge the existence of information that is privileged? Well, for example, Coupon, that's a good question. Earlier they were saying, hey, did you talk to him? Yeah, okay. Yes, we talked. What'd you talk about? That's privileged. Did you talk about X, Y, and Z? That's privileged. I can't discuss it. I can't discuss what we talked about. You can't say, yes, we talked about X. What did you talk about exactly? No. What did you talk about? That's privilege at that point. We had a conversation. What was the topic about? Related to my representation of him. That's all you got to say. Can the guy be sued if the judge says it's okay to answer? I mean, yeah, he could still get sued. He could still be disciplined, possibly. I mean, like I said, this creates so many problems of how you force somebody to talk. The judge is trying to say they're trying to find ways around. This guy's trying to assert privilege, probably to protect his ass, among other things. But also, he's like, I don't want to get in trouble here. This is a complete mess of a case right now. But this has to happen. And I understand what the judge is trying to do, but we're going to rewind it half a second.
When you say you lack personal knowledge, does that include anything they have seen or heard outside of communications with a client? And And you can tell me if that question was horribly phrased. I can try again.
I'm trying to rephrase it for me, Judge.
I get the question. The judge is saying, without disclosing what you talked about with your client, do you have personal knowledge based upon your observations of things not relating to your representation? Although you might want to argue if, yeah, I watched them fucking in the office, well, that goes to the representation of things he told me. But I don't know.
I'm sorry.
Okay. When you say you lack any personal knowledge,
Yes, sir.
does that also mean that and include anything you may have seen or heard outside of communications?
Outside of communications with my client.
Mm-hmm.
That's correct.
Okay. And
Interesting.
communications that were made, if any, that relate to the subject you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Including texts.
Okay, chat, I have to pee real quick. I'll be right back. I can't wait. Let's roll.
Am I asking your question or her question? Okay.
Were there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
Ooh, here we go.
No, Judge. I can't recall anybody being present.
Was Fanny there?
I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
All right. And did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned
I'm working on it.
regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
That's a broad question, Judge, to answer because the advice was given and then you have interaction. I mean, it wasn't, hey, this is for, to say specifically, this was for that, but I can't sit here and say that. So I don't know how to answer that question, Judge.
Okay.
It's a fair answer. Fair
All
answer.
Right. So
I was given a case that may reflect the same proposition that was argued from it's old case. It's Atlanta Coca-Cola Bottling Company versus Goss, Goss, 50 Georgia Appeal 637, appears to be a 1935 decision. I've not had the benefit of jeopardizing it, so I can't say that certainly has been limited or overruled. And looks like it's in reference to maybe head note number 2, at least from what I'm looking at on the computer, and language that is in the case, okay, is as to violations of law or commission of fraud, the protection extends only to communications after the act or transaction is finished. It does not cover communications respecting proposed infractions of the law and the commission of the crime or perpetration of the fraud. And then it cites some cases. And then it goes, the privileged communication may be a shield of defense as to crimes already committed, but it cannot be used as a sword or weapon of offense to enable persons to carry out contemplated crimes against societies, frauds, or perjuries. So our position, as I indicated before, is the witness, Mr. Wade, has committed perjury on the witness stand and called into question the statement.
All right, understood, Mr. McDougal.
Your Honor, this is adjacent Georgia law, perhaps not controlling, and I'll explain that in just a second. And that's Rule of Professional Conduct 3.3A2. A lawyer shall not knowingly fail to disclose a material fact to a tribunal when disclosure is necessary to avoid assisting a criminal or fraudulent act on a claim. A4, and the reason I would qualify that, since we're talking about candidate report, I need to do that. I believe this rule.
He doesn't know necessarily what Wade said, I guess. I still think.
Is regarding the conduct of advocates representing clients in court. It might not govern or control the situation where the lawyer has been put on the stand, but it's adjacent to the point Mr. Sadal made earlier.
All right, fair point. Okay, Mr. Trump, anything you want to address on that?
Briefly, Judge, and clearly there's a lot of smarts in this room, but this whole thing is a deductive fallacy. It is suggested.
Seriously, just start with the fact that this guy doesn't know what the fuck the other witness said. That really kind of kills most of the argument. I don't know what my former client testified to. So I can't correct a fraud that I don't know about.
That the truth of the conclusion of the argument necessarily follows from the truth of the premises given, when in fact the conclusion does not necessarily follow the premises. They're, call him a perjurist. He is officially succeeded in saying the thing itself is true, therefore we must ask these other questions. And Judge, it's a fallacy. It does not exist as such, and the privilege should still apply.
All right, thank you all. So I think here is what we need to do, as I understand the law. As I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship or in furtherance of a crime, or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards, and that's something that can be argued during closings, essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some uncertainty on that point, and so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were, if any were relevant. Or excuse me, not relevant, but just what they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant.
Yes, this is really bad.
As asked, would be sustained on the issue of privilege to premise. He may
this is a dumpster
have told
fire.
you something, but it does not appear that there's any evidence that the client ever waived.
And to be fair, I think this is the right decision right now. There might be another point where this, I know you guys say shit gets different coming up, but for right now, that makes perfect sense to me. And then there was who has it here? Okay, next is the 9,560th is saying, so to make sure I'm understanding what's going on, this case is investigating issues with, yes, this is an evidentiary hearing about what Fani Willis, who's the DA, brought charges against Trump, figuring out like how corrupt she's been in her administration of this case. So yes, exactly, that's what this is about. So that was not a bad ruling by the judge though. And Coupon 9 saying, wouldn't that just kick the can a little further down the road because they would introduce the client's former statement and ask for a statement then? Well, no, because there's no way to he said, I don't know if he said that. I mean, there's no way for this guy to say, I know what this guy said. So they can't, you can't, and I'll say it like this. You can't impeach me with someone else's prior statement. You would have to impeach Wade with his prior inconsistent statement. You're trying to impeach a third party with someone else's statement. It doesn't work. I get what you're trying to get at here. Maybe there's a way you could do it if there's like a, J-Rock, I know you're a better attorney than I am probably on this, but if there's some way to do it through the rules of evidence, maybe. But you're not going to probably get that, because I would object, say, how can you impeach someone else? Like, how can you impeach Mickey Mouse with Donald Duck's words? Donald Duck has no idea what the fuck, Mickey has no idea what the fuck Donald Duck said. So, and yeah. So that's where I think we are. So, but you aren't being impeached. Wade is. Yes, but you have to impeach Wade with his words. You're trying to impeach Wade through a third party. You can't do third party impeachment like that. Now, and here's the problem. Yes, you could use him as a rebuttal witness or an impeachment witness. The problem is privilege exists and you can't pierce privilege yet. The judge is not buying the fraud issue. Because once again, this attorney doesn't know what Nathan Wade said on the stand. So, yeah. And J-Rock, this is the thing. If it was that current attorney, that bald guy sitting at the table with the DAs, Fani's attorneys, that guy could be forced to come up and spill the beans. But we haven't gotten to that point, and this guy didn't represent Wade back then, so it's a former client issue. And that's a big distinction. I do have duties to a former client. My duties to my former clients are not as big as my duties to my current clients. That is a massive distinction under the law. That's a massive distinction under the codes of professional conduct. I still have duties, but those duties are different in scope. And there's fewer of them. So here we go, guys. I'm sorry. Just wanted to clear that up. I know that was a whole... That's the fun... Like, I hate... you guys, you might not like it. This is the fun shit when you're a lawyer. Like, you go in there and you fucking argue stuff like this. And it's about the maneuvering. And can you get the judge to buy what you're selling? I found this case out of some bullshit courtroom in northwest Ohio. Out of the Lucas County Courthouse. Back when it probably only had a couple of courtrooms in it. This is the stuff here. This is the shit, it's like in Heat. I'm like Tom Sizemore. For me, the action is the juice. So, and both these attorneys, Merchant and Sadow, have done a fucking phenomenal job. This other guy over here just bumbling through it for Brandon. It's easy enough to say, look, it's a former client. He has no duty, and I don't know what the hell he has no duty to know what this guy said. Done. So, here we go.
And allow that information to be conveyed to you. Next question.
Thank you, Judge. All right, let's see. So we talked about Ms. Willis and Mr. Wade coming to and from your office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Just asking if you
recall. Do I recall?
Yeah.
I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I'm going to object to that.
Does he recall
Actually, I
Ms.
take that
Willis
back.
taking?
I don't object to that.
But you can answer the question, sir.
I do recall security detail bringing Ms. Willis to my office.
Do you recall approximately when that was?
I do not.
And was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had a security detail before she became DA. So
we'll answer this later.
If she was sworn in, or I don't remember the dates, but I do remember.
We'll talk about this later.
I think she was DA.
maybe during her transition team period? Was that?
No, it wasn't. Trying to remember. She would have had to have been the DA, I think. And I don't want to go on, I think. But I do remember twice her coming to our office, correct?
And she had a security team both of those times.
There was yes, she has a security team with her.
And do you believe that it's a different security team than she has now?
I don't know her security team now.
Well, let me ask.
However,
I'm sorry.
I don't know her security team now. I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Fuck is this relevant for?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
I don't recall saying that, no, but
do you recall talking to me about other people that might have known about their romantic relationship?
Fuck, I know where she's going, I think. Uh-oh.
Yeah, objection based on, we don't know the source. This is either based on privileged information or it's hearsay. Neither one is.
It's neither. I asked if you recall.
You need to clarify it. If you're actually going to think, if you think that this draws on information from outside the relationship that he's already testified to, then you need to lay that foundation. That's sustained.
Are you aware of other people that you believe would have known about when their relationship began?
I object to the relevance of that. Again, the witness has testified he has no firsthand information.
I'd argue you blew that because you didn't object earlier. I would have objected immediately about the security team shit. I'm a little confused, but I kind of think I might have an idea where she's going here. Maybe. I don't know. I got to see this pan out a little bit more.
Of it. Anything he knows about the topic came from representation. Who he thinks might have been able to say something else is speculation, not relevant to anything, and a backdoor to get in the gossip and innuendo that has been pretty much this entire.
All right. Okay, Ms. Merchant, I think we're getting to the point where, you know, the reason that I thought this line of questioning was appropriate was to rebut certain inferences about why we were here in the first place.
Right.
But to go into it at the granular level, I'm not as wild about. So maybe you can ask more overarching questions. And if you have anything else you think that's relevant, then you can get to those as well.
Isn't it true that I gave you a copy of the motion to disqualify in this case? I emailed it to you and you read it, reviewed it, and emailed me back that everything in it was accurate, to your knowledge.
you emailed me, and
Objection.
Okay. All right. So there are things contained within that, Ms. Merchant, which he is now
A lot
said,
of it would be privileged.
fell within the privilege, and they did not have the ability to waive. So I think that's where we have to leave it there.
And I believe I still have to ask the questions, and then if he wants to assert the privilege.
Well, I think we pretty much already established the privilege, and the objection has been made, and I think it's a valid one at this point based on the record. So the answer was he did acknowledge that you sent him the motion, and I think we leave it at that.
Let's see.
She's not wasting time, guys. This is all
You had
planned.
knowledge about an apartment. I'm not asking what Mr. Wade told you and for the rest of legal advice, but you had knowledge about an apartment in East Point or a condo in East Point that was owned by someone and Miss Willis was staying there.
Judge, privilege.
I think in the way the question's phrased, she qualified that, so.
I did not have knowledge.
You did not have knowledge.
I did not have personal knowledge at all. No,
So no knowledge outside of what is privileged.
that's correct.
Did you have texts between yourself, Miss Willis, and Mr. Wade?
Do I?
Have you ever?
I have. Maybe once or twice, but
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection.
On
privilege. I think we still the same thing.
It's not privilege.
Credit card, how's that in the nature of furthering a divorce proceeding?
We were talking.
Oh, God, he thought the judge was going to bend over on that one. The judge says, why? Well, fuck. Now I'm in trouble. I might be suborning perjury or fraud. So he backed down. Immediately we would draw it, Your Honor. Ooh. Ooh, boy.
I have a business card, and we would use my business card. The firm would use my business card.
For travel?
Third-party paper trail. Third-party paper trail. That only works as long as you keep the third party in your good graces. Once you guys fall out, that's somebody running around in a hostile party with receipts. Ooh, God, Nathan, you dumb motherfucker. It's a free lesson to you guys. You're going to start playing games. You better be friends with you better keep friends, because this is how it happens.
Are you asking if I use my business card for travel?
Would Mr. Wade use your business card for travel?
I recall I recall a trip, but I don't know if that trip has anything to do with this case. So I do recall him using my card once.
When was that?
And I don't even know when that was.
This case is not protected by attorney-client confidentiality when he says this case. If he says this case, or does he mean like this case, like their case? Ooh. Ooh. That's not good, chat. Homie is tiptoeing through a minefield, and he's starting to get a little weeble wobble. He might fall down soon.
And that sounds true. I recall him using my card once, but I cannot remember what that was for. I do remember it was a trip, but I cannot actually state, where it was and who it was with or anything like that.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was.
Did Fani Willis pay you in cash? I hope she comes up with that question soon, because that's a question I'd want to ask.
I'm not certain if it was cash or a check. We routinely would use my card for filings, for paper, for whatever stuff with the office.
But this
And
is
so,
I'm sorry. You're done, sorry.
and so he would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I think I remember that.
I cannot recall. I don't even have that business card anymore. But I do recall at least once for travel, yes.
And that was when you were still law partners with him, though, correct?
That is correct.
Do you recall approximately when that was?
I do not.
You did not go on that travel with him, though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I'm assuming. We would use the card for firm stuff. And so it was a business card.
Your business card, though.
It was my business card, yes.
Right.
The law office of Terrence A. Bradley, correct.
Okay, so it showed up on your accounts.
That is correct.
Okay, wouldn't show up on his accounts, is that correct?
That would be accurate, yes.
Do you know if this was before he became special DA in this case, special prosecutor?
I cannot recall.
Did you see he and Ms. Willis together? You said you were in and out of the office, in and out of the DA's office. You saw them together, correct?
In and out of my office or the DA's office?
The DA's office.
Correct.
You saw them together in.
This is actually a very important question. You can always plead the fifth at any point in time, and there's a Supreme Court case for that, Ohio v. Reiner, which, funny enough, came out of Lucas County, Ohio. It was a shaken baby case, and I know one of the prosecutors who tried it at the trial court level. You have the right to plead the fifth at any point when it's going to be your ass. And even if you're not sure, even if you think you're innocent, you have the right to not testify. Now, things could happen where the prosecutor could say, fine, you're granted, and now the DA's office could grant him immunity and say, start squawking. So we'll see. But yes, he could do it. He could do it. But yes, this is a big thing here, or J-Rock. No one asked Fani, did you pay anyone else in cash? Although still, I don't know why they're not asking him. Did anyone else pay you in cash? They're just giving this one away, but yeah. So here we go. Good question, though, down there. Who asked that? Again, Mamasaurus, that was a good question. Brilliant question.
And out of the DA's office.
Did I see them in and out?
Yes.
Well, if you preface it like that, no. I saw him in and out of the office when I would be there doing my filter work for the tank team.
Okay.
He would come by. I rarely saw Miss Willis and Mr. Wade together in the DA's office.
So, brought up the tank team. Let's talk about that for a minute. Tell me about, you did work as, you had a contract as a tank lawyer, correct?
That is correct.
Okay. And that was in the anti-corruption unit?
Yes, I think so, yes, correct.
And how did you get that contract?
What do you mean, how did I get it?
How did you get the contract?
It was.
Bid? Did you apply online?
Oh, no, it was proposed.
My homie asked me if I wanted money.
We were, it was proposed by, I guess it came from the district attorney. I mean, I didn't speak directly with her.
Okay.
It was with Mr. Wade, and he asked if we would be interested in having a contract with the Fulton County.
Okay. He asked you, Mr. Campbell?
I think so. I mean, I can't recall if he asked us both together or not. Rarely. We all handled several, different things for the firm,
Okay.
criminal, personal injury, things like that, family law. And so rarely were we together there at the same time, like for an abundance of time. So he may have called me and then he may have called Chris. I can't recall how we got the contract, but
Was Mr. Wade, to your knowledge, part of the transition team for Ms. Willis?
to my knowledge, he was part of the transition team.
Did he spend a lot of time at that office during this transition period?
He did.
So from when Ms. Willis took office to when you left the firm, did Mr. Wade spend most of his time at the DA's office?
So yes, this guy was part of the team. And notice he said, like, how did you get the contract? Oh, Nate walked in, it's like, yo, Holmes, you want to make a couple $100K? Here, we'll do this. And taint team means they go through privileged information. So this guy's got all kinds of privileged information knocking around his head. But yes, that is sketchy as fuck. Like I said, kickbacks. It's not just for chainsaws, guys.
you say most of his time, you're saying just working business hours,
Yes,
or?
working business hours.
I would say he spent, I would probably say he spent majority of time. If you say over 51%, I would say yes, he spent over 51% of his time.
And that was the entire time from when she took office to when you left the firm.
I can't say that was the entire time, but yes, it was majority of, it was I can't pinpoint specifically when the time that he would spend.
Yeah, it's a nice fig they're making.
I think, if my memory serves correctly, getting to the majority of the time, it would have been whenever.
Sorry, Josh.
He started with this, maybe.
As a special prosecutor?
When you say majority of the time.
Right. Okay, so let's talk about the time before he became special prosecutor. Did he spend a lot of time at the DA's office then?
He spent time. I mean, it depends on what you say is a lot. He spent time at the DA's office, correct?
And so, just so we're clear, you were hired first on January 25th. Both you and Mr. Campbell were law partners, and you were both hired by the DA January 25th, 2021. Is that correct?
Repeat the question, I'm sorry.
You and Mr. Campbell both were hired on a contract basis by DA Willis January 25th, 2021, correct?
Which contract are you talking about?
The first one, the taint contract. Not the first appearance contract, the taint contract.
Well, you said the first one, and the taint contract wasn't the first contract, and so.
Okay, so what was the first contract?
To my knowledge, the first contract was the first appearance.
Okay, so let me just mark these. Let's see what number 23.
Oh, here we go.
4.
I kind of get the feeling shit's gonna go down.
Judge, when they're done reviewing these contracts.
Yes, they are all lying. Yes, they are.
This rally is showing you what's been marked. I'm fixing at 23, 24, and 25. You can just look at those.
You guys are getting me nervous. Getting me all worked up out here. You guys got me all excited. I'm like a horse sitting in the gates at a race. I have a lot of anxiety right now, but it's like it's anticipation. I'm glad I didn't see this yet. This is the calm, but this is the storm before the calm. To quote the great John Mayer. Here we go. Oh boy. Oh boy.
Okay, I see.
So on now that you've reviewed those, is it true that on January 25th, 2021, you got your first contract as a taint lawyer?
As a taint lawyer, yes, I see the date on that as a taint lawyer, but I'm also looking at this contract here for first appearance, and there must have been. I don't have it for me, but there must have been a contract before this.
Okay, so you think there's a fourth contract?
I can't say that there is or isn't. What I do know is that we did first appearance during COVID.
Wait, y'all getting paid without a contract? Is that the bombshell? Because that's not good either. They're just money flopping around. Like, what the fuck is going? Like, I don't know if there was another contract, but I got paid. Whew.
And it was before 2021. So I don't know, if I had a contract, a written contract at that particular time or anything, but I do know, I think that you could look at the recordings because everything was recorded at that time as to when the first appearance contract started and the taint contract started.
So when the three of you were partners, you had at least 2 contracts to do taint work, which is filter work, and then at least 2 contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So, it just renewed. So yes, if it was the same contract, but it was a renewal of.
Okay. And so how did you, and you said that you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Yes. I didn't have a meeting with Ms. Willis or anything. It was.
We'll save this. This is a good question.
It was brought to the attention that a contract was going to be needed or awarded, and if I was interested, because this was off of mine, and I said yes, and so
Mr. Wade brought that to your attention?
He asked if I was interested in doing the contract, correct, and then after that is when Ms. Willis, would come in, or I think we actually came down here or something, and signed the contract.
Okay. And so that is how you were paid from Fulton County, these contracts?
From Fulton County government? Yes, ma'am.
And you shared, your partnership, you shared a third of all your profits with Mr. Wade?
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay. So during 2021, 2022, you all had 2 filter taint contracts. You had 2 first appearance contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
So I don't think at this time we had established WBC.
Okay.
At this time, I think I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So you weren't actually partners, you just fee shared.
That's not a bombshell, guys, but that's fucking sussy under the rules of professional conduct, pulling money like that. That's just fucking weird. That's fucking weird.
At this time, well, yes, at this time, we were not. At this time, I had Law Officer Terrence Bradley, Chris Campbell, PC, and whatever Nathan's was, if I'm not mistaken.
And all these the taint contracts and then Nathan's special counsel contracts, all of those were under the anti-corruption unit, correct?
First appearance was not under that. The tank contract, if I recall, was under the, I don't think they called it, what are you calling it?
You can take a look at your contract if you need.
Okay.
And I'm not asking about the first appearance, I'm asking about the tank contract
Mhm.
and then Mr. Wade's contract, which has already been admitted in evidence if you need to look at that. Let me know when you're done reviewing.
Well, I see on the first page where it says tank attorney, and I'm trying to go through and I see where it continues says tank attorney, but it always says Fulton County District Attorney's Office. Your question was specific as to the anti-corruption unit, and I'm looking for the verbiage of anti-corruption unit, so I apologize.
Oh, no, take your time.
Exactly. Although I guess our resident barrister down in the Hotlanta area, J-Rock, would say that's how they do stuff there. This is how the corruption is. But yes, this is old red line. You're hearing what I'm hearing too, man. That don't. Oof. Oh yeah, that's not good. Oh, but here we go. Oh God. My feet are already sweating from how bad this is.
And see, on both pages, I mean, it starts out Fulton County District Attorney's Office, and then it just goes to initials FCDA, unless I'm overlooking where it says the anti-corruption unit, then the contract was with the FCDA. I mean, unless you want to show me something.
I'm just asking you, and I didn't know if that would refresh your memory. Those contracts were for the anti-corruption unit, right?
Well, they were for the
Is that who
district.
you worked for?
I worked for the DA.
Okay.
I worked for the DA.
Okay, so just in general, the DA.
Correct. I worked for Fulton County District Attorney's Office in as a contract person, as it says here.
And when you did the taint work, you had to report to Sonia Allen?
I did not.
You did not. Who did you report to then?
I can't remember his name. His first name was Brian.
Okay. And let's see. So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts, or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office and something like that. But no, I didn't have any meetings with Ms. Willis.
Okay, so the only times you met with her were when you signed those contracts.
Clarify meet with. I mean, I
Sat down and had a conversation with her.
I signed these contracts, so when I signed these, I met with her. To say that I sat down and spoke with Ms. Willis, are you saying in life, and you saying during this time? What are you asking me?
I mean, if it's voluminous, I can narrow down the times, but I wasn't.
Ms. Merchant, I haven't really heard a point in a while. Can we get along to something
Yes,
where we're going to have to wrap it up?
So I had one more question about your text. Have you ever been in any group text with anybody other than, with me, and somebody other than Mr. Chopra and Mr. Merchant?
You're gonna narrow that down. I'm sure I many
I can look
times.
at my phone.
No, with him, if there have been any other texts. And I think that state had some thing in rebuttal they mentioned, so I was just trying to clean that up before it got there.
Can you try the question one more time?
Yeah. Isn't it true that the only texts that you and I have ever had have been between me and you and Mr. Chopra, or me, you, and John Merchant, correct?
Can I give him a phone?
Sure.
Did anybody else hear that noise?
They've said multiple times that there's this third party that we've talked to, and I'm trying to establish this with a third party.
It's not me, guys.
And I don't know why it was relevant, but the state's...
Yeah, guys, I don't know what the fuck that is. It's not me. Fuck, it's annoying.
Argument, so...
Well, if Ms. Merchant doesn't know why it's relevant, then maybe it might become relevant later date. But,
Ms. Merchant, I think you've been able to show
It's not my smoke detector.
what maybe launched this and answer the state's initial claims. And so let's get back to the core of what we were here for this hearing. Do you have anything else relevant to ask?
After you, yes, just a few more questions. After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
I did.
And was he trying to determine if you were going to be giving information in this case?
I can't, I don't know what he was trying to determine. He stated that it was an odd, I had not spoken to Gabe in a while. We are colleagues, we are friends, we are in the same fraternity, Gabe and I. And when he called, it was out of the blue. But he did call, yes, ma'am.
Okay. And you relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me. The call was,
I'm going to check if there's a hearsay. It's the response to the call for hearsay. Thus far, it hasn't. But
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that.
well, he hasn't testified to it. He also said there wasn't any message relayed by Mr. Wade or any party.
Well, no, he didn't say that by any
Right,
party.
Mr. Wade.
So assuming he did hear something from a party, what's the hearsay exception for that, Ms. Merchant?
I
Prejudice
believe that it was a
impression?
threat, so it's a statement against interest. I'm sorry, it's a
Effect on the hearer.
if he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right, so
I did not take it as a threat.
if you're saying it's to the effect on the listener, perhaps,
Yes.
then we'll go from there.
Effect on the hearer is always an exception.
Were you told to remember your privilege?
No, the witness just testified he didn't take it as a threat.
Understood.
That's not what he's asking.
I'll overrule the objection, the testimony given the way it deserves.
It's not what you asked her.
Were you told to remember your privilege?
I was not.
A witness, there may be a potential witness now in the courtroom, because the person that Ms. Merchant is referring to is sitting in the courtroom.
If that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his name.
Okay, and so were you told anything to that?
Answer the question. Answer the question.
Repeat the question one more time, but so I was not told, remember my privilege.
Something about privilege. Remembering that.
I do recall privilege being mentioned, but it wasn't remember your privilege or, a threat of any sort.
Did you immediately call me after?
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day, yes, ma'am.
Okay, thank you.
Sit down.
Your Honor, because this is a defense witness, is it the state's first cross? I think that's how we had been doing it yesterday.
No, actually, we're doing it just this way.
Yeah, I've been,
Yeah, there's been
this is
no
the first time
change.
he's gone, and then we go through all the defense,
Yeah.
and then you'll have your chance.
Yeah.
Some foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
I would say it was, if I'm speculating.
I really don't want you to speculate. I mean, you're the one that was the attorney and Mr. Wade was the client.
Correct.
So give us the ballpark figure of when it was that you began acting as his attorney.
Maybe 2017, 2018, I think, maybe.
And the purpose for which you were retained?
His divorce.
So, according to you, from that time period, your communications with Mr. Wade with regard to the divorce or any matters related to the divorce, it's your position are confidential, are privileged, correct?
Yes. Yes.
Okay, good. Now, did you ever meet with Ms. Willis and Mr. Wade prior to, and everything I'm asking you was prior to November of 2021, okay? Keep that in mind. That's.
Why are you yelling?
I don't think he's yelling, Mr. Bradley.
He's not yelling. Don't be a
Let's
bitch.
go.
Okay, thank you.
Don't be a bitch. That whole Fanny thing. Don't yell at me. Number one, you're not a woman that. Why are you yelling? Quit being a bitch. You're cornered. I get it.
Prior to Mr. Wade getting his
Fucking yell at you, brother. You're
contract with Fulton County, which was November 1st of 2021. Okay, just please keep that in mind.
November 1st of 2021.
Right. Did you ever socialize with Mr. Wade and Ms. Willis prior to November 1st of 2021?
Why you fucking lying?
I've never socialized with Mr. Wade or Miss Willis in any setting. If you're asking, have I ever met with them, then I would say yes. But when you say socialize, what do you mean socialize?
Have you ever gone out to eat with both of them?
Before 2021, I do not
Or
think
November 1st of 2021?
out to eat with both of them before. When was she sworn in? I'm sorry. When was she sworn in? There was a dinner before, when she was sworn in that I attended. Shaquille O'Neal was there. So it was like her inauguration dinner. So I'm thinking that's before 2021. So I would say
Let's
yes.
assume for purposes of my question that
Yes,
that's in early January of 2021.
Yes, that's a
That
hard yes.
is early January 2021. So yes, it would be before November. So if it was January, yes, that dinner would have been in, I'm assuming January.
Okay. And any other time that you socialized, went out to eat, went to anyone's home, you know what socialized is?
Exactly. So no, I did not socialize with Mr. Willis. With Miss Willis and Mr. Wade.
So prior to November 1st of 2021, did Miss Willis come to your offices? Your offices, the
Also,
offices
good to see you here.
that you shared with Mr. Wade.
I think she came once or twice to our office, correct?
And the purpose for which she came?
I don't know. We had separate offices. I do recall, I do recall some type of meeting happening at our office. And I don't know what that was about. I wasn't a part of those meetings. There was a meeting. There were other people there. other people from the, I want to say DA's office there, maybe.
Okay.
You
Let's
don't
go
know.
back to
That's concerning.
the basics. Ms. Willis came to your offices, together offices, on a couple different occasions.
I recall Ms. Willis coming to my office at least twice.
And on at least one of those occasions, or you tell us, did Ms. Willis meet privately with Mr. Wade in his office that you observed
Oh, I bet they
or
did.
heard?
I can't recall.
You can't recall.
That'd be a privilege
Did she ever
too.
meet with you in your office? Ms. Willis now.
Privately in my office? No.
No.
I've never met privately in any office with her outside of signing this contract.
Did Mr. Wade, prior to November 1st of 2021, ever talk to you about socializing with Ms. Willis?
I can't recall.
You can't recall?
You're asking me if he ever mentioned to me that he socialized
with Ms. Willis, correct?
And I'm saying I cannot recall if he socialized with Ms. Willis, if he ever mentioned to me that he socialized.
Did he ever mention to you that he ate or went out to dinner with Ms. Willis? Again, time period before November 1st of 2021.
I'd still be arguing this is privileged. Wait. Hold on here. Is Wade's attorney sleeping or something? Because I'd still be screaming privilege all over the fucking rooftops. And I don't know. This guy's not saying privilege either. Also, yes, some of you guys did send in super chats that looked like they may have been spoilers, so I did not read them yet. We'll get to all the super chats after a while. I promise. But please keep sending them in still. Ooh woo.
Did he repeat your question?
Did Mr. Wade ever tell you prior to November 1st of 2021 that he had socialized, gone out to eat, visited Miss Willis in anything other than a professional setting?
I'm sure he did, maybe. I don't recall any specifics of any dinners, any specific places. It's been 3 years ago, the time frame, but I do not recall at this time whether or not he ever mentioned any dinners or socializing.
Did Mr. Wade mention to you that he visited Miss Willis at Miss Willis's then current abode, which would have been a place, not her original house, but a place she was staying in the period of 2021 before November 1 of 2021? And his question is, did Mr. Wade ever tell you that he visited Miss Willis at her house?
I don't think I can answer that.
Yeah, privilege based on communication with my client. Also based on hearsay.
Mr. State, if you want to try and rephrase the question, you can, but otherwise that would be sustained.
Yeah, you should have done that already.
Oh, I didn't hear a second ground.
Dumbass.
Hearsay ground.
Oh, that would be on privilege alone.
Did you talk to Mr. Wade at all about his relationship with Miss Willis prior to November 1st of 2021?
I think he's just laying a record, Mr. Wade. It's okay. And so on those same grounds, Mr. State Allen, all subsequent grounds, apparently the relationship with Miss Willis in any way is covered by privilege according to this witness.
Well, I think the key words, respectfully, Your Honor, are according to this witness. So I'm trying to drill down to see if there are communications that are not within the privilege.
Sure.
I can.
So then we need to acknowledge the privilege in the form of your question, right?
You're asking me to ask it as in a way saying, are there any non-privileged?
Essentially.
Okay. Did you ever communicate with Mr. Wade prior to November 1st of 2021 about Miss Willis that was not privileged?
I mean, we discussed this contract. But
This contract doesn't help. You have to give me a exhibit number, please.
you said before November 2021?
Yeah, November 1st of 2021.
Before November, this contract for 1/25/21 is before that. So I mean, we discussed this contract.
Okay. And if I remember correctly, when again, just give me that exhibit number so we can reference.
Exhibit 23.
Okay, so hold on 1 second. 1 second. On exhibit 23, did I understand you to say that it was Mr. Wade that effect brought you and Ms. Willis together for the contract?
That would be accurate, yes.
Okay. And what did you understand was the relationship at that point between Ms. Willis and Mr. Wade, for Mr. Wade to be able to bring you to Ms. Willis for the contract? It's not a hard question. It's
No, I'm just, say that again.
Mr. Wade is the one that basically says to you, go see Ms. Willis about this contract, right?
Mhm.
Okay. That's a yes, correct?
Yeah, yes.
So Mr. Wade had to have some knowledge, you would assume,
Yes.
right? That you going to Ms. Willis might bring you the contract,
I
right?
never went to Miss Willis. So I stated I never went to Miss Willis.
No.
I was told about that there was a potential contract, and I was asked by Mr. Wade if I would be interested in doing that contract.
And my
I
question, okay, my question to you is, what was the basis that you understood Mr. Wade being able to essentially offer you that contract on Ms. Willis's behalf?
I'm going to object to that. That's a mischaracterization. Mr. Wade offered it to him. I think he said he expressed interest. And also, I don't see the relevance of this at all.
So just in terms of relevance or phrasing, I'll overrule on those grounds. So the question that's standing unobjected to, Mr. Bradley?
Can you repeat the question?
You've explained to us how the contract
Yes.
came to you, correct?
Yes.
And my question is, what was your understanding of the relationship of Mr. Wade and Ms. Willis for it to have been offered, or whatever word you want to use, for him to have said, expressed to you whether you had an interest in the contract?
Privilege. Okay.
All right, Mr. Evans is no privilege of my question, so Mr. Sadell, I think you need to clarify whether.
Was it a privileged conversation that you had with Mr. Wade that let you know about the contract?
Or, no, it was the relationship was the question you're focused on.
Is the nature, I'm trying to do it in such a way, and I understand what the court said. Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client
Yes, that's how this shit
communication?
goes.
No, I knew of that through whatever work they did together as municipal court judges. That's.
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they
Why are you
did
saying
work
this now?
at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
Say that again, SLE?
Mr. Wade would have told you what you just told the court after you had established an attorney-client relationship with Mr. Wade, correct?
Yes, but when he told me of them being at a conference, I mean, I'm not understanding how relate. I'm trying to understand your question.
Well, my question is basically, you had communications with Mr. Wade directly that
Yes.
were not attorney-client privilege, right?
I've had conversations with Mr. Wade that were not attorney-client privilege, yes.
That involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
Well, if he's talking about her, that is if Mr. Wade is telling you about Miss Willis and Mr. Wade having met at a conference, right? Then he's talking about Miss Willis, correct?
Yes, but he also told me about other people that he met at the conference.
But he told you about Miss Willis as well, correct?
I think so, yes.
Okay, so there were communications in which Miss Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance, I was told about a conference. And
when were you told this?
I can't remember the dates of the conference, but it would have been after the conference.
Okay, well, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019, okay? So could you give us an idea, that being a fact, when you would have had this communication about meeting with Miss Willis at the conference, that is Mr. Wade meeting Miss Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade was, he had some position with the municipal court.
Yeah, right now my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
Okay. So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Miss Willis meeting at the conference had to be before.
Oh, yeah, yes, it would have been before that, yes.
So what other communications did you have with Mr. Wade about Miss Willis that are not privileged? We know of one, about the meeting at the conference. Are you suggesting that that's the only one you ever had about Miss Willis that isn't?
I cannot recall any. I cannot recall.
You cannot recall whether there were any other communications that weren't privileged?
No.
I'll be specific.
Yeah, it's a very
and
compound
I understand
question.
there's probably going to be objections, but I want the record to reflect. Did you have a conversation with Mr. Wade prior to November 1st of 2021 about Mr. Wade dating Miss Willis?
Mr. Wade has risen. An objection is sustained for the record. Excuse me, Mr. Evans.
Say that again.
You don't have to answer the question, Mr. Brown. Next question. Say that.
Well, I understand it's been objected to and the court has sustained the objection. Can you tell us
You have no idea.
the circumstances in which, that is, under which Mr. Wade may have told you about dating? What I want to do is try to figure out if we can, you tell me if you want me, if I can do this. I'd like to know how the communications themselves took place, where they took place, how they took place, under what circumstance, whether he was
Okay.
at the time providing advice, seeking advice. So those are the basics. If I can ask you as to all those, but if the court's going to sustain the objection to those, then I don't want to waste your time.
And that's something I'll cover in camera. So I'll note the question and your question for the record, and I'll sustain the privilege objection to that.
Okay, all of this prior to November 1st, 2021. Okay? I'm going to show you two text messages. I don't have hard copy. This is
What's that one? That data. See, what do
This is the first one. These are text messages.
And you want to get into the content?
I'm going to set up a question based on this. Here's the follow-up.
Okay, so I'm gonna have objections
Of
to
course, you're
that.
gonna have objections. I realize that. I want to be able to show it to him, and then I'm gonna frame the appropriate question, and then you're gonna object. We'll see where we are. May I approach?
You may, sir.
Look at this text message.
Of course, of course.
I mean, generally no, because you're trying to show the witness something. This is a good question by future Mrs. Martin 2.0. But there have been times where, like, Your Honor, may I approach with something for the court, or like to consider something, or can we approach for a sidebar? And I've been told, no, stay back. And I've also been the other party who's like, no. And I'm like, oh, damn. Yes, when the judge says no, that's not good. So, yeah, that's where we are with that. But that's a good question. All right, guys, I lied. Sorry, I answered that question. We're going to keep going, though.
Kind of hard to object. I haven't asked the question. I know it's coming. Okay. Then you must be a CSAyer.
Oh, what an
Mr.
ass.
Bradley,
He's like,
I showed
fuck
you
you
two
guys.
text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, yes.
Okay. And the text messages would have been between you and Ms. Merchant, correct?
I didn't see, yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message to Ms. Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct?
I'm gonna.
I haven't asked him anything about what the.
That's not objectable.
This is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
Understood.
He's only asking, did you talk about things, the subject, not specifically about it. This is about as vague as you can get, so this should be overruled.
Yes. And it's your testimony that the information that you imparted to Ms. Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
An objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established as privilege.
What another question? He didn't get into anything. He just said,
Yeah.
these two text messages about privileged communications. We haven't actually, he's testing. I don't see an issue there.
Yeah.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Whoa, there we go.
Can you tell us when it was?
That is brilliant. That's how you get it in, chat. Your information came from Wade and Wade alone. It's nice watching good fucking attorneys do good fucking work. I know it's not a bombshell for you guys, and this ain't it, but that's some good shit right there. I know it gets better, but that's good stuff. That's good stuff, chat. And save the energy. I have all kinds of energy. My stamina's replete. Just you watch.
Mr. Wade imparted this information to you.
Objection.
All right. And I think that
That's what you're gonna do.
Sure. So I'll sustain that on privilege.
And I'm gonna introduce for the record, when we finish, these two text messages so that Your Honor has those back there so that you can.
Sure. What would they be marked as?
Video.
I have a whole set.
Okay.
We have up to 24.
Go ahead.
The contract.
Once I put a staple in it, I think it'll be Defense Exhibit 26. Give me a real pen.
All right, so this is marked and on the record is Defense Exhibit 26, but not
Pissed
necessarily.
because he's already snitched
This is
inadvertently.
not admitted
Evidentiary value.
questions. It's for purposes of the court conducting the in-camera review. And put a staple in it, just to make sure that you see it. No charge?
Nope, it's free.
All right, let's say that. What else?
All right, so there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to?
Ah, that's how you get it. That's how you get it in. You prove. Oh my God. Say now, you fucking brilliant man. Because now he's gonna say, did you recommend anything be deleted? No. That's not tipping privilege. Did you recommend any corrections? No. That way you verify everything in the complaint and in the motion. There we go, chat. There we fucking go. I know it's not what you guys are still looking at, but that's some good shit right there. Woo!
But in an email.
I don't think I responded to her in an email.
Fucking dick Giga Chad. Giga Chad.
He responded by text. I'm sorry, I mischaracterized it. He responded by text?
If I can look at my text, I can, but I'm assuming I did, but.
Okay, I'm gonna get it for you, because I don't want to make any assumption. Let me forget. Let me show you. This is. Here. I don't have anything besides.
That, and look at him, he's like, fuck, they got me to admit to it. And notice the other attorneys, they can't say nothing because it's not privilege. Now Ashley Merchant's making allegations in a motion. Did you correct any of those? No. Did you say anything? No. Ba-bow! Ba-bow! I mean, so that means it looks like Fani and Wade looks like they may have committed a little perjury there. So good job, Fani. Good job, Wade. You dumb motherfuckers. You had it all. It was so easy, but you're so stupid and so greedy. Did you think people weren't going to notice? I guess. Pigs get fat. Hogs get slaughtered. If you're new to this chat, I tell you that. Pigs get fat. Hogs get slaughtered. Don't be a hog.
So, is that what you're?
I'm going to show you if I might approach.
Yes, pretty much. Fuck.
I made reference to an email Ms. Merchant would have sent you about the motion she was going to file. If you look at this, does this appear to be the email that you received? It's dated January the 6th, 2024 at 10:20, 10:25 a.m.
Yeah, I see it, the email, yes.
So that's the email that you received, correct?
along with, obviously, the attachment, which is referenced.
Yes.
And then, did you respond to that email within the text message that I just placed before you?
Yes, I said looks good.
The answer is yes.
Oh, yes, I did.
Okay. Then we'll mark this as another exhibit for your honor to look at. Since you love my tongue, can I have some of that? So I can catch that one. Somebody else.
I saved it for wild chat, but uh-oh. Uh-oh. Now we're in really big uh-oh territory. Big uh-oh territory. Uh-oh. Woof. Nathan Wade's probably sitting there going, whoopsie doodle. Yeah, it's a big whoopsie doodle, Wade.
Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected, let me hand it to you. Okay. What's the course rule, to ask or not to ask?
We'll take it case by case. I think he's doing all right, so we'll need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade?
Objection, this is privileged and cumulative.
All right, so now we're talking about the email, potentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1 of that?
Wade's attorney should have been objecting a lot more. Wear that fucking word out. Get the judge mad at you for objecting, because this guy sat a lot. He got caught fucking slipping, I think.
Is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Oh, check. Exactly.
Have you discussed
I panic
with the district attorney's office this case and your purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
Well, he can assert his own privilege, but that's kind of crazy.
Is there a objection to be heard?
Absolutely.
There's no
Sustained. Stay down. Next question.
Do you know whether or not your attorneys shared privileged information with the district attorney's office?
Ooh, ooh.
No, I don't.
Ooh, if D shared the privilege information, that ruins privilege. Uh-oh. That's a good one.
Know what my attorneys shared or didn't share. I don't know if they even met.
Last question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that.
You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
Why did you leave?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay.
Why?
And what was the reason for the partnership
Yeah.
or the fee-sharing arrangements?
You
What
fucking ripped me
caused
off.
the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I wanted to leave and go out on my own, yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I'm trying not to get into specifics. Was there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Miss Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So we had a disagreement. Whether the disagreement was, we disagreed. And so we dissolved, I left the firm.
Okay, why?
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you, we had a disagreement and
Just tell me what the disagreement was, sir.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with
Answer
this
the
Trump
question.
case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As a connection to Miss Willis, that's correct.
What? Yeah, okay.
Connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
I'm not sure what this correct means under that. You kind of got lost on it.
Yes, the
It did
question.
or did not relate to your representation?
It did relate to my representation.
In the marriage case?
It does.
And this was whose decision was, at that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I like to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I'll have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was.
They had a falling out over something.
So you continued representing him in connection with the divorce case after you had the separation that you've made reference to?
And he continued to, yes, and he continued to represent me on the construction case.
But the separation.
Okay, Chad, I accidentally broke the seal, so I got to pee again. I'll be right back. Sorry. Give me 1 second. All right. No, that's what your mom's mouth is used for. That helps me kind of find it. Like, helps me echolocate the edges.
At least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now, Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? I'm leaving that as the premise for what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, let's say that. I think we.
Would such information be privileged in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. So I'll sustain that.
So I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be we've already gotten an answer on that. Now we're asking the same question again. Ms. Merchant asked him a variation of that, and he already answered.
I think the variation, Your Honor, is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Because if it includes Mr. Wade, it is privileged communication. So therefore, the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Oh, no.
Impeachment at this point, but
that would not just be here.
That might be too fine a distinction for me to.
That would not just be here. Like saying it's automatically hearsay, bro. That's not true. That's not true. But I get it. That guy's fighting hard now because he understands they're on the precipice, and he knows better than I do how close to the edge is. But I have a feeling we're starting to we could put our foot and feel the edge of the cliff here.
See the need for the question. I think I'm failing to see the difference.
Well, I'm not asking respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the.
It's homie's wearing cowboy boots. Check that shit out. Mandeba. Wearing cowboy boots in court. That's you got a good attorney. Listen, wait, I can wear shit kickers to court.
Actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
so you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're
Reserved for
talking
the record.
about as far as the foundation about when things are said and what it's said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credible determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So, again, just to follow through to make sure. So if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified to.
And to that end, Mr. Sadout, that is something that you can, I've got this case from Ohio, but if you can find something more on point in Georgia before we schedule.
Other than the one I gave you.
The
1935 case.
The Atlanta Bottling Company. I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say that there's this alternative theory about fraud upon the court. But we can flesh that out in our research.
I appreciate that. Thank you.
Okay, Mr. Stockton.
No question, Judge.
Mr. Durham.
All right, Jimmy, you said this is the time.
No question, Your Honor.
Mr. Bryce.
Good question, Your Honor.
Okay. Apparently, you guys said we're getting a fucker walk time. All right, let's go. It's time for the money shot.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel for him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on it?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well?
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Okay. Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to him, to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Isn't adultery as a statute just on its face been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current.
Then it can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent that this witness has information both with the original interrogatories that were filed in December of 2021, and frankly, with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
Good afternoon, Ms. Bradley.
Good afternoon.
Been a long day. When did you sign your engagement letter with Mr. Wade to represent him in divorce proceedings?
It would have to be 2017, 2018. Same time frame, 2017, 2018.
So did you sign or have signed an engagement letter to represent him, or are you just speculating?
I can't recall. I mean, we were in a, we shared space. I can't recall if there was a contract or if there is a contract. I think there is a contract, but right now it'd be speculation.
Right now, sitting here, you do not know whether or not you had a signed engagement letter with Mr. Wade discussing the parameters of your legal representation of him. Isn't that correct?
That's not correct. I mean, I can't say I don't have my files or anything with me.
Well, sitting here, you do not have specific recollection or knowledge that you even had an engagement letter to represent him. Isn't that right?
I think I had an engagement letter, but I do not know specifically if I had an engagement letter.
Well, when did you open a file? Did you open when you represent someone, you open a file in your office? And when did you open the file on Mr. Wade?
I am going to object to the relevance of this line of questioning. There has been no dispute by the attorney or the client that there was an attorney-client relationship. And so I object to the relevance of
you don't
the circumstances under which
Yeah, and actually I'll bring this up because this was a question asked earlier. We need to address it because it does fit in this actually right here. Okay. Coop and Diamond's asking, does the lack of a contract change anything for confidentiality? No. I mean, if you don't have a written contract, if you were representing that person and that person believes you're representing them, no, you have an attorney-client relationship. If you call me on the phone and ask me for like a legal consultation, I say, yeah, you don't have a case, or like, hey, something happened. Is this a crime? And I tell you, don't worry about it. That's attorney-client privilege. That's protected. That's privileged information. Did I sign an agreement with you? No. Still protected. Cops can't ask me what we talked about. I could refuse to answer. So the fact whether or not they had it, I mean, that's just sloppiness and like whatever, but that's not illegal.
I think it can, because as Mr. Gillen knows, that's not a factor in determining whether there was a true attorney-client relationship.
Well, Your Honor, it's not just up to Mr. Wade and Mr. Bradley, it's up to the court.
I agree with you there, Mr. Gillen, and so I'll give you a little bit of leeway, but I don't think we can spend too much time on this.
No,
so
okay, Your Honor. Now, did you or did you not open a file in your law practice with Mr. Wade's name on it? Yes or no?
Yes, I had a file with Mr. Wade's name on it.
When did you open that file?
I'm assuming 2017, 2018. I can't tell you the exact date. I've said that 3 or 4 times.
Well, let's approach it from another angle. When is the first invoice that you sent to Mr. Wade for your legal representation?
I didn't send him an invoice in that capacity.
Yeah.
So what we have here is you're not knowing whether you even have an engagement letter. You don't know whether you actually even billed him, correct?
I represented Mr. Wade. I signed the documents that we filed. I filed the documents. There's depositions that I had with the divorce attorney that was representing his wife.
I'm sorry, sir, that's not my question.
Okay.
My question is, did you bill him in your capacity as the lawyer that you're telling him?
I don't recall.
As a matter of fact, did you have any invoices where you billed him on an hourly basis?
I don't recall.
And the answer really is no, isn't it, sir?
I don't recall.
And the reason why it's no, isn't it, is because what happened is that you and Mr. Wade were in a law practice together, and it was a very small work environment, correct?
It was a work environment, yes.
A work environment where you and him would meet and talk literally every day, correct?
Not every day, no.
Well, almost every day.
Not almost every day. I stated earlier that I ran one side of the practice. Mr. Wade did, and we rarely were there at the same time. I stated that earlier today.
So, well, just give us totally how much money you got for representing Mr. Wade in this since 2017 or whenever you told us up until you dropped off the case in 2023.
I don't recall.
Would the answer be zero?
I do not recall.
Well, you would know whether you got paid or not, wouldn't you, sir?
I do not recall.
So you don't recall whether you as an attorney got a single dollar to represent Mr. Wade, correct?
That's correct.
Because you really did it as a friend, didn't you?
No, I did it as an attorney.
Well, an attorney that wasn't being paid. You were doing it pro bono for a friend, weren't you?
I'm going to ask me.
All right. So I'm just saying that, Mr. Gillen, I think the law is clear that money doesn't even have to change hands for that relationship. I'm making a finding this has already been presented. Namely, the fact that he signed pleadings to the depositions on Mr. Wade's behalf that attorney-client relationship did exist.
Well, at some point, I was just laying the foundation of the circumstances in terms of the non-billing from the 2017 period and whether there was really an attorney-client privilege there. That's what I was trying to do.
Okay. If the dispute is just when it occurred, you can try to hone in on that. But the questions I've heard so far are more from you were never paid ever. It's from an overall angle.
Well, from 2017 until November of 2021, you didn't receive a dollar from Mr. Wade for your supposed or your representation of him, correct?
I don't have the file in front of me, and I do not recall.
Okay. And the reality of it is, as I mentioned or asked you a few minutes ago, is that it was a small firm and you were doing him as essentially a favor as a friend and as a law partner, correct?
No, I was representing him as an attorney. Were we in the practice together? Yes. And were we, or are we friends? I mean, we were friends at the time. Yes.
Well, you were friends and law partners, correct?
Yes.
And in a small firm, and I know because I'm in a small firm, people will sit around the office and talk about their social life and what they're doing, correct?
Yes.
Correct.
If that happens in your small firm, yes, yes.
Well, that doesn't happen, or did it happen in your small firm?
The witness has been asked very specific questions about conversations about socialization, and we've gone on through it, so I think this is asking actually.
All right, I'll answer this one question overruled.
Repeat the question.
Well, did you in your small firm have occasion to where people would sit around and socialize and talk about what was going on in their lives as opposed to merely talking about the law?
Yes.
And you had those conversations with Mr. Wade as a friend on a social basis, didn't you?
Objection, going back into the privileged communication.
Not yet, but it might.
I assume, yes, we talked about sports. We talked about, sports a whole lot.
You talked about life, and about what was going on in your life and what was going on in his life, right?
Right. Sometimes, very rarely, yes, sometimes.
And that is what you do in a small work environment when you know people very well and you do favors for them, correct?
Again, I'm going to object.
Yeah. All right. So, next question, Mr. Young.
Now, in that capacity, didn't you have discussions with Mr. Wade about what was going on in his social life? That had nothing to do with him asking you legal advice.
Objection, to be more specific.
I think he's just asked whether he socializes outside of legal
Pretty
advice.
specific.
So, I think you can answer that question.
I did answer the question. I said we talked about sports a lot.
And I'm asking, sports is one thing, the social life. Did you talk about each other's social life, like Mr. Wade, and who he was dating?
All right, so that'll be sustained on privilege.
Your Honor, just for the record, I would state that my objection would be that the privilege only protects communications in furtherance of seeking out illegal advice, not talking about something that might be personal or confidential. And that's the distinction that I would draw.
I think that's an accurate legal point. However, I think the witness has already been questioned and testified on this point. So, next question.
Now, you got in the fact that you were the initial attorney on the divorce case, correct?
That is correct.
Now, did you and Mr. Wade, without getting into discussion, did you and Mr. Wade together prepare his responses to the interrogatories which were filed initially in the divorce case?
I'm assuming we.
Objection. He's asking about the interrogatory responses, preparation of the case in the divorce case. I mean, that's all covered under attorney-client law.
Well, I don't think it's the attorney-client. Did they meet together? And when the interrogatory answers were filed, did he file them? And did he do that in concert with his client? There's nothing privileged there.
Did they meet and work together, and that work taking the form of them talking back and forth to each other on the right responses?
I'll change a little bit. Did you review yourself the interrogatory responses given in the divorce case?
I did.
And whatever knowledge that you had when you were involved in the interrogatory responses, you had the knowledge of all that material or information that you had without getting into the content. You had all of that knowledge and information. I'm sorry, let me get my question out before he objects. And when you filed those interrogatories, you had all the knowledge and information that you had obtained from Mr. Wade from 2017 up until the date the interrogatories were filed, didn't you, sir?
Okay, so that's
a big compound.
Follow-up question to that is going to be incorporating knowledge learned during communication. So
No, I'm not going to have a follow-up question. I just want to know whether is that the case? When he filed the interrogatory forms, he had all of the information that he had discussed with Mr. Wade from 2017 up until the time. That's it. That's my final question.
Okay. In which case, without doing that extra assuming link that he based his answers on those communications, it has no relevance.
Well, it does in the sense that it shows what knowledge he may have had when he, the attorney, is filing interrogatory responses. That's what it shows.
Okay.
It does.
I'm still not seeing the relevance of his knowledge as the attorney filing the responses, unless you're linking this back to
Well,
Mr. Wade.
it gets back, Your Honor, to whether or not, if you're an attorney and you're filing an interrogatory response, which you have reason to believe, or specific information to know that certain responses are not accurate, then you shouldn't be filing them. And now, so that's where I was going with that. So if he's got a body of knowledge over here that's built up from his communications with Mr. Wade that everyone so dearly doesn't want everyone to know about, in spite of the allegations made against Ms. Merchant. Now,
so what if the question was, did you when you signed your name to the interrogatories, did you commit any knowing fraudulent statement and submitting those to the court at the time? Would there be a problem with that statement or that question?
Well, I mean, I think that is a conclusion that others could draw, like the court. I just want to know that he had all that information at the time that he, as the attorney, filed the interrogatories. That's it.
We would object. This does fall under attorney-client, and he is making
No, it doesn't.
presumptions about when information may have or not have been disseminated to Mr. Bradley in his capacity as attorney. He didn't have to know about anything at the time of, and in the middle of, at the end of, or he may never have had that information. There's too much presumption associated with it. The whole matter is covered on his privilege.
One comment on that, Your Honor. We have spent almost a day talking about trying to block public the dissemination of what Mr. Wade said, either as an attorney or in any capacity, about his relationship with Ms. Willis prior to November the 1st, 2021. And questions about discussions in 2019, all objected to, the claiming the privilege. And
No,
now
well,
to say,
20%.
well, that doesn't mean that he learned something after. I'm talking about, what did you know at the time the interrogatories were filed? And everything now they're claiming privilege. Well, that's fine. The court will address that in chamber and in due course. What did you know?
I'm sorry, Mr. Gillen, I really don't see the distinction. So your question's noted for the record and your objection as well.
All right, and I'll follow up with this. Now, you're leaving removing yourself from the case, the divorce case, correct? You withdrew from the divorce case, correct?
Correct.
Did you do that as a result of your concern about any of the accuracies or representations which had been made by your client in the divorce case?
No.
Objection. Privilege.
Okay, so that's going to cover communications during the relationship?
Well, Your Honor, hypothetically, not saying this is the case, hypothetically, if Mr. Bradley, knowing, let's say hypothetically, that he speaking with Mr. Wade, was aware that the intimate or personal relationship, romantic relationship, existed prior to November the 1st, 2021, and started in 2019 or 2020, if he's armed with that information that he's obtained from Mr. Wade, but Mr. Wade would want to insist on responding to interrogatories which were contrary to the information that Mr. Bradley would have, then I'm asking him whether he took steps as an attorney to say, I cannot be a part of that or countenance that, therefore I'm withdrawing from the case.
Sure. I still see that as covering their communications.
Yeah, that does.
So I'll sustain that objection.
All right,
Yeah.
thank you, Your Honor. That's all I have.
Thank you, Mr. Gillen.
Thank you.
If he asks
Mr.
you to
Contreras,
break
you
the
still with
law
us?
is a bit much. I get it, though. I get it. That's a very good question.
Anyone on behalf of Mr. Floyd still joining us? All right, moving on. Mr. Cromwell.
Two brief questions, Your Honor. I think everybody's exhausted with my question, right?
Let me go, Mr. Bradley. When did you withdraw from Mr. Wade's divorce case?
I don't have it in front of me. I don't have the file.
Was it sometime in 2023?
No, agree. See, I left in 2022. It could have been anywhere between July of 2022 and maybe December of. It wasn't. I don't have the accurate date, but it wasn't when I left, and it wasn't.
I'll make it easier.
Okay. All right.
You were not his divorce lawyer at the time the interrogatory responses were filed in May of 2023. Is that true?
Oh, no, I was not. Okay. Yes.
And as of today's date, Mr. Wade is still a married man. Would you agree?
I haven't kept up with the divorce proceedings, but I think they're still open.
So, and if they're still open, that means he's still a married man.
Yes, that's correct.
So the fact that in a pleading, there's a reference to the marriage is irretrievably broken, that doesn't mean the marriage ends, does it?
But I guess you have to ask the judge that's handling the case.
Well, it doesn't end until there's actually a divorce decree signed by a judge. Would you agree?
I would agree.
All right, thank you.
Okay, Ms. Cross, were you taking?
I am, Your Honor, and I'm going to have a minute. My cross-examination might be a long one. So we can go for an hour and a half. I have just a 5-minute break.
Sure. All right, we'll be back in 5.
You have to
Oh, this is- Yeah. Are you gonna take that down? You're gonna want him to put your shoe back there?
That's interesting. Okay. Ooh. Who is Bradley's attorney? Bradley's attorney is that guy right there. That's Bradley's attorney. That's this dude. Okay? So he's talking to her like, what are you going to do? Are you going to fuck my guy on privilege? What's going on here? Okay? I'm still not, guys. I also apologize. I am not looking at super chats right now because I don't want to be spoiled. So I'm sorry about that. Oh God, I got the fucking. You gotta trim up. We're gonna catch up. We're gonna catch up later. Okay, guys. I'm sorry, I can't do it now. Well, I'm not. I'm just reading some these quotes or these comments real quick. Why are you yelling? Why are you yelling? Why are you running? Yes. Yes, this is my first hearing of this. So here we go. All right, chat. And here we go. I'm not going to respond until something happens.
Presented, do you anticipate calling any further witnesses? All right.
Oh, hold on here. Hold on here.
Mr. Bradley's testimony was presented. Do you anticipate calling any further witnesses? All right.
Also, defense witness. All right, here we go.
Housekeeping.
Yes.
Okay. Ms. Cross.
Thank you.
Here we go, chat.
Mr. Bradley, have you still got the exhibits 23, 24, 25 there in front of you?
I do.
And 23, that's one of the contracts for your personal LLC or PC, your personal legal entity, right? For the district attorney's office? Yes?
Yes, that's correct.
Okay. And I understood your testimony to be that any income that came into the partnership, when I say partnership, let me be more specific. You had an individual legal entity. Mr. Campbell had an individual legal entity. Mr. Wade had an individual legal entity, but y'all had a partnership agreement, right?
Yes, but we didn't have that the entire time.
There was
Yes.
a period of time that we've been talking, or that we had talked about in 2022 prior to leaving the firm, that there was an actual entity for the three of you, correct?
That is correct.
And that was roughly during the time period where y'all bought a building together.
Yes, correct.
And it made things simpler, or for whatever reason, you decided at that time that a joint entity made sense to own that building, right?
Correct.
Okay. All right, but those contracts there, they're not with the joint entity, correct?
No, they're not.
Those are all with you individually, is that right? Can you take a look at 23, 24, and 25?
Yes.
They're all with you individually?
Yes.
Okay. 23, what's the hourly rate that you were being compensated? I think that was the first appearance.
23 is the, I don't think, no, 23 is not the first appearance. 23 is the taint, it says.
What's the hourly rate on that contract?
$150 an hour.
$150 an hour? All right. So the $150 an hour, the way I understand you all shared profits was you get 50, Mr. Campbell get 50, Mr. Wade get 50, and then y'all pay expenses jointly as well, correct?
Correct.
All right. What about exhibit number 24?
It seems to be the same.
Same amount?
I don't know if it's the same amount.
I'm interested in the amount. Can you tell me the hourly rate?
The amount was $65 an hour.
$65 an hour?
Mhm.
All right. That's not a particularly high rate for an attorney in the Atlanta metro area, correct?
No, it's not.
All right. Was that a government rate that you were willing to accept at that time?
Yes, that is correct.
All right. And so the $60 you're getting for that contract, again, that's split 3 ways, you, Mr. Wade, and Mr. Campbell, correct?
That is correct.
So when you were being
Minus
asked,
expenses and stuff like that. but yes.
exactly. That was the income, and then expenses come from that, and then profits, whatever's at the end, correct?
Correct.
All right. So when you were being asked questions about Mr. Wade, I think the phrasing, I object to, but I think you might recall the question. Mr. Wade brought you this contract, or Mr. Wade got you this contract. Do you remember those questions?
Yes, I do.
All right. So we're talking then about the split among the 3 of you of about $20 a piece, right? For that particular contract?
For this one, yes.
All right. What about 24? You got 24 there? I'm sorry, 25. You got that in front of you?
I do.
What's the hourly rate on that one?
It's 150.
150 on that one too? All right. And the same sharing went through the business, the way you handled that contract as well, right?
That's correct.
All right. Who is Austin Dabney?
He was a probation officer that passed the bar, and we hired him and another individual. The other person didn't stay long.
And did Mr. Dabney and the other legal associate that you all had working for you at that time, did they do some work on these first appearance contracts?
Yes.
And that was a pretty good position for a younger lawyer to be sent to get some courtroom experience, correct?
That is correct.
All right. 2020, you're aware that Mr. Wade had a serious illness during that time?
I'm aware.
And you and Mr. Wade, I think you described your relationship in a lot of details earlier about specific circumstances. But you were business partners in, let's say, up till the time you left in summer 2022, correct?
That is correct.
You were business partners up until that time?
Yes, I said yes, that is correct.
Okay. And while you didn't socialize together frequently, you considered yourself a friend of Mr. Wade at that time?
Yes, we were friends at the time, yes.
All right. You are no longer business partners.
That is correct.
You are no longer friends.
I mean, if he's saying that we're not friends, then
I
yeah.
want to know what you think, Mr. Bradley. Do you consider yourself a friend of Mr. Wade?
I'll consider.
It goes to potential bias. This cross.
Would I consider myself a friend of Mr. Wade?
Mm-hmm.
I would.
Are you sure about that?
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm. The firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. You recall answering questions as though you left due to a disagreement. Yes?
Yes.
Oh.
And that disagreement was that there was an allegation of sexual assault by an employee made against you, correct?
That is incorrect.
There was not an allegation that you that you sexually assaulted one of the employees in the firm.
Kind of figure it's going to happen. Why are you going down this road? This is a guy who's using his privilege and is doing his best to shield the fuck out of one of your people, and now you're starting to fuck with him. Why are you doing this? Why are you doing this? He hasn't hurt you so far. He's been very helpful. Literally, the fucking DA's office is fucking stepping on a rake right now for no reason. Why are you doing this?
That is incorrect, but yes. Yes.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, that was an allegation, yes.
And as a result of that allegation, you left.
I did.
and you were no longer business partners with Mr. Wade.
That is correct.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that. They did leave the building, of course, and I don't know. Some employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is
Ooh.
That is
How the fuck do you know
that
that?
is incorrect.
Unless Wade's
as far as
them
what
off.
was- no.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
Why?
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you sexually assaulted her?
I never signed any, I never gave any money. I left the money in the escrow account. What happened to that money? I can't, I don't know what happened to it.
For what purpose did you leave the money in the escrow account when you left the firm?
I left the money in the escrow account.
For what purpose, sir?
Wade, why are you fucking your friend over? Literally, because like now you're giving him all incentive just to fuck you dry. Yeah, you could sue him, and yeah, you could hold his feet to the fire with allegations. But this guy was like 10 toes down. They boxed him in, but he answered the questions he had to answer. Now all of a sudden, this attorney's coming in trying to fuck him over. Why would you help them do this? Unless they're like, I hope to God they were trying to send a message to her saying like, no, don't do it. Call off the hit. And she's like, I got a green light. Bop, bop, bop. Because that's what she's doing right now. Fuck that text message. This is not, no. Why would you do this? Why?
There was no purpose.
You just left the money in the escrow account?
Yes.
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my attention? Why did you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
I didn't hand any money. It was money from my escrow account, to my knowledge.
To your knowledge, where did the money in the escrow account go?
To the employee.
To that employee.
20 G's? He definitely did something. I'm just saying. You don't hand out 20 cents for no reason.
Was there one allegation, or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
Just one incident.
There were not two.
To my knowledge, there were not two incidents. No.
I'm asking for incidents that you have been involved in. Were there two incidents where you sexually assaulted this employee?
No. I
There's
didn't
only
sexual
one?
assault anybody.
Was there another occasion where you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
I don't even know that name.
You don't recall a client named Anna Rodriguez?
Anna Rodriguez? No, I do not.
Oh my God.
Never met her.
I do not recall the name Anna Rodriguez.
Pardon me, Your Honor, I would object to this. I'm not sure what we're trying to do here. So I would object to this line of question.
All right, Ms. Cross.
Your Honor, this clearly goes to the bias that the witness has towards Mr. Wade and other individuals, his motive in involvement. And I believe it's an appropriate avenue to pursue based on exploring his credibility.
At some point, though.
I'm not
Well,
going to go much further.
okay.
Judge, if this is allowed to continue in this way, it does here a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not?
That's what I was gonna do. Don't do that yet. Sit on it. I think she's already done that.
Your Honor, I'm asking in all seriousness, that privilege, although.
Yeah.
Based on the answer right now, I think now we've opened up a hole.
We opened up a hole and drove a fucking Mack truck through it. Like, this is like Optimus Prime doing some goatsy. Just, ah! It's like the mountain just stepped on a little kid's tent. Just, boom! Holy Jesus Christ on a cracker! There's so many people in that courtroom shitting their pants right now. And the defense, I guarantee you, like, they kind of like, I guarantee they're looking at each other like, what the fuck? The prosecution team is stabbing. This is like a civil war breaking out. And the other side's like looking at the battle like, what the fuck are you guys doing? I mean, holy shit.
Area. What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the run. So, Ms. Cross.
I'm finished.
Okay.
I'm finished.
Stay down.
What was the point of that? I'm finished. Fanny told me to go do a hatchet job. I just did that hatchet job. Like, and now Fanny's going to fucking prison. Because guess what's going to happen on that in-camera hearing? Ooh, Lord child. Unless we blow open the doors right now. Oh, my God. Oh, my God. Oh, my God. I'm really like, listen, I'm not the dumbest fucking guy in the world. I promise you, okay? I promise you, like I promised future Mr. Martin 2.0. I am not the dumbest fucking guy in the world. But I'm also not the smartest. What fucking purpose did all of that serve? Cross just came in there and fucking executed that guy in front of the world. About blew the doors off privilege, and I think it happened. Why? Why would you fuck this guy over? I mean, I don't fucking get it. I get it. Fanny and Wade are fucking lunatics, and they're just, the moment they think you fucked them, they kill you. They're like it's like in The Departed, where Costello's losing his fucking mind. Everybody gets clipped. But you can't fucking do that. You clipped a guy that was like, you came at a guy, it's like Sammy the Bull Gravano. John Gotti came at him. And guess what? He fucking flipped. Sushi Nita said, I watch this just for hours to see this reaction from you. Thank you. My night is made. Like, I know, I don't fucking get it. Why would you do this, though? You've got it in the bag. Like, there's still a good chance Fanny survives this intact. There's still a good chance she's running the case. Fucking A. You know, yes. You know, congratulations, you arrogant ass. You killed us. She just fucking launched a torpedo at herself. Oh, God. Okay, well, look what happens next. All right. Holy shit. They're not morons. She was Cross was a good little soldier. She had marching orders and she fucking carried them out. She got told stack a body. She stacked a body. So fucking A. And now here comes Sadow, which here, you guys need to see this because J-Rock is an attorney down that way in Hot Atlanta. So look here are the comments. Steve Sadow, excellent defense attorney, one of the top attorneys there. He is hardcore. He's a great defendant on a multi-defendant joint case. In a joint case, he's great. If he's not, you're fucked. Okay, so look who's walking up to the stand, unlimbering his fucking ball sack. That's what you're seeing right there. Look at him. Dude's got the fucking, I'm surprised he doesn't walk up like I'd walk up like fucking Vince McMahon and Conor McGregor. Why not? Oh God, this is only going to be good, I'm sure. Whew.
You were accused by Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Who accused you? Did Mr. Wade not, based on the questions we just asked, did Mr. Wade not bring to your attention the sexual assault allegations?
Ask that again, please.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney, and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
I object to that. I don't think that's factually true. I don't know that that's not, I know that that is not legally true. The attorney-client relationship is of a matter. It is not vitiated by other instances or anything outside that matter.
Then why did you go down this road? What did that serve you at all? You threw a bunch of landmines down and then you didn't mark your path for some reason. Or you wanted the forbidden tuna. I don't know, honey. But you did it. Now it's there. You baked the cake. You got to eat it.
I'm not sure that...
Look at these guys. They got shit-eating grins on right now. They know what's about to happen, apparently. She's writing on notes like, oh my God, they just fucked themselves in the ass with a shovel. I guarantee you it says something like that. LOL. Or maybe Ashley Merchant uses cack. Cack. I don't know. But those aren't people who look defeated right now.
That's accurate. He was accused by Mr. Wade, his client. Do you mind if I speak? I allowed you to speak. Mr. Wade accused this gentleman of misconduct in the performance of activity while he's an attorney working with Mr. Wade and representing Mr. Wade. Those allegations of misconduct open up the question of whether or not he can defend himself by now discussing his confidential communications with Mr. Wade in connection with the representation as well.
Remember, Rule 1.6, we talked about this. You can defend yourself based on what your client tells you. If you need to defend yourself, you may. It's not mandatory, but it's discretionary.
As the allegations. That's the position of the defense.
Understood. So what is the question you're putting?
My question I'm going to ask you now is, tell us what Mr. Wade told you about when he began his relationship with Ms. Willis.
All right. So where I think we are with this is that Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. When asked by the state, he went into a factual scenario that to my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this entire time. And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. But is there anything else though that you were going to cover other than this issue?
No.
Ms. Cross, any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question, and I don't believe that's factual, though there was an employee who accused Mr. Bradley of sexual assault.
Okay, but regardless though, the point is that the circumstances of his departure from the firm, from what I've now heard,
Were
has
facilitated
nothing
by
whatsoever
Wade.
to do with his representation of a divorce. Is that fair?
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related, I can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay.
And why would you cause that to happen? You walked up and went up to the blanket of privilege and just ripped it off the wall. That window was blocked, and you walked up there, no, I'm going to fuck him. I'm going to call him a liar. So now Nathan Wade's out in the open. Unless Fani just sold Wade out, which I could see because these guys are assholes and they're going to start panicking and selling each other out. I don't know. I mean, that's the only thing I can think of at this point is Fanny's cutting Wade loose. Why is she proud of herself? Because she was told to do a job. And like a good little soldier, she did the job. Kill this now. I guarantee you Fanny said we're hanging. I guarantee you there was a discussion. We're hanging Nate out to dry. All right, what do I do? She didn't violate the rules or ethics here, so she blew it up. My God. Yeah, she's just realizing. Yeah, I called him a liar. I think I don't know. I think she's like, oh, unless she backtracks all of a sudden, I think that was her job. Yeah, he was using privilege to protect them all, and they fucking killed him. The one guy who was still trying to be a team player, and they killed him. It's a problem with conspiracies, man. When you run a scam, it's got to be rough. Got to have good people.
All right. Other than this issue, which I think we've covered at length, was there any other questions based on Ms. Cross's examination from other defense counsel?
No, Judge.
Okay.
No, they're all good.
All right. With that understanding, can this witness be excused, Ms. Merchant?
Yes, Judge.
All right. So, Mr. Bradley, I would ask, I don't know if we may be able to do it today.
I'm sorry, because I don't think I could excuse him. Mr. Sadow had reserved the rest of his cross for after you determine the privileges.
Right. What I'm about to say just logistically is, I'm trying to do this, if we can conclude this hearing with the exception of that in-camera hearing, we end for today. And if as a result of that in-camera hearing that I learned that we need to reopen the evidence, then that's what I'll do. So to that end,
so if we have to come back for another day, then we know the story. That's the spoiler.
I can give Mr. Bradley instructions that he's to report back if upon order of the court, but otherwise, is there anything further the parties need from him today?
Not contended, I wanted to get those certified.
I know there's other housekeeping things and things we need to do.
And based on the testimony, we do have another witness, Your Honor. It doesn't involve Mr. Bradley
Right.
requiring to be here.
Okay, so now the state does have a witness.
I do.
Okay, all right. In that instance, okay, Mr. Bradley, you can sit down, sir. However, I'm giving you the order to stay in touch with your attorney, and then we're going to have to find a time to meet again and go into the camera session. Do you understand, sir?
I do.
Okay. All right. Thank you, sir. Step down. Mr. Chopper, do you have a card for me?
I do.
Okay.
At least I hope I do.
Gotta have your cards on you, kids.
I'm the worst lawyer on earth. I usually just tag bus stations with my
You can
name.
write down your contact information for us.
I will.
All right. Ms. Merchant, do you have any further witnesses?
That happens though. Sometimes you run out of
Okay.
cards.
Your Honor,
What we got?
on the issue of the Bill Sawinski, the 1006 versus 611, we're not going to call him. We think the chart, the foundation of the Sawinski chart is sufficiently in evidence, and we can just use the chart during argument under a 611 demonstrative.
Okay. And any objection to this entry as a demonstrative, Ms. Cross?
No, Your Honor, given the parameters we discussed earlier.
Okay. Can we go ahead and mark that an exhibit and make it part of the record in advance of arguments? Since I don't know when we're going to be able to have that scheduled. I think this would be Defense Exhibit 28. Let me go down the order just so we're staying organized. Ms. Merchant does not have any further witness. Excuse me. Ms. Merchant, on behalf of Mr. Roman, has no further evidence. Mr. Say-Down.
Your Honor, we are in the process, if the court will allow us to obtain certain phone records, and we'd like the record kept open for the introduction of those phone records. We have them in draft. I say draft, we have them informally, we do not have certification. And they will deal with, remember I asked Mr. Wade about certain activity down in Hapeville during the time period, and it deals with that specific time period. So we're talking about February to March of 2021 to November 1st.
And is it your intention that you would want to introduce these solely as an exhibit, or do you think that this should reopen and bring us back for an entirely new evidentiary day with witnesses?
I think that we would want to, if what we believe is there, based on our preliminary research, is there, we'd like to reopen and be able to introduce the records and someone to explain what they mean.
State certainly, I'm sorry, were you finished, Mr. Sagan?
I believe so.
All right.
State would certainly have an objection to that. This hearing has been set. We haven't seen the records. I don't know if I have any objection to what they are. But the day has been set for quite a while. We object to leaving the evidence open for any purpose.
Okay. And Mr. Say, how did you first go about trying to obtain these records?
I think, I know it's also the Delta records. As soon as we got a hearing date and the state's response, so what happened was when the state responded, I think it was February 9th, and admitted to the relationship, but put parameters on the timing. I said some subpoenas out in response to that, so that was February 9th. Problem is Delta, AT&T, all these folks aren't super fast about that. And so I know Delta, we're also waiting, I wanted to remind the court, waiting for those records to be submitted in camera. And AT&T actually emailed me these phone records yesterday morning on the way to court.
Okay. All right. Any further exhibits that are self-authenticating? If counsel are able to provide those, obviously serve those on opposing counsel, and then before sending them over to us, let us know whether they would be tendered with or without objection, just purely on authentication or hearsay issues or relevance. We can make those part of the record and all reserve whether this reopens a full hearing format, but the exhibits themselves I'm willing to have come into the part of the record, but there will be a cutoff point very soon, as soon as we schedule argument. All right. Any other evidence, Mr. Sadow, then?
No, Your Honor.
So that would be cell records. Mr. Stockton? Any evidence? All right. Mr. Durham, if you're still with us?
No, Your Honor.
All right. Mr. McDougald?
Certified copies I mentioned to Your Honor yesterday, Your Honor.
Okay. And why don't you lay those out for the record?
They are marked but not yet numbered. I believe our next exhibit would be 29.
28, I just said, was Mr. Gillen's demonstrative, just so I'm keeping it straight.
And so I previously provided these to the prosecution. 29 would be a certified copy of County Code Section 2-68.
30 is a certified copy of County Code Section 2-69. 31.
Yeah, over 500 people watching, guys. Thank you so much for being here. I appreciate it. Everybody over on Twitch as well. Thank you guys so much. For those of you hanging out over there still. Like I said, guys, if you like this over on Twitch, give me a follow or, just however you want to do it over there. Guys, if you're here on YouTube and you like this so far, please give me a like if you appreciate this one so far. And if you haven't subscribed yet, please subscribe. Look, I'm not going to say I spaz out all the time, but I try to give you guys all the knowledge I have and try to, because I love talking about this shit. It is cool. It is interesting. And it's interesting how this is playing out on the national stage. I mean, this is so cool. But yeah, please. Looks like we got more to go, chat. So here we go. Yeah, 510 people watching here on YouTube. Thank you. On a Friday night, Saturday morning, 12:25. Happy Saturday, everybody. Hold on real quick. Baby, happy birthday. Love you. Future Mrs. Martin 2.0's birthday officially. And I didn't really power level because she already told everybody. So here we go.
Is a certified copy of County Code Section 2-79. 32 is certified copy of County Code Section 10-114. 33 is a certified copy of County Code Section 10-115. 34 is a certified copy of County Code Section 102-464. 35 is a certified copy of County Code Section 102-465. 36 is a certified copy of County Code Section 102-466. And 37 is a certified copy of a emergency motion by non-party deponent for protective order filed on behalf of D.A. Willis in the Wade divorce case.
Okay, Ms. Cross, objection to defense exhibits 32 through 37.
I object to their relevance, and I will take opposing counsel's representation that the pleading is.
So, guys, we don't have all of those, but I got the one that matters. 102-466. Here we go. What does 102-466 of the Fulton County Code talk about? Well, chat, you may ask, Sean, what does it say? Gratuities and kickbacks. Like I said, a kickback, it shall be unethical for any payment, gratuity, or offer of employment to be made by or on behalf of a subcontractor under the contract to the prime contractor or higher tier subcontractor or any person associated therewith as an inducement for the award of a subcontractor order. And a gratuity, it's unethical for any person to offer, give, or agree to give any employee or former employee or any former employee or former employee to solicit, demand, accept, or agree to accept from another person a gratuity or an offer of employment in connection with any decision, approval, disapproval, recommendation, preparation, or any part of a program requirement or a purchase request, influencing the content of any specific specification or procurement standard, rendering of advice, investigation, auditing, or in any other advisory capacity in any proceeding or application, request for ruling, determination, claim or controversy, or other particular matter pertaining to any program requirement or a contract to or subcontract to any solicitation or proposal thereof. So the Fulton County government has its own code. Like I said, people want to know what to call it. It's called a kickback. So I explained good. Well, thank you. Carlos says, I want more spurging out, bro. Thank you. Glad to support. Thank you, Carlos. 14 months. I appreciate it. Oh, God. All right, guys. Don't call it a kickback. Don't call it a kickback. It's been graft for years. Yes. Whew. Called some LL Cool J there. But let's get to the rest of this chat. I want to say, I'm holding off on the super chat. Should I wait or can I read those now? If the DA's office is sexual evidence of sexual assault, why don't they charge him with the crime? I know. Fanny's going to get me too. That'd be hilarious. Next witness. Keep going. I can read them now? Read them? Okay, we got to read up. We got to catch up on shit here, guys. Sorry. All right. Reformed Convict sent me $2. Sent you a screenshot of the judge on DMs. I did. We saw that. It was great. Brandon said it's about to get lit in 3 hours. That's about correct. Yeah, just shy. Welfare check for Clyde. All right. Let's go. Brandon says you have to admit the amount of attorneys in a room like this make you yearn for a cold shower. I every day, man. These are my people. These are my people. Brandon again for $4.99 says, remember when they asked for sanctions because they never spoke? How are they not defrauding the court? Well, they could claim we did. That's what our clients told us. They've got a decent enough out, but yes, this makes them look really bad. Charlie says, do I like the Grand Tour? Yes, I do. I didn't know there were new episodes coming out, though, but yes, Grand Tour is beautiful. I love it. And it's sad because you're watching those guys get so fucking old, and I grew up watching them. It's like weird because they're my dad's age. Let's go. Brandon for $4.99 says, have you ever seen the prosecutor fight so hard to obfuscate, hide, and conceal facts? All the fucking time. All the fucking time. This is them every day. You just happen to see it on a massive stage. Reformed Convict for $5 says, in my experience, a steel car antenna is way better than a baton. It's a life-altering moment for those lashed to bring color through clothing when justified. Yes. And also, if you take a car antenna and you bend the bottom end of it, it's a great window smasher because it'll just glass windows on a car. It'll just crush automotive glass. Squizgar says, hey, Sean, I'll give you a summary of Fanny's testimony. That's not true. Yeah, that pretty much was Fanny yesterday. All right. Coupon 9. Okay, here we go. I told you I'd get to this. If a lawyer's information from a previous client, but no information about that client's later statement, but later finds out the client's fraudulent statement was bad, wouldn't the lawyer have a duty to candor to the court the instant they learned of the fraudulent existence of the fraudulent statement's existence? If it's all said and done, no. I would argue it's a former client duty at that point. And the candor to the court, he didn't perpetrate a fraud, because that's a former client liability. I don't think you have a duty to act at that point. I don't know, J-Rock. Normally if you make me feel like I'm getting ethically right on things. I don't know how you feel about that one, or Old Line Road, I know you're out there too. McKinley, whoever else is out there. I think there's a bit of an issue there about whether or not that's the right answer. So, yeah, Old Line says, and yet another they get shut down on. Okay. Yeah, we'll get to that though. But yeah, that's kind of where I'm stuck on this. It's a good question though. I mean, I'm initially wanting to say I don't have a duty at that point. Coupon saying, but can you not be accomplice of fraud through an action? I get what you're getting at here. Yes. But it's not necessarily through omission. I have different duties to my clients, and this is a former client. Remember what I said? former clients, your duty kind of withers, like the duties wither away and atrophy. So I don't think you have that same duty anymore. But I'm not 100% sure on that. I mean, is that something I would talk to a bunch of attorneys and I would talk to a lot of people to make sure I have the right answer? Because I am not going to lie, I would not want to risk my ticket on that. Because number one, I don't want to risk like bar discipline, but I also wouldn't want to risk my reputation on a poor reading of it. But I mean, like, I'd probably talk to a judge or two and ask them if they had an idea. So, Jim is saying, okay, the fraudulent interrogatories, yes, but we're not talking at that point. I agree. I think those interrogatories then were fraudulent because it sounds like it. And if he didn't sign it, he signed it for someone, so someone helped him suborn that fraud, which is likely Nathan Wade. So yes, I agree there's a crime fraud issue there, but I'm not sure why they're tying that up, or they're waiting to see the results of I'm betting the results of the in-camera thing, if they have to come back for round 2, Sadow's gonna fucking light him up on that shit. So Justin, I think you're an attorney too, aren't you? What do you think about that issue? Cooper's saying, do you have a constant duty to the court even if your former client is withered? I mean, there's a limit to that. Like, how much do you have to do? I mean, yeah, I have a duty of candor to the court, but I think at some point there is a bit of a. I think there's a bit of a attenuation at that point. Well, at least that's what I would argue. I mean, what do you think? So, Justin, what do you think about this whole idea? At some point, if you so let's say Brandon later learns that Wade had said all this shit that's wrong, does he have to come back and correct it? Does he have a duty under the candor of the court? Yeah, with the former client. Okay, if you guys have an ethics hotline, yeah. And if I could call the professional conduct people down in Columbus, I probably would. The other option is if you were to go to an ethicist. So there are lawyers who are kind of like ethics scholars. Generally, they're professors. You could get them to write you an opinion, and you could rely on that if it's well enough put together. So yeah, I would question if the court calling you on the matter itself is not enough to revive any duty of candor. Yeah, but remember, like I said, this is you are asking some questions here. This is stuff that a law professor would ponder to the students, and because it's not like there's not a clear answer. This is actually like a really good essay question, believe it or not. You could write out, on the other hand, boom, 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 forever. So that's a really good question. I'm an engineer, not illegal anything. I just like taking apart systems. Oh no, I get it. I appreciate that. So I appreciate that. No, it makes sense. It's a good question, and I don't know the answer to it. And now I'm thinking about it. So thank you. Arden for $2 says this firm's accountant must hate him. I doubt they're using an accountant. Unknown Hero for $2 says Sean is gonna come. I just about did. Dougie Fresh for $2 say, why would he say a essay was privileged? Because, and that's the judge's point. He's like, does this guy even know what the fuck privilege means? The judge is really concerned this guy just kept doing it. LA gang or lagging for $2 says Snape kills Dumbledore. Read another book. That's a shame, says I'm sure he did, maybe. I don't recall. It's a beautiful answer, yes. I have no recollection of that event in question, Senator. Is not a bad answer. Look how many people use it. Jim Cox says, gifted 10 memberships. Thank you. Whoever got one of those, I'm sure is very happy. Unhung Hero says, Bruce Willis is actually dead in The Sixth Sense. Thank you for ruining that for me. Darcy for $20. Thank you, Darcy. Saying, did this start with a scorned woman getting a divorce? Holy cow. Yeah. For want of a horse, well, there's also, a scorned woman in all that, but for want of a horseshoe nail, a kingdom was lost. The littlest embers, The biggest forest fires start with a single ember. So, yeah, it's amazing what can go. This is the butterfly effect on fucking steroids. He looks buck broken. He did, yes. Alpha said, put a pin in that has nothing to do with Bradley's conduct. Yeah, well, Jesus Christ. I don't know where that came from. Jack is for $1. Thank you. Lagging for $2 says Soylent Green is people. Why are you ruining the world for me? Lagging for $2 says Darth Vader's Luke Skywalker's father. You know, I'd ban you, but you put super chats in, and I'd feel bad about that. Garrett for $5 says for the cleanup fund. Thank you. Stacy's like, call off the hit. That's what I think. They're like, why are you killing this guy? J-Rock saying this is the guy Gabe Bank talked to and accused Gabe of tampering. So Fanny accused Gabe of tampering. I kind of forget how Gabe plays into this. Unhung Hero says that's some Optimus Goatsy. Yeah. Eric V for $10. Thank you, Eric. Is saying for your coverage and a live reaction. Thank you, Sean. I've rewatched this all night. Best reaction by a lawyer yet. Well, thank you. Unhung Hero for $2 says she went in raw with no lube. Yeah. Well, to be fair, she sat down on her. She went into Fanny's ass with no lube. Like, she just saw an ass sticking up in the air, so she shoved a rake down it, and it turns out it was Fanny, not or Fani, not Bradley. So she fucked Fanny here. I don't understand why. Egalitarian says for $1.99, does the essay stuff hurt Trump or Fanny? Well, I mean, Fanny's gonna be like, no, like Fanny looks like a massive piece of shit now. So I don't see how this helps her. The Mr. K says, this is where I learned how to derail trains. Yes, it is. We've talked about that before. We're talking about all kinds of great stuff. Legal stuff, you know, little Minecrafty stuff, all kinds of great things. Mr. K for $10 says, I hope the edging is worth it. Not what you expected, I bet. No, I didn't actually see this as the road we were going down, but why? Wow, that was a big twist. Like I can't imagine that expecting that. That had to catch them off guard. But thank you, Mr. K. And that's for 10 Australian dollars. It's a dollary due. And Shree for $19.99 says, happy birthday 2.0. Well, thank you, Shree. We appreciate that. Squizgar says, hee, you said duty. I know. Ford Convict says a 2.0 isn't limping in the morning. You are a failure. Challenge accepted. That's a shame for $1.99 says, I have only read and will only ever read 7 books. Oh, God. Oh, my gosh. Oh, my gosh. All right, guys. Hold on here. I'm trying to clean stuff up. Give me 1 second. All right. Okay. So you guys had a bunch of comments here in the meantime. I appreciate you chasing us down with me. Hey, it's a good fucking questions. That deserves some discussion. Old Line Red says, why is Fanny making us go back to law school? I don't know. But like I said earlier, we had to figure some stuff out. Let's see here. Sean owes you a whole lot of lip service. Has been over 500 viewers for a good bit. Oh, I know. Yes, fisting Fanny. She fisted herself here. Keopathic says, Rhodes, we're going to need a boat with all this blood. Yeah, pretty much. Pretty much. My God, that was awful. So, yeah, let's keep going. Let's keep going. Yeah. Oh, 497 here watching, guys. Thanks for sticking around. 42 still on Twitch, guys. Appreciate it. So let's go. Let's go, chat. Here we go.
Complete and accurate as it was filed, and object to the relevance of that as well, but not the authentication.
Okay.
All right, we'll note the objection for the record and we'll admit them for whatever way they do. So defense exhibits 32 through 37 are admitted. You can hand those to Madam Court for. Any further evidence, Mr. McDougall?
No.
Okay, Mr. Rice.
No, Your Honor.
Mr. Gill, the demonstrative 38 or 28? Okay, and do you have a physical copy for us already? Great. All right, do we still have Mr. Kuchura with us on Zoom or anyone else on behalf of Mr. Floyd? So he's not on any longer? All right, I'm being informed that he dropped off Zoom, and so I'll make a finding that he voluntarily has absented himself from this hearing. Mr. Cromwell?
No evidence, John.
Okay. Ms. Cross, back to you.
If the defense presentation of evidence is done, I'd ask that all of the witnesses who had been subpoenaed but not called now be released.
I think that's fair. Ms. Merchant, any reason to hold on any of those witnesses?
No, Judge.
Okay.
And the state has 2 short witnesses, and that's it.
Okay, you may call your next witness, Ms. Cross.
Next witness for the state is Austin Dabney.
Your Honor, these witnesses are going to be
Impeach. Did they impeach the testimony, Mr. Dabney?
on collateral matter. We'll wait.
Yeah.
Okay.
Who's this guy? Thank you for joining us here, buds. Appreciate it.
Yes, my name is Austin Dabney. That's AUSTIN DADNEY.
Good afternoon, Mr. Dabney.
Good afternoon.
I want to direct your attention, well, first of all, how are you employed?
I am employed right now. I have my own firm.
You're a lawyer and you've got your own law firm?
That's correct.
All right. I want to direct your attention to 2021, 2022. What was your employment at that time?
Yes, I was employed with Wade Bradley Campbell firm.
And that's Nathan Wade, Terrence Bradley, and Chris Campbell?
That's correct.
All right. And what did you do in that firm?
I was an associate attorney.
All right. And don't need a whole lot of detail, but generally speaking, who in the firm did you work for? What kind of matters did you handle?
Well, I believe I worked for all of them equally. They would all give me tasks to do, which court dates to go to, what cases to work on.
I want to direct now your attention, Mr. Dabney, to a particular instance. Did you have occasion at any time to go to a club with Mr. Bradley?
Could you repeat the question?
Yeah. Did you have any occasion to go to a club, a nightclub, or a bar situation with Mr. Bradley?
Yes, I have.
More than one time?
More than one time, yes.
What is this proving?
The time that I'm going to direct your attention to, we spoke about a little earlier today. Do you recall any instance, Mr. Dabney, where Mr. Bradley, where you witnessed Mr. Bradley sexually assaulting him?
Your Honor, I object to this. Specific instance of impeachment is improper.
All right.
What does this do for you? What does this do? What is the relevancy here? I'd love to hear it.
It's not extrinsic evidence in a collateral matter, Ms. Cross.
Maybe ask a better question. Yeah, my question will be if this witnessed Mr. Bradley sexually assaulting another employee of the firm.
Same subject matter. How is that not issue on a collateral matter for impeachment?
I think it's not a collateral matter. Your Honor, the witness denied it. I think it is highly relevant. I think that it goes to the witness's credibility and his denial here this afternoon that he committed the assault. There's a witness I will proffer to the court who has firsthand knowledge and witnessed the event. And so I think that's highly relevant to both Mr. Bradley's credibility and to the proceedings that we had for the last 2 days.
Still object, Your Honor.
I understand, Mr.
In the attempt to impeach Mr. Bradley, they have to live with whatever answer he gave. They can't have a sub-trial, and there being extrinsic evidence of misconduct here, so we would object. 608A. Right? 608.
Ms. Cross, under 608, I don't see how this isn't well beyond the core facts of the issue. I think you confronted with him. I think he answered them as he saw fit and argument he made as a result. But to go down a whole mini trial on whether he did or did not do this and circumstances that was leading the firm, I don't see how that gets past 608.
I understand the ruling, Your Honor. Disagree, and just for my objection, I put a proffer on the record, not a detailed one, but that
I think you already have.
I'd like to, with the court's permission, I'd like to make it clear that the sexual assault I'm referring to was the same employee that I asked Mr. Bradley about. I just wanted that to be clear on the record.
Okay. All right. Understood. Is there anything else that is relevant to this witness?
Given the court's ruling, no.
All right. Questions from defense counsel?
Good afternoon, sir.
Good afternoon.
When did you start working at the law firm?
I believe I started working, to my recollection, March 2021.
Okay. And at that time, do I understand that there was what I would call a three-way partnership or sharing arrangement at the law firm?
I'm not aware of any sharing arrangements that they had, but there was the Wade, Bradley, and Campbell law firm.
Okay. And did you work in the law firm office on a daily basis?
I did.
And during the time period, you were there for the remainder of 2001? That is, you worked from March of 2001, at least to the end of 2001, correct?
I didn't even have a bar license in 2001.
I'm sorry, 2021. It's a little late. From March of 2021 to the end of 2021, correct?
That's correct.
Okay. During the time period that you were working at the law firm, did you see Fani Willis?
During my time, could you repeat
In that time period between March of 2021 and November 1st of 2021, did you see Miss Willis?
I may have recalled one instance where I saw her in passing.
And when you saw her, was she at the law firm?
That would be correct.
And do you know who she went to visit?
I do not know.
You didn't see her go to Mr. Wade's office?
I do not recall.
Did you ever talk to Mr. Wade about Fani Willis?
Could you repeat your question?
Did you ever talk to Mr. Wade about Fani Willis during the time period of March of 2021 to November 1st of 2021?
No.
Did you know they were dating?
No, I did not.
Did you see anything did you ever socialize with Mr. Wade?
As far as being an employee, yes.
Well, I don't know what that means exactly, but did you ever go out to eat with Mr. Wade?
On occasion, he would take the office out to lunch.
We ate out.
Beyond that, did you ever go to a nightclub or drinking or any of that with him?
No, I did not.
Okay, so whatever relationship Mr. Wade had with Miss Willis during this time period, you don't have personal knowledge, correct?
I do not have any personal knowledge.
Thank you very much for being here.
Thank you.
Any other questions from defense counsel? Mr. Stockton?
When you started in March of 21, was that just you gave them a resume and started working there?
I don't understand your question.
When you started working there, is it a situation where your first
Yes,
day on the
that's
job
what
is
they're
the
saying.
first day you may have met him or shortly before you met him?
Again, I don't understand what you're asking.
Let me back up. Did you know Mr. Wade or any of his partners prior to March of 21?
Yes, I did.
How did you know them?
In a professional capacity.
He's
I
a
used to
probation
be
officer.
a community supervision officer with the Georgia Department of Community Supervision.
And where would that have been out of Fulton County?
Cobb County.
How long did you know Mr. Wade prior to that?
I didn't see Mr. Wade in my professional capacity. I thought you were asking about all partners, but if you're only asking about Mr. Wade, if you could please clarify.
Okay, so you went to work for Mr. Wade in March of 21, correct?
I went to work for the Wade Bradley Campbell firm.
Okay. Prior to that, how long did you know Mr. Wade?
I did not know Mr. Wade prior to that.
At all?
At all.
No further questions?
Any other counsel? All right, seeing and hearing none. Any redirect, Ms. Cross?
No, Your Honor, subject to the court's ruling.
All right, can this witness be excused?
May.
All right, thank you, sir.
Thank you.
Next witness, Ms. Cross.
I believe I know the court's ruling, so let me proffer that the next witness the state would call would be Anna Rodriguez.
They're going to call the sexual assault victim. What the fuck? What the fuck? Why is this going to work? That was a bad witness for the state. That was not a good witness. No. That, I mean, the one point here is Brad, your Brad is a I'm missing that they had these people in the witness room for intimidation. No, they did. No, I totally get that. These people were there. But once again, like here's the thing. Intimidating Brandon doesn't help you. He did his job, and then they came out and fucking killed him, and now they're beating the body to death. Like, they're just chopping the body up in little pieces. What, why? So Nancy Kerrigan, why? It's like, I'm like, here's the deal. Like I said, I am not a moron, I like to think. I don't understand the tactical considerations behind this. And I get it. Sometimes I miss the big picture. Sometimes I fail to think strategically. But I do not see the strategic benefit of doing this. I don't. I really don't. Yes, it's like Jesse Smollett. I am not suicidal. I am not a moron. I'm not a moron. Oh. So, Obscure says this is a signal to witnesses of the future. Yeah, I mean, that's the only other option, but this is still... He was towing the line. He towed the line, and that's where it's like, if you tow the line, we protect you. He stood up there and kept on going, privilege. And then they still fucked him. Like, I don't get it. I don't get it. Okay, and Old Line Red saying, I don't see the 75D chess on this one at all. Yeah, I just don't. I don't get it. This is... I mean, this is like... That's just like letting yourself get encircled in Avdiivka or Bakhmut. Like, maybe the Ukrainian army's planning this out. I don't know. Don't forget Fani threatened Wade's wife and lawyer with the prosecution for talking to Merchant. Yeah, I've heard that. I've heard that was an issue. Cupid saying, I'm wondering if he said something more important than we realized. Maybe, but if nobody noticed it, you don't kill him, because now we go back and look through what he said. So Squizgar says this entire proceeding was a result of him opening his mouth to a milk truck. This is retribution. Yeah. So let's see the Santa Rodriguez check. Oh, so thank you for the super chat, Squizgar. Let's get to this. See what this lady looks like. This Latinx woman. Proud Latino woman.
Question, Mr. Bradley, about the sexual assault of Ms. Rodriguez, a client of the firm. You denied knowing her or recognizing her name. I believe Ms. Rodriguez's testimony would be impeaching of Mr. Bradley. I believe it's appropriate. but want to present that before I call.
All right, thank you, Ms. Cross. And so, based on that proffer and the subject matter proffered, I still believe that would fall under 608B as extrinsic evidence of collateral matter. And so I don't think it's allowed under our rules of evidence.
Understanding that, I just make a proffer on the record that Ms. Rodriguez would testify that Mr. Bradley sexually assaulted her. She was a client at the time. And that would be impeaching of his testimony that he denied.
All right.
Yeah, I think the judge is lost
evidence
at
or
this
witnesses,
point.
Ms. Cross.
No, sir.
Okay. All right, then at this time, for now, I'll consider the evidence closed, subject to any certified submissions by counsel.
Wait.
To the results of the in-camera hearing.
You guys promised me shit was going to go down. Is that going to happen yet? You said there was like another witness. You guys promised me shit going down. Where is it?
We will coordinate with all counsel to find a date to come back for summation. And to that end, again, using Ms. Merchant as kind of running lead on this, I'd like you to consult on whether that's going to be a collective response on behalf of the defendants. If not, then we're going to have to get into time allotment. And if it's more than a handful of counsel, it'd probably maybe be 10 to 15 minutes per side. And so, Mr. Sadam.
I apologize. When did you say this might happen?
We'll follow up by email so we can coordinate with everyone's schedules. I want to make sure we have our same court reporter as well, so that the record is all in one place. And I know we have a lot of schedules to coordinate, but looking at either late next week, as in next Friday, or the following week.
And would we at least have the opportunity to get a transcript before we do that?
I think that's probably highly unlikely, but we'll see.
There's no way. Look at her smiling. She's like, I ain't fucking getting a transcript done in time, you motherfuckers. She's like, ain't no way in hell. It's a couple hundred pages, guaranteed.
It's just that would require a rush, and I know again we're in a shortage of court reporters, but I think there are other means you can refer to the evidence with confidence as to what was said.
All right.
Ms. Merchant.
The merchant's on me.
Okay.
You said next
Like I said, we will. We're gonna follow up with scheduling.
Thank you.
Now, Your Honor,
Mr. Gillen.
the argument would be on this hearing, and also on the forensic misconduct.
Any other claims brought in any of the filings regarding forensic misconduct? This whole line of questioning.
Thank
you. All right. Any other questions from defense counsel? Anything from the state?
Your Honor, we would just ask that we be allowed to submit a brief as it relates to the rulings that you just made. As relates to the objections by defense counsel under 607 and 6021 was the impeachment by contradiction, which in the state's understanding would allow the use of extrinsic evidence to impeach the specific testimony here of Mr. Bradley. So we're just asking for leave to provide a brief and ask the court to further consider your ruling.
Well, if you still got your witnesses here and you think you've got a better legal argument, I'm willing to hear it. You said 607 and 608.
Oh, wait, are we going to hear it still?
607 and 621.
Oh, there's like an hour still left. Oh my God, chat. Were you guys blue ball? Like, were you guys fucking with me? Are we going to hear this shit? Oh my God. Oh my God.
Okay, I see 621, I see 608. And
in both of those instances, they allow testimony that related to the testimony of another witness here, Mr. Bradley, that we can prove this is patently false, as he testified that he didn't commit a sexual assault and that he didn't pay off witnesses and things of that nature.
Okay, and how do you get around 608B's prohibition on extrinsic evidence of collateral matters?
Both 607 and 621 allow the use of extrinsic evidence to specifically impeach facts known to be false.
But if that held true, respectfully, that would mean that any time a witness denied something, you'd be able to evade. The matter testified to, you'd be able to impeach with extrinsic evidence
That's not how that works.
Well, here's what I'm fine with. Mr. Abadi, if you want to submit that brief on purely legal argument, you can. But I don't want to have this as a vehicle to essentially put forth an extended and long-winded proffer of what you expected the evidence to be. So if you think I've made a legal error on that point, feel free to brief it, and we can reopen the hearing if that's legally invalid. Okay? All right. Mr. Chopra, is your client still here?
I believe so, Your Honor, but I'm sorry.
That's fine. If he is still here, let's relocate to the jury room. Okay. We will be adjourned for today. Thank you all.
Oh, okay. All right. Well, wow, that was okay. I just want to double check. There's nothing left, guys. So we're gonna double check real quick here. Yada 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 yada. No. Done. All right. Nothing. We don't know yet. Woo! Wow, that was interesting. An hour of nothing. There's nothing there, guys. That's it. We're done. Oh, I hear you. I hear you, convict. I challenge accepted, man. Challenge accepted. So, Justice says, who won? The judge has not said who's won yet. But holy shit. If anybody in the U.S. Attorney's Office in Georgia wants to nail somebody's fucking scalp to the wall, Fani just offered her scalp up. So, oh my God. Oh! Coop says, yes, we won. This was a great stream. Well, thank you. Yes, no court Monday because it is President's Day. So, court's closed down. So, which means I don't have anywhere to be on Monday. So, I'm not sure what I'm going to do. Maybe we'll catch up on Tracunas. Yeah, Fanny's going to offer a weave up to the DA's office. Yeah, that none of that. This wasn't good. This wasn't good. Kimmy Joe says, I need to watch the Nancy Grace talk about the newborn baby. That's a story I'm going to get to. That's a really fucked up story. They ripped the baby's head off and they wrapped it up in a blanket and made it act like it was fine. They ripped the baby's head off during delivery and they were like, oh no, it's okay. You can't touch it now. Old Line Red says, now I understand why the YSL case is such a shit show. Yes, because these guys are fucking morons. And that is a preview of what the Trump case is going to look like. A dumpster fire, which I'm betting YSL gets a mistrial because of prosecutorial problems. And reformed convict, yes. When it comes to Fani, these hoes ain't loyal. I can't do it. I can't do it like Chris Brown, but these hoes ain't loyal. Oh, 523 viewers still total. Holy cow, you guys are awesome. You guys are awesome. I appreciate all that. Thank you so much again. Whew. But yeah, these hoes are never loyal. That's the problem. They arrested Young Thug's lawyer for what? His current lawyer? Or previous lawyer? Gang activity. Bella says, what about the Ohio 5-year-old's body found? That there's a lot of we do a lot of murder in Ohio, so I don't, that doesn't help me. Sorry, Bella. Tracunas had a bunch of effery as well today. Well, good. We're not that far behind. Hold on. What? Oh, that's what that was? Ugh. Oh, okay. Well, Dan the Dev says no Nick tonight, so the locals friends are hanging with Sean. Oh, okay, cool. Thanks for being here. That's a shame, since I thought I'd never heard of YNW Melly, but I just learned he's one of my favorite Kanye songs. He's on one of your favorite Kanye songs. Awesome. Oh. Galatarian says, thank you for being consistent while being a practicing lawyer. I try. Guys. Debbie O says, for $10, thank you, Debbie. I don't get it. They opened up Bradley's privilege claim, potentially exposing Fannie and Wade, and or they diminished Bradley's testimony. Are they possibly covering up something even bigger? Maybe. I mean, there might be more layers of this onion, or they might be idiots. I don't know. It could easily... I'm leaning more towards they're just fucking idiots, because nothing else makes sense. Nothing else makes sense. But I still think if you wanted to go chase someone down, and if I'm in the U.S. Attorney's Office, investigating Fannie would be a very good idea to go after, because she's made herself an embarrassment at the national level. No one's going to come run to her aid now. Harry to Steven says, hey, Sean, my buddy isn't getting the death penalty for shooting his wife in the face 15 times. Arizona missed the deadline. Rock on, man. Rock on. Some good shit there. There we go. Just do the first 10 minutes of Traconis now. I totally didn't understand it. Here's the problem. Which first 10 minutes? Because we did Monday, Tuesday. Monday, Tuesday, obviously Lincoln's holiday. Tuesday was a snow day. We got Wednesday done because Wednesday had a whole bunch of issues and fighting. We are behind Thursday and now Friday. So I don't know which first 10 minutes you're talking about. And if it's the 10 minutes from today, I don't know if those relate back to the Thursday, so I'd be kind of lost. So KRM says, dude, Shaq was at her inauguration during. Yeah. Brian Kemp also has to be looking at the situation. I think he is. There's no way they're not. All the eyes of the world are upon Fulton County, and they yeah. It's not a good look. Debbie O says for $5, they should have just caught him walking in traffic instead. Yeah. There's so many ways they could have killed him that would have been less painful. Today, okay. Island, I gotta watch I have to watch it in order because I have a feeling they talked about stuff that I don't know about. So then I'm really I'm going to be as lost as you guys. We'll catch up tomorrow with Tracunas, and then we'll catch up on Sunday with Tracunas as well. MJ says, why does it say you've been live for 6 hours? Because I've been live for 6 hours. 6 hours, 42 minutes. Actually, 6 hours and 43 minutes right now. 6 hours, 43 minutes, and 4 seconds. Boom. That's how long we've been going. So. Ryan Harden says, I'm confused. Is the trial going in Fannie's favor? I don't know. I don't know. This is a disaster. This is an absolute unmitigated disaster. I would enjoy the skill of being involved in this fight. Like, I feel like I could, get my, sharpen the knife out of this. But this is going to be a fucking head scratcher of how to deal with this. Because she is acting like, where the idea, like, she is acting like on a level of super rationality, like, I'm going to be crazy, so I'm going to act not crazy, but in reality, I am going to go crazy anyway. Like, we're this, I don't know if you can really, if you tried to ask Musashi what to do here, he'd be like, I don't fucking know. Just kill her with a wooden sword. Like, Musashi's like, I don't know, dude. I just tell you how to kick people's ass, not lunatics. Old Iron Ren says you need last 10 minutes of Chakunas Thursday and the first of Friday. It's a mess. Yes, but I'm sure the last 10 minutes of Thursday play into prior time on Thursday. So I'm gonna have to do. We gotta watch Thursday first. But tomorrow we will get a start on that, and we'll go from there. We will fire it up, and I will watch. We'll watch all the way through, and then instead of starting the full Friday, we'll get the first bit of Friday in. How about that? Let's see here. MJ saying, is it true the judge used to work with Fani? Yes, he used to work there. Yeah, and that's very common. A lot of judges are prior district attorneys or assistant district attorneys. That's not uncommon. But we also know these guys all know each other. That's not uncommon either. I mean, these are all the top line pipe hitters in the Atlanta, Georgia, the Fulton County, Georgia area. Best attorneys. So, yeah, I mean, they all know each other. But that's not uncommon at all. In fact, in Toledo for a while, and actually, I don't know, is okay, so he's well, when did this judge retire? Okay, so there was a judge, in one of the counties I practiced in. The judge was a felony level judge, and the county prosecutor was his wife. So, I mean, how about that for crazy results? So, Ellen saying, trust me. Oh, it's stuff happening in the gallery. Okay, well, yeah, I don't. Oh, well, let me see if it's worth it. We can stop. No, it doesn't. It's a gallery. Okay. So if it's something in the gallery, you cannot stop. Arca still has 10 laps left. All right. We'll go ahead and look then. Bradley's lawyer was okay. Hold on. MDOH. MDO. Or MDO. Or MDO. I don't know. For $4.99 says, why was Bradley's lawyer talking to Cross during the break right before she went in on him? And then his lawyer was the one bringing up the privilege. Because I think he was just talking to her like, what are we doing here? Hey, how you doing? He might know her. So he's like, hey, what's up, Cross? What's up? What up? He's like, hi, girl. What up? Or he'd say like, what's your scope? What are you going to start going into? And she's like, nothing bad. Or who knows what they were talking about? Who knows what they were talking about? I really don't know. Okay, guys. So we got to watch the end of Michelle Trakunas the last 10 minutes or so. I guess, fuck it, chat. We're going to get some extra content here. We'll do it. We'll do it live, chat. Okay. Okay, got that shit for Kershaw away. Okay. Michelle Trakunas. All right, here we go. Day 22 afternoon. You guys want the afternooners. We got the nooner. All right, hold on, wrong day. Live. Day 22 afternoon. Okay. Hold on here. So where does it end? Okay, so hold on here. Where do we got a witness on the stand still? All right. Okay, here we go. All right. All right, guys. You want to see? So Michelle Trakunas, it's a murder case out in Connecticut. We've been watching it. Here we go. I bet your nighttime entertainment. Oh, I appreciate it. You're pissed at Fanny, so you want my take on this. All right, let's go. Let's see what this is. I got it, chat. Oh, God, everybody left now. Damn. It's like, you all left. Okay, let's go, chat. Guy looks like fucking Nick Offerman.
Ladies and gentlemen, that concludes the state's witnesses for this afternoon. The court has been informed that there will be testimony tomorrow, and it'll be a lot of video testimony. In other words, video of interviews. And we'll adjust the break schedule accordingly as those interviews take hours. So have a good evening, and please do not discuss the case. Please do not follow any media about the case. Have a good evening.
That's not possible.
Okay, guys, so let's see what this is all about. Oh, okay, we're back on the record now. Okay.
Just a note from
I can't hear it.
reads that Mr. Cronus appears to have a text from a sealed report on her monitor in a very high, big font. The beginning of it reads, "Dr. Krasner told me," in quotes, which the only reason why the state is reading that quotation, Your Honor, is that is the note. Now, the state brought this to the court's attention. This is also not the first time that we have heard that Mr. Cronus has been putting things on her laptop for other people to see. For instance, there's actually an article in the Stanford Advocate that during, I think, either Christine Roy's testimony or Kristen Medell's testimony, she had a article with a headline that Dr. Lee is held liable for impeaching or something to do with his testimony. The only implication there was an attempt to it was related to the blood results in his testimony. The only implication to have that up is an attempt to either put that out in the press or for a witness to see. So this is the second time we've had a concern. We didn't address that first with the court because it was we didn't see it or hear anything. We actually read it in the Stanford Advocate. The concern the state has is this notion that she would have access on her device to a report that it starts off that a member of the audience is able to see, which is clearly under seal. So that is concerning. The second major point is that that was displayed for the public with a news camera behind us, and that she shouldn't even have read it to begin with. So it is a huge concern at this point that I'm bringing to the court's attention. We can't gloss over the serious nature of the idea of a violation of her having access to the report, her displaying it for everybody to see, essentially. And three, also there was another instance where we're not sure if she or a member of her family was mouthing to the jury earlier in this trial. So now we're at a point where this has to be raised on the record. And I bring that to the court's attention to address in some way.
Well, does the state know who handed the state the note?
If I may just
Uh-oh. It's a custody evaluation. Wow. Yeah, that's not a good look. Don't be fucking with the exhibits like that. Don't do that. Don't do that, chat. No, no, no. Don't do that. Nepa!
just inquire, Your Honor, my inspector is back.
The court is not asking for an identification.
Yes, Your Honor.
So the first consideration by this court is to find out from the person who handed the state the note how that person was able to determine what was seen on the screen. So of course, that's not going to be done on the record in this proceeding. But in other words, how did this come to the state's attention? Who brought it to the state's attention? Did you want to be heard, Attorney Felsen?
Very briefly, I'm not sure which order to address things in. I will say it was my understanding that any video that was taken would not display our screen, so it would not be available to the public. We've taken great pains to work with people who are handling the cameras and the videos to ensure that all of our communications, whatever's on our monitors or on our desk, remains private and inaccessible to other people. As far as the report is concerned, I'm not sure how anybody in the audience would know the contents of what would be in a sealed report.
That's a good point.
I know that I have not reviewed the report in its entirety. I have never seen it on a computer. I have reviewed the last 4 or 5 pages that I was provided, and they were in paper form. I can say that I have never shared the contents of the report with Mr. Konis. I do not know, in fact, whether she was reading from a memo or what it was. I don't intend to ask her and discuss it at this point in time. What I can say is I know there have been a lot of notes that have been passed back and forth with information that is now just being shared. If I had known that there was an issue with the public possibly viewing what was on our screens, I would have taken steps to ensure that that wouldn't happen, and I can do that from here on in.
Well, the court's first concern is, and the court understands that we are talking about the custody evaluation.
Yes, Your Honor. And the only reason, again, while I indicate that, is I do believe the individual who saw it is a close friend of Jennifer's and would recognize a name that was on the report or on Mrs. Konis's computer.
Well, what the court has to task the state attorney's office with is to find out as much information as it can as to how, first of all, the individual recognized whatever was on the screen.
Yes, Your Honor.
How they were able to see it from their vantage point. Was it broadcast? Was it live streamed? And the court is just going to have to begin tomorrow's proceeding without the jury, because what is happening at this point is there appears to be, the court has issued a protective order and sealed that custody report. If that custody report is being disseminated, and if it's being disseminated essentially with the involvement of the defendant, then the court has to take certain action. Because then it's a violation of a court order, and there would have to be a contempt hearing.
Oh, chat.
Stand in a recess until tomorrow at 10 o'clock.
Wow. Okay. Sorry, guys, trying to save up some stuff here. I'm clearing up my. Sorry, trying to clean up Word. Don't save, don't need. Okay. All right, so let's move on to day 2 or the next day. Too many windows. All right. So let's go back. Day 23, the morning. Okay. Here we go.
When we concluded the session yesterday, the court had been informed that there had been a possible disclosure of an evaluation report that the court ordered sealed yesterday. The court indicated that the state, who had indicated to the court that a note was passed to the state, would investigate to find out from whom the note came, how that person would know whether there was a violation of the court order to seal, and any other information that the court would, or rather the state could develop concerning the allegation yesterday. So the court will hear from the state.
Good morning, Your Honor. May it please the court. Judge, we were able to conduct an investigation in the evening hours last night, and we were able to speak with the witness who passed the note, Ms. Carrie Luff. She provided a written statement to our office late last night. Additionally, we were able to pull footage from YouTube, which corroborated Ms. Luff's statement. There were additional witnesses to what occurred as well from the state's attorney's office. I'll just indicate, Your Honor, that our investigation has revealed the following: that the defendant absolutely had the sealed report on her computer screen, that it was being displayed in violation of a court order, and that the defendant's mother attempted to prevent her from being discovered as having violated that order by tapping her on the shoulder and bringing it to her attention that we were about to address it with the court. And so that's what our investigation has revealed. Now, we were prepared to go forward this morning with the contempt hearing, if that was the court's pleasure. The court has indicated to us that it doesn't wish to take it up at this time due to the fact that we do have a jury that is waiting, and we are trying to get to a resolution of this case. But it is amazing that nearly 5 years after Jennifer Doulos' death, that this defendant still will not let her rest in peace.
Objection. Object right there.
Judge, we're asking.
Object right there. That is just tampon. That is tampon woggling. Objection. Objection.
That the defendant's mother be ejected from the remainder of the proceedings. This is not the first time that we have brought an issue concerning the defendant's mother to the court's attention. Now, the first time we brought it up, we did it at sidebar. We indicated that we received information that the defendant's mother was mouthing to the jury. We indicated that we didn't wish to make a spectacle of it.
What was she saying?
Counsel assured us that they would speak with the mother, and I know the court recalls that conversation. And now this is the second incident in which the defendant's mother has injected herself into the proceedings in a very inappropriate way. And I'll just indicate, I'm expecting some argument. Well, the Farber family blows kisses at people and makes hearts at people, things of this nature. First I'm hearing of it this morning. And we've spoken with them in the interim. But this is now a second strike for the defendant's mother. And I'm asking that the court eject her from the remainder of the proceedings. Her conduct is inappropriate. And the fact that she tried to prevent the defendant from getting caught by tapping her on the shoulder, and then the YouTube clip you'll see, the defendant immediately takes action with respect to her computer. So I don't make this request lightly, Judge. I have to say I've been practicing law for nearly 15 years, and this is the first time that I think I've ever made such a request. But this is beyond the pale, and I'm asking that the court do something about it, pending the contempt proceeding.
Your Honor, Attorney McGinnis's comments revealed just how highly charged this trial has been and how much emotion there's been in the courtroom. We have taken steps to avoid and ignore any negative interaction and to try to focus on the evidence in this case and on ensuring that the evidence goes before the jury without any interruption. As Your Honor knows, we've talked repeatedly to the media to ensure that they were not able to pick up anything on our computer screens, anything that was on our table of evidentiary value. I have confirmed with them that, in fact, they have taken those steps. They've complied repeatedly and ensured that they've been in compliance with the court's orders. As far as if we are addressing today, Mr. Konis's mother being in court, We did talk to her about the allegations last time. We did not note that she was making any inappropriate movements, gestures, signals in any way. And we have no evidence other than a statement from Jennifer Farber-Doulos' friends and family that in fact occurred. I do not understand why the state is suggesting that any interaction that Mr. Conus's mother had with her about putting something on her screen, taking something off of her screen, has to do with avoiding getting caught for something. That's just an inference that doesn't seem to be based on anything that I've heard so far. I know Your Honor is taking up those allegations at another time. However, what I will address right now is the fact that there have been other interruptions and disruptions and comments that have been made in the courtroom galley that we ignored and will continue to ignore. We don't feel the need to put anything on the record. We've addressed it with Your Honor in chambers. I don't know why that needed to be put on the record now, but rest assured, Your Honor, we've taken steps to speak to Michelle Troconis's family, to speak to Michelle, and ensure that there are no further disruptions. Her computer is not here today because I'm not going to be focusing on what somebody has or doesn't have on their computer. We need to listen to the evidence and ensure that what's supposed to come in before the jury comes in and what's supposed to stay out stays out.
Thank you.
Wow. Fuck.
This court makes every effort to conduct proceedings in a fair and efficient and dignified manner. This court makes every effort to show counsel and the defendant respect. What the court is not going to countenance are competing pep rallies like you have in high school. The defendant supporters and the state supporters. This is not high school.
But it is a game.
The court is not going to become a hallway monitor. So if there are efforts to communicate with a jury or a witness, you will be removed. No hearing, just removed. There will be no computer use other than by counsel in the courtroom.
Ooh, that's a.
There will be no communication with the gallery at any time. There will be no attempts to show your approval or disapproval of a witness's testimony. Or you will be removed.
You'll be removed. Yes. We will remove you.
Court is not going to take up a formal contempt hearing today.
Subject to change.
Court will schedule a contempt hearing at the earliest after the defense rests. That's at the earliest.
Wow, he's pissed. Damn.
Are we ready to proceed?
Yes, Judge, we have one witness, and then we have Detective Kimball, and we're going to be playing the third.
Detective Kimball, Detective John Kimball, I'm a cop, you idiot. Really, the guy's name is Detective John Kimball, just like a kindergarten cop. Wow. Wow. Interesting. Wow, Michelle is just fucking this up for herself here. I have to explain in English. There's nothing to it. He's not putting up with any bullshit in the courtroom. And a contempt proceeding for violating the court's orders will be scheduled, but not until after the defense is done. So that's all he's saying. But he will hold a contempt hearing, so. So that's the thing. So the whole trial's bullshit. Yeah, it is. At this point, I'm still not convinced what they've got on her. There's nothing. Yeah. The contempt hearing would be for Michelle because she let people see it. And she supposedly, it would be for Michelle at this point. So, Michelle says, I'll have to try her next time. Well, no, still if he says, who is your daddy and what does he do? Missy better not alter that laptop. Well, I don't know if that's even the issue, but I'm sure the judge is going to want to see the stills and the screens of that. So, Island says, so things are changing. I mean, she's still like, overall, it's still circumstantial and it's not a strong case, but juries convict on flimsy shit all the time. So Michelle is not out of the woods at all. Hold on, we gotta go. Shing. Anyway, doesn't the court control the layout of where they sit? Yeah, but it's still, that it's still only so much they can do. So, things are changing because her phone stuff's coming in. Well, I thought a lot of her phone was kept out, but yeah, I'll find out as we watch tomorrow and later on. So, I don't want to spoil. I don't want spoilers. So, all right, guys, 7 hours and 11 minutes and 35 seconds and 2, 1, boop, mark. So, yes, 7 hours and 11 minutes. We are done. I am going to take a break. And yes, thank you everybody tonight. Everybody on Ruble. Thank you for watching on Rumble, guys. I appreciate you guys all over there. Sorry the chat was all kind of weird over there. Twitch. Oh my God. Kirsch, thanks for the raid. And the 32 people still on Twitch, guys. Thank you so much for being here. Your stamina is amazing. You have no idea. But yes, thank you. And everybody here on YouTube, guys, I appreciate it. Thank you so much for sticking around. That was fun. Oh my God. I still don't understand it. I'm still thinking about it. I'm going to think about it tonight while I'm sleeping. And I'm still not going to understand what the point of that was. There we go. Perfect. But yes, thank you guys for all the comments. I appreciate it. When you guys are commenting, it's great. And then yeah, also thank you for all the super chats, the likes, subscribes, everything, guys. Awesome stream, love and reacting insanity. Well, thank you. I'm glad you guys did. So, all right, guys. Yeah, tomorrow we are going to work on Michelle Trakunis. And then I don't know what to figure out the rest of what we're doing. So the weekend, but I will be in touch. I'll see you guys around. Have a good night.